is the man, the legal wizard, with a podcast you should hear. Andrew Branca's name, the self-defense pioneer. He knows the law, the ins and outs, he'll take away your fears. His expertise is unmatched, it's crystal clear. The law of self-defense, this book that you must read. 5 elements laid out, he's got all you need. From innocence to eminence, he'll break it down for you. Andrew Branca, he's the voice that rings through. Andrew Branca, the self-defense guru. He's got the knowledge, the skills, he'll fight for you. Andrew Branca, the master of the law. When it comes to self-defense, he's the one you should call.
All right, everybody, welcome. Welcome to today's Law Self-Defense Show. It's going to be another long one today, covering the Nicolae Miu Apple River tubing stabbing trial. Part 7. So today, we're still playing catch up. We're covering last Friday's proceedings. So a full day of last Friday, still the state's case in chief being presented. We're up to, I want to say we're up to state witness 27 or something. 29 will be the next witness. So we'll cover Friday today. And I'm also going to try to cover yesterday's proceedings. So yesterday was a half day. It appears that some of the state's final couple of witnesses were unavailable for some reason. So they'll be presented in real time today, Tuesday, April 9th. But because they weren't available yesterday, instead of the state resting, the judge allowed the defense to begin its case. So yesterday, the defense presented half a day's worth of witnesses, what they had scheduled, and then things were ended for the day. This morning, in real time, the state will present its last couple of witnesses and then presumably rest. Anyone looking for a directed verdict, I'm sure the defense will make a motion for a directed verdict. Not going to happen, folks. Directed verdict is when there's essentially, there's literally no way, based on the state's case, that a rational jury could convict. And many of you may emotionally feel that a conviction would be inappropriate here. But the legal standard is that the judge is required to look at all the evidence, all the arguments in the light most favorable to the state. And if they do that, there is a way to get to a conviction. I would suggest not a very good way. Again, the legal burden here, Nicolae Miu is charged with first-degree murder and 4 counts of attempted murder. He fatally stabbed 1 person and stabbed an additional 4 people who survived. He's also charged with battery for punching the blonde woman, purportedly, which of course he disputes. He's claiming self-defense to the murder and attempted murder charges, and now that he's done that, the burden is on the state to disprove self-defense beyond any reasonable doubt. Based on what I've seen of the state's first 28 witnesses over the first 4 days of the trial, that seems unlikely to me, but jurors are dangerous and unpredictable creatures. So we have the defendant, Nicolae Miu. The judge is Judge Michael Waterman, runs a very tight ship in court. I like him quite a bit as a judge. Prosecutors are Carl Anderson. He's actually the elected DA in this jurisdiction, and he's assisted by Brian Smetstad for the state. Defense counsel are Aaron Nelson as lead counsel, and second chair is Corey Chirafisi, who we all remember, of course, from the Kyle Rittenhouse case. He was second chair for the defense there as well. Did a great job there, particularly on cross-examination, and he's doing a great job here, particularly on cross-examination. So far, my evaluation based on the evidence I've heard from the state and the state's arguments is that they're not close to disproving self-defense beyond a reasonable doubt. Ironically enough, the single biggest piece of evidence that the state has is this video that was made with a cell phone of the encounter by one of the group injured by this defendant. The group of 6 young teenagers who were young teenagers, old teenagers, as teenagers go, 17-year-old high school football players who are repeatedly referred to as children in the proceedings. But these 17-year-old teenagers, 6 of them, taunting the defendant on the river, calling him a pedophile, a raper, shouting he's looking for little girls. That attracts the attention of another group. Everyone of these antagonizers are drunk and or high on marijuana. And that attracts another group to the point where now the defendant is outnumbered 13-1, and they begin beating him into the river, which is when he comes up with the knife. It looks like self-defense to me, but again, jurors are dangerous and unpredictable creatures. And of course, we haven't yet heard all of the state's evidence. Now, the state's witnesses seem to be diminishing in terms of how compelling they are for the state argument, but we'll have to see what happens today. Full day of witnesses today. And I think some hijinks involving Spanish-speaking witnesses. We'll see how that goes. All right, with all that set up, let me go ahead and launch the formal start of today's show. And today's show is sponsored by Law of Self-Defense itself in the form of our upcoming Law of Self-Defense Advanced class. This is our full-day course taught live by me, streamed to you at your computer using Zoom. This is the course that teaches you everything you need to know in order to be hard to convict if you're ever compelled to defend yourself, your family, your property. If Nicolae Miu had taken this class before he went tubing July 30th, 2022, he would not be sitting in court looking at murder charges today. He missed that opportunity. You should not. The class is being taught Saturday, April 20th. We only teach it twice a year, folks, so it'll be October before it comes around again. Can you afford to wait? I would suggest not. Nicolae Miu waited, and look where he is now. You need this information and insight on board before the attack happens, and you don't choose the time, place, and manner of attack. The bad guy does that. Plus, we're in the early registration period, 50% off this week. lawofselfdefense.com/advanced is where you would learn more and sign up for that course. Don't pass it up, folks. lawofselfdefense.com/advanced. And yes, I know I sound even more congested today than yesterday. It's this crazy cold. All right. As always, by the way, folks, questions and comments, if you're a Law of Self-Defense member, please post them in the member chat where we're also live streaming this. And if you're watching on YouTube, feel free to post questions and comments on YouTube, but I only address those that are at least a $10 super chat. If they're not a $10 super chat, I do not see them. And that's how we address Q&A. I would encourage you to become a Law of Self-Defense member. It's dirt cheap. You can do it for 99 cents at lawofselfdefense.com/trial. You'll get an email with how to join us on the member chat. Get all your questions answered for free for the duration of the trial. And as long as you stay a Law of Self-Defense member, or do the $10 super chat thing if you want. After the 2-week trial for 99 cents, it's still dirt cheap to be a member, only 30 cents a day, less than $10 a month, less than the cost of one super chat. And you get all your questions answered for the entire month. Something for you to consider. All right, let's see where we are. Day 5, full day of testimony. Let me get to where. Now, there is some kind of technical glitch this day. So court's already started when the feed begins. There's a woman on the witness stand. I don't know who she is. Hopefully they'll display her name. A Spanish-speaking woman is the first witness of the day on Friday that we have on this feed. Hopefully someone will tell us who she is. Oh, Apple Pay comes in as $9.99. That's why they do. That's why I see those $9.99 super chats. It's okay. I'll answer them if they're $9.99 too. Let's see. Let me make sure. I'm going to play it at 1 1/4 speed. Closed captioning is on. Volume is boosted. And here we go.
Yo dije 3 veces, stop, stop, y le dije a Ariel que fuera a ayudar.
I said 3 times, stop, stop. And I told Ariel to go help him.
So when you said stop, 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 who were you talking to?
Estaban personas jóvenes.
Well, this is annoying. This is a state witness. I guess we had quite a delay at the start of the feed. So this is the same news channel, Fox 9, I've been using throughout, and we're starting 45 minutes into their stream. This is Corey Chirafisi asking questions. He's the defense team. So we've missed the entirety of direct questioning of this witness, and we're already on cross-examination.
Como en círculo y asumí que era Nica que estaban golpeando porque él no se miraba.
There were some young men in a circle, and then I assumed they were hitting Nick because I couldn't see him.
A alguien estaban golpeando.
They were hitting somebody.
So when you were saying stop, 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 you were talking to people that were far away from you. Is that right?
Sí,
Yes.
The people in your group, when Nick's wife said Nick's in trouble, did anyone go to help him?
yo recuerdo que fue Ariel, Ernesto y Sergio.
I remember it was Ariel, Ernesto, and Sergio.
Pero Ariel fue primero, perdón.
But Ariel was the first one.
And were they walking over to that area?
Sí,
Yes.
Nobody, and when I mean nobody, Ariel, Ernesto, and Sergio, they didn't run over to help Nick, right?
no, yo no vi ninguno correr.
No, I didn't see anybody running.
Did you see Nick in trouble, or did you just hear that he was in trouble?
Yo escuché que él estaba en problemas.
I heard that he was in trouble.
And I think you said that you saw Nick walking back toward your group. Is that right?
Yes.
And when he's walking back toward your group, you saw him kind of go over to the edge of the river bank. Is that right?
Sí,
Yes.
You know, if you can tell us about
It's so
how
funny when they
far
translate
away
C.
were you from that riverbank area that you saw Nick walk over to?
era como de aquí a la puerta,
It was like from here to the door,
lo que tiene el río de ancho.
the width of the river.
And when you saw him walk over to that area, I saw you make a motion with your hand, kind of like pushing it out in front of you. Is that fair?
Sí,
Yes.
So and I think you said in your statement to police that you believe he was discarding something.
él tiró algo, fue mi palabra.
Yeah, he threw something out there. That was what I said.
And when he threw, you don't know what he threw, is that right?
No, no sé.
No, I don't know.
But the way and manner in which he threw it was the manner that I'm showing you right now, kind of. And he moves his hand away from his body, kind of like that.
Correcto.
Correct.
Correcto. Correct.
Did you see Mr. Miu walk over after he discarded this object? Did you see him walk over to the object, or did he head back toward your group?
Se dirigió al grupo de nosotros.
He walked through the group to our group.
Okay. And I think you told police that when he walked back to your group, he appeared white and pale. Is that right?
Sí,
Yes.
He really wasn't talking. Is that right?
él dijo que le
Sí,
quitaron
yes.
la navaja.
He said they took away the knife.
Is that the only thing that he said to you?
Y que se iba a ir para los árboles atrás de nosotros.
And that he was going to go by the trees behind us.
Now, when you talked to the police, you never told the police that Mr. Miu was looking to go into the tree area. Is that true?
Cuando usted me dice que yo hablé con la policía, ¿fue cuando salimos del río o cuando ellos llegaron a mi casa a hablar conmigo?
When you say that I didn't say that when I talked to the police, are you talking about the time I talked to the police by the river, or when they went to see me at my home?
When they went to your home, they sat with you for a while and spoke to you. Is that right?
Sí,
Yes.
And they were asking you questions about what you saw and what you heard, right?
sí,
Yes.
They were asking you details about what Nick Miu did that day, right?
ujú, sí.
Yes.
And during this interview that you gave with police, you never mentioned to the police that Mr. Miu wanted to walk into the area by the trees.
Honestamente, no lo recuerdo en ese momento si yo lo dije.
I honestly don't remember if I said that at that moment.
So you don't have a recollection, a memory of whether you told that to the police or not. Is that fair?
No, no recuerdo.
No, I don't remember.
Had Nick previously that day gone into the woods to go to the bathroom?
No que yo viera.
No, I didn't see that.
He's in a river. Does anyone leave the river to go to the bathroom? I've actually never been
You
tubing, but
described to the police when Nick came back to your group, you described him as being looking scared. Is that fair?
Correcto.
Correct.
And you knew that Nick had a knife with him that day. Is that right?
Sí,
Yes.
And you knew he had the knife to cut the rope on the tubes. That's why he had brought it. Is that right?
sí, cierto.
Yes, that's true.
Is it fair you told your group,
yeah, it may be hard for you guys to hear. I have my earbuds in, but as Chirafisi is posing his questions, there's a woman translating in real time in the background. And I assume that's what the witness is hearing. And then there's a male translating her answer afterwards. I don't know why they do it that way, but there we go. And I believe this is a state witness, not a defense witness. This is from last Friday. It's not from today. The state called lots of witnesses whose testimony was favorable to the defense. So if that's why you think it's a defense witness, I could understand, but it's I believe it is a state witness. We had a glitch today starting the show, not starting my show, in this court stream from last Friday. It really only started about 45 minutes in to proceedings, it looks like.
people in your group to call 911. Is that right?
No recuerdo.
I don't remember.
And of course, I missed that. Hold on. I got to rewind it.
You told your group, people in your group to call 911. Is that right?
No recuerdo.
I don't remember.
¿Dónde está la biblioteca?
Your group stayed at that location for some time. Is that true?
Sí,
Yes.
Did you see Nick? Nick didn't run up into the woods. True?
no,
No.
He sat in his tube. Is that right?
sí.
Yes.
How long do you think your group sat there before moving on?
No sé. No podría decir una.
Don't know.
I don't know. I couldn't tell you, well, how much time we were there.
You had mentioned that you wanted to move where you were sitting in your tube. Is that true?
This is from Friday, folks.
Sí,
Yes.
And I think you mentioned to the police that you wanted to move in your tube because you were concerned or afraid of the situation. Is that right?
Sí,
Yes.
It wasn't anything that Nick had said or done to you that made you want to move, right?
no, nada de eso.
No, nothing like that.
¿Dónde está la baño? El baño. Sorry.
Do you remember whether or not Nick Miu had his phone with him during that time?
No,
No.
Terrible question. You don't. Did he or did he not have his phone, or don't you remember?
no recuerdo. No tengo una memoria como específica de eso, muy vago.
I don't remember. I don't have a clear recollection of that in my memory. Yeah.
When Nick came back to the tubes, I think you said it became quiet.
Sí,
Yes.
No one was really talking.
no.
No.
Tatiana decía como, algo pasó, ¿qué habrá pasado?
May I ask for a repetition of the?
Solamente Tatiana decía, algo pasó, ¿qué será lo que ha pasado? Pero nada más.
Tatiana was the only one who said something happened, but nothing else. Something must have happened.
Did Nick appear? Nick appeared to be in shock, right?
Sí,
Yes.
When Nick came back to your tubes, did he just sit in the tube?
sí, que yo recuerde, sí.
Yes. As far as I remember, yes.
You didn't see him run away from the tubes and try to get away from you guys, is that right?
No,
No.
And you were with a gentleman, if you know, by the name of Eric, is that right? He was with your group?
sí, andaba un muchacho ahí, pero no lo conozco.
Yes, there was a guy there, but I didn't know him.
Is it okay? Ms. Costanza, do you remember seeing this gentleman
Sí,
with your group?
Yes.
sí,
Yes.
And that's Eric Von Williams. I don't know if you know his name.
sí recuerdo el nombre cuando me lo presentaron.
Yes, I remember the name when they introduced us.
And Mr. Von Williams went over to at least try to render aid or help. Is that right? You remember that?
No, yo no vi el momento que él caminó hacia, no sé. Si
I didn't see him walking at that. I didn't see when he was walking.
Did you see the number of people that were in the other groups?
eran varias personas, pero no puse atención cuántas eran.
There were several people there, but I didn't pay attention on the number of people.
But you believe that Nick was the only member of your group from over there, right?
Sí.
Yes.
I don't have any other questions.
Mr. Anderson, do you have more questions?
Yes. Only one who saw Nick throw something.
How
Nunca he
speculative?
hablado con los del
How would
grupo
she
de
know?
esto. No sé si ellos miraron.
I never talked to the group about that. I don't know if they saw that.
Did you know that that was important information to tell police?
Bueno, sí.
Well, yes.
When Nick came back, do you know if the look was shock or fear or something else?
Como en shock.
Like in shock.
Wrong
And-
answer for the state again. They get a lot of that.
When you were leaving, you specifically did not want to sit by Nicolae because you were afraid to sit close to him, right?
Sí.
Yes.
Nothing else.
Mr. Trofisi?
You didn't know what happened. Is that fair?
No.
No.
So you weren't afraid to sit next to him because of anything he had done, correct?
No.
No.
You were afraid in part because of the look on his face, right?
Correcto.
Correct.
The shock that he had on his face concerned you, right?
Sí.
Yes.
That's the reason that you didn't want to sit next to him, right?
Podría decir que sí.
You could say that. Yes.
That's all I have. Thank you, ma'am.
Thank you, Ms. Costanza. You may step down.
More shock.
Is she released?
No.
Someone please.
Say that. Yes.
That's all I have. Thank you, ma'am.
Thank you, Ms. Costanza. You may step down.
All right, Costanza. I'm just going to try to get a...
Now. Is she released?
No.
Just going to capture an image of her for my notes. Let's see. Witness number 29 for the state. Testifying to the shock Defendant Nicolae Miu was in after this event, which is testimony favorable to the defense. It's part of them explaining the manner in which he interacted with police in the aftermath of this use of force event.
Someone please collect the headset. How is everyone doing? Does anybody need a break? Let's continue then. Mr. Anderson, who is the next witness?
Can I have 1 minute, Judge?
Yeah, so that was definitely a state witness. Oh, the court's pretty full today.
Alba Torres.
Alba Torres. Witness 30 for the states. Well, she just popped her eyebrows at somebody in the courtroom.
Ms. Torres, please raise your right hand. The clerk will administer the oath.
You swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please have a seat in
C.
the witness chair.
You're supposed to say C. Court went to all this trouble to get a translator for you.
Mr. Anderson.
Can you please state your name for the record?
Alba Rosa Torres.
Alba Rosa Torres.
And can you, Alba, were you tubing with Nicolae on July 30, 2022?
Sí.
Yes.
And I want to direct your attention to about the time the phone was lost, if you remember that.
Sí.
Yes.
Sometime after the phone was lost, was there some sort of disturbance?
¿Puede repetir, por favor?
Can you repeat that, please?
Sometime after the phone was lost, was there some sort of commotion or disturbance?
Sí.
C.
Yes.
Yes.
What do you remember about that?
No, no mucho.
Mm.
No vi.
Not much because I didn't see.
You didn't see anything about what happened downriver?
Ya había pasado todo.
Everything had already happened.
So you just weren't looking in that direction?
No.
No.
Do you remember hearing screaming or seeing people with bloody injuries at all?
The translator. It's been so funny. She keeps translating C. Yes. And now she just translated no as no. Oh, I hate it when this thing drops out of full screen. Okay.
Alguien me dijo que llamara al 911, nada más, que estaba pasando algo.
Somebody told me to call 911. That's it. They said something was going on.
And although I forgot to ask, did you know Nicolae before that day on the river?
Sí,
Yes.
How long had you known him?
como 5 o 6 años.
About 5 or 6 years.
Were you friends?
Sí,
Yes.
So after, did you say Tatiana told you to call 911?
sí.
Yes.
After that, did a person from your group leave to go help with the injured?
Sí,
Yes.
And do you remember who that was?
Eric.
Eric.
It's got to translate Eric as Eric.
And
I get it. It's just funny.
was the reason your group didn't leave sooner because Eric was away helping with the victims?
Nope.
No.
Another answer not helpful to the state. They
You
interviewed all these people
told
beforehand.
police, you remember telling the police about how you're impressed with how Eric responded to the situation?
No.
No.
These are just Hispanic friends.
Do you remember anything you told law enforcement about Eric? And
Solo que había salido a ayudar.
Only that he had gone there to help.
do you remember telling law enforcement that your group called Eric back to your group so you could leave?
Sí,
Yes.
Do you remember telling law enforcement that that man conducted himself very well, and that's why we were waiting so long until the police came,
sí,
Yes.
because he was away from your group, so you had to wait for him to come back, right?
sí.
Yes.
Sorry.
And
So it's kind of interesting. With the last witness, they had what sounded like a female translator translating the prosecutor's questions into Spanish in the background, presumably through the headset the witness is wearing. And it was a male who was translating her responses for the court back into her Spanish responses back into English. It looks like those translators have switched roles now for this witness. I guess they'll go back and forth every witness. Now it appears to be a man who's translating the state's questions into Spanish and a female who's translating her Spanish responses back into English.
was, when you saw people who were injured, were you wondering or trying to figure out who did it? Who was the person who caused those injuries?
No sabía, pero sí.
I didn't know, but yes.
By the way, good idea to have two translators in the courtroom, right? Because what if one of them wanted to lie about what was said? You'd have a second unrelated translator there to catch it.
And when you eventually left from the sandbar, Nicolae was wearing his hat, sunglasses, and jacket, right?
Cuando estábamos tubo,
when we were tubing,
Yes.
su chaqueta,
his jacket.
pero no recuerdo si los lentes. Yo no recuerdo si lentes.
But I don't remember if he was wearing sunglasses.
What about a hat?
No recuerdo.
I don't remember.
And when you spoke with law enforcement, you gave them a video you took after you left the sandbar. Do you remember that?
¿Sí?
Yes.
See?
May I approach?
Yes.
This is Exhibit 85, Judge. I'm just gonna.
Not very shocking that you'd put your clothes back on after climbing out of a cold river, right? Even under normal circumstances, but especially if you're in shock.
Attorney Andrew, you don't have to lay foundation.
Gotcha. Okay. I just have to move to admit 85, has to publish.
Any objection to 85? Received. You may publish.
He has something like hammer in his hand.
Take a picture and save it.
I don't take a picture, take a video. I take a video. Look,
Just take whatever.
look what he has in his hand. Look. Emmy, get out there. Look. Who are you? He has something in his hand. Emmy,
Just take a video, just take a picture, take whatever.
yeah,
If it's anything,
take a video.
just take a picture, take a video, take whatever. We don't know if it's anything to do with anything, but just take it.
Se cayeron, ¿ves?
Just take.
So,
I try.
over there. Everybody put your ass out.
Ernesto,
And
mueve
now-
para allá.
¿Eh?
Mueve para allá.
No, pero donde quiera va a estar loco. Te va a tener
Escúchame. Escúchame.
We gotta go to the rapids.
Para allá.
But just take video.
He waiting for something.
Just take a video.
I know. I try, but maybe I can't. Porque él está viniendo desde allá con una cosa en la mano, un martillo.
Hold your phone. We're going to the rapids. Over the rapids.
And he waiting.
Oh, but that was a video you took after you left the sandbar when you were going to the exit, right?
Yes.
And in the beginning of the video, is that Nick that you see paddling with his hand? Do you remember, or do you need to see it again?
Vi que iban ahí, pero yo estaba pendiente a lo que estaba haciendo.
Yeah, I'm talking.
Just a moment. The interpreter needs a repetition. Repite, por favor.
Que sí, estaba con nosotros ahí, pero yo estaba tomando mi video porque estaba asustada.
I saw that he was there. He was there with us, but I was taking the video because I was scared.
Were you scared because you didn't know where the person was that had hurt those people?
Sí.
Yes.
And you thought maybe the guy up on the shore was the person who did it?
Sí.
Yes.
Did it turn out to be an employee of the tubing company?
No sé.
I don't know.
Do you remember telling law enforcement that it turned out it was an employee of the tubing company?
Yo no recuerdo.
I don't remember.
And you remember telling police that you were wrong, that it was a hammer, that was because you're poor English, you used the wrong word?
Sí.
Yes.
Do you remember what was in his hand?
No recuerdo.
I don't remember,
pero algo tenía.
but he had something.
Was it maybe a radio or couldn't you see?
Ay, yo no sé, no recuerdo.
I don't know. I don't remember.
And was it, did you hear in the video somebody saying in English, "You're almost there"?
No.
No.
When do you recall telling law enforcement that when Nick came back to the group, he appeared calm?
Yo lo vi normal.
I saw him just normal.
And that was the time that you remember seeing blood everywhere and injured people?
No vi a nadie lastimado, solo de lejos vi que algo pasaba.
I didn't see anybody injured. I only saw that something was going on far away.
And Nick, when you saw Nick, you described him as being calm.
Yo lo vi normal,
I saw him normal.
todos asustados.
We were all scared.
I don't have anything else.
Mr. Shropshire?
Oh, but you and your group were tubing with Nick and his wife on the Apple River that day. Is that right?
Correcto.
Correct.
And do you remember your group stopping at the Hideaway Bar before all of this happened? Do you remember that?
¿Me puede repetir, por favor?
Can you please repeat the question?
Do you remember your group stopping?
Sí.
And
Yes.
prior to anything that happened with the other group?
Antes.
Before?
Yes.
Correcto.
Correct.
And when your group had stopped earlier in the afternoon, Nick was snorkeling around the area. Is that right?
Sí.
Yes.
And when your group does there come a point where Ariel loses his phone?
No, en ese momento no.
No, not at that moment. No.
Is there some point later on the trip where Ariel loses his phone?
Sí.
Yes.
And you know that Nick, because he has a snorkel and goggles, offers to go look for that phone. Is that right?
Sí.
Yes.
So Nick leaves your group and goes away looking for the phone. Is that right?
Correcto.
Correct.
Your group waits for Nick. Is that true?
Correcto.
Correct.
Correct.
To your knowledge, is Nick by himself, meaning nobody else from your group goes with Nick?
Solo, creo.
By himself. Yes.
And I think that you talked, when you spoke to the police, you mentioned that you saw this other group of people pushing Nick. Is that right?
No,
No.
es que no vi.
It's because I didn't see.
Okay. Do you hear Nick's wife say that Nick's in trouble?
Correcto.
Correct.
And when his wife says Nick's in trouble, do you look to see how Nick's in trouble?
En ese momento no, porque yo estaba de espalda.
Not at that moment because my back was facing that direction.
Yeah.
Do you turn around to see what's happening?
No,
No.
Okay. Do you see anyone else in your group respond when Mr. Miu's wife says Nick's in trouble?
mi hermano,
My brother. Mm-hmm.
And what's your brother's name?
Ernesto,
Ernesto.
So you see Ernesto respond. How do you see him respond?
yo le dije, ve a ver qué pasa.
I told him, go see what's going on.
And to your knowledge, does Ernesto listen to you and do that?
Yeah.
Yeah.
To your knowledge, does Ernesto walk over there or does he run over there? How does he get over there?
Solo vi que salió caminando y ya casi en ese momento regresaba Nick.
I just saw him walking over in that direction, and almost at that moment, Nick was coming back.
Do you see Nick walking back to your group?
Yeah.
Yep.
And when Nick comes back to your group, he tells you that he'd been attacked, right?
Yo pregunté.
I asked.
Okay. You asked what happened and he told you that he'd been attacked, right?
Estaban puchando, esa fue su palabra.
They were pushing. That was the word that he used.
Okay. Do you remember telling the police that Nick said 5 people attacked him?
Yo no recuerdo.
I don't remember.
What you do remember is him telling you they were pushing him?
Yeah.
Yeah.
Okay. And you described him as calm. Was he quiet?
Callado.
Quiet.
Did he appear to be in shock to you?
¿Puede repetir?
Can you repeat?
Did he appear to be in shock to you?
Yo.
You're talking about me?
No. Well, first I'm talking about Nick.
Oh,
What did you see Nick doing? How was he behaving?
Callado.
quiet.
Do you know? Have you ever seen someone in shock before?
No.
No.
Did he appear to be? Was he angry or upset?
No.
No.
So he tells you that he'd been pushed. Is that all he says to you about what had happened?
Correcto.
Correct.
Correcto. Correct.
You
Pacifico.
described you being in shock to the police. Is that right?
Claro, todos.
Of course, all of us.
Okay. And can I ask
Including
you,
Nick?
at that point, why did you feel the way you felt?
Porque no sabíamos qué estaba pasando, no sabíamos que tantas cosas, no sabíamos nada.
Because we didn't know what was going on. We didn't know many things. We didn't know anything.
Estábamos súper lejos nosotros.
We were really far away.
At that point, when Nick walked back to your tubes, were you in fear of the situation?
Y sin él estar también, porque estábamos todos asustados.
And also when he wasn't there, because we were all scared.
When you say we were all scared, did Nick appear to be scared to you?
No le presté atención a él.
I didn't pay attention to Nick.
Did your group stayed there for some period of time after Nick came back to the tube? Is that right?
Correcto.
Correct.
And do you remember about how long you were there?
No recuerdo, pero mucho. Pero,
I don't remember, but it was for a long time.
yeah.
She translated, yeah.
You didn't
yeah.
see Nick attempt to run away from you guys, like up into the woods or anything, did you?
No.
No.
He just sat on his tube, is that right?
Correcto.
Correct.
When your group headed back down the river after Nick came back, were there already police there?
Oh, ya había pasado todo prácticamente.
Oh, everything had already happened, basically.
Did your group have any contact with police at all when you were on the river?
Llamamos al 911 nomás.
We just called 911.
Tatiana.
Tatiana did.
And was that the only contact that you guys had with police or law enforcement of any kind while you were on the river?
Correcto.
Correct.
On that day, do you remember seeing Nick with sunglasses on at some points?
Yo no recuerdo.
I don't remember.
Okay.
No recuerdo.
I don't remember.
I'm going to show you exhibit 12A. Are you in this picture?
Yep.
Oh, sí.
You're right there with the pink shoes on. Okay.
Mm-hmm.
Do you see Mr. Miu in that picture?
She translated.
Yep.
If I said he's wearing sunglasses, would you agree with me?
Yes.
Yes.
If I said he's wearing the shirt that he was wearing later on, would you agree with me?
Sí.
Yes.
So if I asked you at various points during that trip, were there times that he was wearing the things you see in this picture?
¿Puede repetir?
Can you repeat the question?
If I asked you at various points on your trip that day, were there times that he was wearing sunglasses?
Sí.
Yes.
Are there times that he was wearing this shirt?
Sí.
Yes.
Ahí estoy. Sí.
Do you need help with the device?
Let's just.
Ay, un momento.
Somebody,
Ah,
Lots of grunting. Are they going to translate the grunting? What's that in English?
ya, perfecto. Sí, gracias. Ok, gracias.
thank you.
No Ricardo.
I don't have any other questions for you, ma'am. Thank you for your time today.
Mr. Anderson, do you have more questions?
Just one question.
Alba, did you ever hear Nick say he wanted to leave and go into the woods, but Ernesto's told him to stay with the group?
No.
No.
Okay, nothing else.
Mr. Robson? Thank you, Ms. Torres. The testimony is finished.
Gracias. Thank you.
Gracias. What's that in English? Anybody know?
It's almost 9:30. Let's take our morning recess. We'll come back in about 15 minutes. All rise for the jury.
Morning recess. All right. Let's move forward. Oh, here we go.
We did hear from
Okay. Not quite.
You're about to give this matter will be the truth, the whole truth, and nothing but the truth, so help you God.
You can answer out loud, please.
Yes.
Thank you. Please have a seat in the witness chair. Mr. Anderson.
Can you please state your name?
Sergio Liban Ruiz Leiva.
And can you,
Sergio Liban Ruiz Leiva. Sergio Liban Ruiz Leiva.
can you,
Wait for interpretation.
Sergio Liuban Ruiz Leiva.
How's the interpretation
can you
different?
spell your middle name?
Liuvan.
Liuvan.
Sergio, were you tubing with a group of people, including Nicolae, on July 30, 2022?
Sí,
Yes.
sí.
Are you in that? Are you on that image somewhere?
Sí,
Yes.
Where?
del chor amarillo.
I have the yellow shorts.
And white shirt and white bucket hat?
Sí,
Yes.
Do you remember a time when you were tubing when Ariel's phone got lost?
sí.
Yes.
And do you remember a discussion about looking for the phone or just leaving it?
¿Puedes repetir, por favor? Sí, en un momento decidieron de que no se iba a buscar el teléfono, que no querían porque la aseguranza iba a pagar el teléfono.
Yes, and at some point, they decided they didn't have to look for the phone because the insurance would pay for the phone.
Did Nicolae go look for the phone?
Sí.
Yes.
After do you remember how long? Strike that. At some point after he went to look for the phone, did you hear Sandy yell something about he's in trouble?
No.
No.
Did something catch your attention downriver?
Bueno, el grupo de personas.
Well, there was a group of people there.
And what about it caught your attention?
Alrededor de Nick.
They were around Nick.
Was there a time you saw Nick down in the water?
No, porque es que había muchas personas. Estaba muy grande el grupo.
No, because there were many people. It was a large group.
Again, not helpful for the state.
Did you ever remember seeing Nick?
That sounds like Nick was like the defendant was surrounded, right? At least a wall of people between this witness and the defendant. He couldn't see him. It was a large group around the defendant. Not helpful to the state.
Interacting with a blonde girl?
No.
No.
Can we have exhibit 45? Sergio, do you remember telling
¿Recuerdas?
police there was a girl, if I'm not mistaken, with a black leotard
Sí.
Yes.
who said, "Go, go, go, go" to Nick?
Yo la vi cuando ella estaba en el grupo, que estaba en el grupo alrededor, porque era la que más se distinguía entre ellos por el color del leotardo negro.
I saw her when she was around that group because she was easier to identify because of the black leotard.
Pero en sí estaba bien un poco alejado del grupo, del grupo porque no me moví de mi recámara.
But I was far away from that group. I just didn't move from my inner tube.
And do you remember telling police that Nick pushed her?
No recuerdo.
I don't remember that.
Can I approach?
Yes.
Again, but so say this is true. If Nick pushed her, he didn't punch her.
For the record,
Yeah.
Judge, I handed the witness Exhibit 45 on page 15. Sergio, do you see this transcript?
Yes.
And about the middle of the page, do you see where you said the woman yelled, "Go, go, go," and then Nick goes and pushes her?
Yes. Yes.
And you were far away, you said?
Yes.
Judge, I'm going to pull up some screenshots or frames. I'm going to start with 2872. I'll let you know. I'll let the clerk know when we're ready.
The evidence is that Nick didn't touch her until she put hands on him.
And we're going to zoom in on the top left. Sergio, is that you in the
Yep.
top left?
Yes.
And if you know, is that about where you were when you were watching what was happening?
Yo estaba al lado de mi recámara, de la goma.
I was right by my inner tube.
Do you remember telling police that you walked about 5 meters from your group and then someone told you to stop?
Mi hermana me dijo que no me moviera. Cuando me iba a mover, mi hermana me dijo que no me moviera hacia allá abajo, que no fuera. Por eso me regresé a mi recámara.
When I was going to move, my sister told me not to move. That she said, "Don't go to the other side." Just and that's why I returned to my inner tube.
Do you remember, did you see the girl in the blonde girl in the black swimsuit? Did you see her fall or stumble backwards when Nick pushed her?
No recuerdo.
No, I don't remember.
And did you actually see if it was a push or a punch?
Objection's been asked and answered. Steve.
Well, free approach.
Yes.
I knew it. The state had to circle back. If it's a push, it wasn't a punch. So now now the state wants to sway the response over to the punch side.
I'm sorry, I'll change my ruling. So overruled, you may ask the question.
Do you remember if it was actually a push or if it was a punch or something else that Nick did to the blonde woman?
No recuerdo.
No, I don't remember that.
And Sergio, do you see on page 15? I'll direct you. So I asked you about the paragraph on the middle. Remember that?
Sí.
Now, the next
Yes.
paragraph where you're describing what happened, do you see that?
Sí.
Yes.
And you described that it was after Nick got out of the water, and that's when the girl said, "Go, go, go," and he pushed her. Do you see that?
Sorry, I want to catch that again.
Do you see that? And that's when the girl said, "Go, go, go," and he pushed her. Do you see that?
Oh, sí.
Oh, yes.
And then below that, you reiterate that it was after she said, "Go, go, go, go," that Nick pushed her. Do you see that?
Sí.
Yes.
Can you turn to page 16?
He wasn't too far away to hear it if she was
On
screaming.
page 16, you described that she was wearing a black leotard, and you clarified that that was a black one-piece swimsuit.
Sí.
Yes.
And then you, further down, you describe again seeing her, hearing her say, go, 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 and he pushed her. You see that?
Sí.
Yes.
And from your memory, when you're telling this to police, you thought that was the last thing that happened, and then Nick walked back to your group.
Sí.
Yes.
And you thought he was down in the water before the girl said, go, 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 and he pushed her. Right?
Yes.
And
State
Sergio,
impeachment
have
of
you
one witness?
ever seen the video from this incident?
No.
No.
And so you were trying to recount what happened to the police as best you could remember?
Sí.
Yes.
Sí, en el momento.
Yes, at that time.
Did it happen fast?
Yep.
Yeah.
Was it difficult to remember in what order things happened?
Lo que yo recuerdo fue que en el momento que se perdió el teléfono, Rosy se puso en una esquina a buscar el móvil en la orilla.
What I remember is that at the moment when we lost the telephone, Rosie started looking for the phone by the edge of the river.
Y yo me quedé ahí en la balsa, lo cual le decían de que dejara el teléfono, que ya la aseguranza lo pagaba.
Yeah, I stayed there because they were talking about it and they said, just leave it, the insurance will pay for it.
Y ya no recuerdo más nada cuando el compañero Nick cogió el snorkel y se tiró a bucear, a buscar el teléfono.
And I don't remember anything else except that Nick took the snorkel and started diving in there to look for the phone.
Y ya me fui. Entonces cuando miro hacia abajo, ya veo el grupo de personas.
And then I left. And then that's when I saw on the other side the group of people.
Ya, más nada, eso es lo que recuerdo.
That's what I remember.
So you may have forgotten a lot of what you remembered then.
¿Puedes repetir, por favor?
Can you repeat that, please?
Yeah, bad question.
You can see the transcript where you describe seeing more to law enforcement.
No, yo no había visto, yo no vi, yo solamente escuché.
I didn't see. I just heard things.
But you can see in the transcript you told police multiple times that when she yelled, go, 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 Nick pushed her.
Objection is
Bueno, porque se sentía que era la voz de una persona, de una mujer, pero no estoy seguro si fue ella o no.
Because I heard the voice of a woman. I am not sure if it was her.
You described her as a blonde woman in a black one-piece swimsuit.
Sí,
Yes.
sí, lo veo aquí.
And I see it here, yeah.
And when you described seeing Nick down in the water, you described that you believed that they must have hit him, or you thought they must have hit him because he was down in the water. Do you remember that? Or did you say that to law enforcement?
No, I didn't. I never said that.
No,
No.
Do you remember ever seeing anyone hit Nick?
No.
When Nick came back, did Nick come back to the group at some point?
sí.
Yes.
And as he was coming back, did you see people that were injured?
Sí, sí.
Yes, I saw them. Yes.
Did you see blood?
Bueno, en el lugar que estaba, yo solamente veía la mano de la muchachita y sí, tenía como sangre así, pero no se distinguía bien.
From the place where I was, I could see the girl with her hand over here, and you could see blood. Yes. but you couldn't distinguish it that clearly.
Porque era la que le estaba pidiendo ayuda, a que decía que llamaran al 911, que estaba pidiendo ayuda a mi hermana.
She was the one asking for help to call 911. She was asking my sister to,
Y en ese momento me
Call.
volteé y ya no miré, no quise mirar más.
and I didn't want to continue looking. I just turned around.
Turned away from the injured person you saw?
Para no ver nada de sangre.
So I didn't see any of those things. Yes.
Un momentito. Just a moment, Your Honor. Señora, acérquese al micrófono usted para no ver nada de él.
Para no ver nada de lo que estaba pasando.
So that I didn't see what was happening.
Puede acercar el micrófono si usted
So it was something that was hard to watch or see.
Era algo difícil de ver. ¿No será difícil ver eso?
Sí.
Yes.
When Nick came back, did you hear him say anything?
¿Escuchó decir algo?
No.
No.
Did you hear him say they took my knife?
¿Me quitaron mi navaja?
Neti le preguntó y eso le dijo y yo le pregunté a Neti que qué había dicho y dije que sí, que fue eso lo que dijo.
Nettie asked him, and I did ask what he said. What she said.
Repito que no sé.
Can
Que
you?
Neti le preguntó que qué había sucedido y entonces él dijo que le habían quitado la navaja.
Nettie asked him what happened, and he said that they had taken the knife away.
Y yo le pregunté a Neti, ¿qué dijo Nick?
And then I asked Nettie,
Y,
what did Nick say?
y me dijo que le habían quitado la navaja y ya no se habló más nada en él.
And she said that they had taken away his knife, and we didn't talk about it anymore.
Did you see Nick saying anything or hear him talking anymore after that?
¿Escuchó hablar más? ¿Algo decir algo más?
Mm.
después de eso?
No.
No.
What was Nick like? What did he look like? How was he acting?
¿Cómo se veía? ¿Cómo estaba comportándose, actuando?
Vino pálido cuando se acercó a nosotros
He looked pale when he got close to us,
y con los ojos grandes
and his eyes wide open.
y se sentó y ya no habló más nada.
He just sat there and he didn't talk anymore.
Like shock. Not helpful to the state.
Do you remember when he came back and got back to your group, him putting on his hat and jacket?
Si él se puso su chamarra y su gorra.
Sí.
Yes.
And do you remember telling police you didn't look at Nick too much because you didn't dare to look at him?
No lo volteaba a ver mucho a Nick porque no se atrevía a verlo.
Porque no me atreví, estaba en la parte de atrás de la recámara.
I didn't dare, but he was also in the back of the inner tube.
Él dijo que estaba atrás. Usted.
Yo.
I was in the back.
So can you turn to page 21?
Por favor, pasar a la página 21.
Folks, just a reminder, this is an adult show for adult people watching an adult court proceeding about adult events. People died. Someone's on trial for murder in the first degree. If anyone's hypersensitive, there's, I'm sure if you move elsewhere in the internet, there's some SpongeBob SquarePants you can watch or something like that. No one has to be here.
Do you see where you said,
Yes.
I didn't look at him because the truth is I didn't dare to look at him?
No, porque la verdad es que no me atrevía a voltear.
Sí.
Yes.
Do you remember how long you guys stayed at the sandbar?
No.
No.
recuerdo.
I don't remember that.
El tiempo no lo recuerdo.
I don't remember the time.
Do you remember seeing police come?
sé que Eric fue a buscarla porque Eric fue a buscarla
I know that Eric went looking for them. Eric went to
a la policía a guiarlo.
look for the police and guide them.
After Eric came back to your group, did your group leave?
Sí.
Yes.
What do you remember of the time when you guys were tubing to the exit?
¿Puedes repetir, por favor?
Can you repeat that, please?
Can you describe what it was like, what you remember from tubing to the exit?
Compañero Nick se puso la gorra, la chaqueta y ya no se habló más nada. No se
Well,
habló nada.
Nick put on his hat and then his jacket, and we didn't talk about anything else.
Y ya no se habló más nada porque estaba todo el mundo callado.
Nobody talked. Everyone was quiet.
I don't have anything else.
Mr. Trophy?
Sir, do you remember giving an interview to the police on August 3rd of 2022?
Sí, ellos fueron a mi casa.
Yes, they went to my home.
And was your memory of what happened better in August of 2022, or is it better today?
Bueno, antes estaba mejor. Yo estoy muy nervioso.
Well, it was better back then. I'm very nervous now.
Okay, so when you spoke to the police on August 3rd, about 5 days or 4 days after this happened, fair to say your memory is better of those events than it is right now.
Sí.
Yes.
And when you were interviewed by the police, there was a Spanish-speaking officer that was talking to you. Is that right?
Sí.
Yes.
And you tried to answer that officer's questions as truthfully as possible. Is that right?
Sí.
Yes.
And you said that was at your house?
Sí.
Yes.
Was it less stressful than it is here today?
Sí.
Yes.
And that officer had asked you questions about what happened on July 30th of 2022.
Sí.
Yes.
I want to ask you, if I can, about that date and maybe some of the things you answered when you were speaking to the officer, okay?
Sí.
Yes.
So I'm going to start with this. You knew that Nick Miu had a knife with him that day because you saw him fixing his shoe or his sandal. Is that right?
Sí.
Yes.
So before any of this incident happened, he had been using that knife to fix something, right?
Sí.
Yes.
And you knew that Mr. Miu or Nick was looking for a phone that your group had lost. Is that true?
Sí.
Yes.
And you also knew that Nick, on that day, Mr. Miu, was with your group, and your group included his wife. Is that right?
Sí.
Yes.
Can you look at that picture right there, sir?
Mhm.
You had mentioned you're in this picture, correct? Is it okay to identify?
Yes.
Sí. Sí.
And you see Mr. Miu here?
Yes.
You see Mr. Miu here?
Sí.
Yes.
This is the shirt that he's got on is the same shirt you saw him wearing at the end of the day, right?
Sí.
And this is
Yes.
and this picture is taken before you guys head down the river. Is that right?
Sí.
Yes.
And he's wearing sunglasses in this picture, right?
Sí.
Yes.
So is it fair to say that when he got off the river, he looked the same or close to the same as he did when he got on the river?
Sí.
Yes.
Now, you know that Nick is looking for this phone that had been lost. That was Ariel's phone, right?
Sí.
Yes,
And you were also aware that he had brought snorkeling gear and goggles with him on that day. Is that true?
Sí.
yes,
You had seen him on that day snorkeling around the areas where you guys were tubing. Is that right?
Sí, al principio, sí, en la mañana.
yes. At the beginning, that was the case in the morning.
And when you speak to the officer about the specific incident, meaning what had happened, you recall telling that officer that you saw a group of people surrounding Nick.
Repite la pregunta, por favor.
Can you repeat the question, please?
Sure. You told
Love
the
to.
officer on August 3rd of 2022, when you were being asked about what you remember, that you had remembered that they were surrounding Nick.
Sí.
Yes,
You told this officer that they were falling on him. Is that right?
Your Honor, the interpreter needs a repetition.
I'm sorry.
the interpreter needs a repetition.
You told the officer that you observed those people falling on him. Is that right?
Sí, cuando lo empujaron.
Yes, when they pushed him.
You told
Keep in mind, folks, when the state brings this murder charge against this defendant, they know all this. They know this is going to be the testimony. They're well aware that this interview was given by this witness to this Spanish-speaking officer a few days after the event.
the officers that they put Nick in the middle of them. Is that right?
Sí, lo tenían ahí, no sé, el bulto de gente, y se veía que estaba adentro el compañero.
Yes, they had him there. It was a group of people, and you could see that they had compañero, my friend there.
Could you see Nick with a group around him? Could you see him?
Y usted lo-
No, no lo podía ver, solamente el grupo,
No, I couldn't see him. I could just see the group,
Claro, ya. Sí, solo el grupo.
just the group.
You told the police that they hit him, meaning they hit Nick. Is that right?
Sí, cuando lo empujaron al principio, que él se acercó, se acercó, y cuando ya que lo empujaron, y ya ahí lo rodearon.
Yes, when he had close, then they pushed him, and then they surrounded him.
And you remember the blonde girl with the black suit on. Is that true?
No la recuerdo muy bien, pero sí, tengo más o menos la...
I don't remember her very well.
No la recuerdo.
I don't, but I have an idea. I don't remember her.
Well, do you remember telling the police that you heard the blonde girl telling Nick, go, go, go?
Ujú. Sí. Sí.
Yes, yes,
You told the police that Nick pushed her. Is that right?
Sí.
yes.
Another state witness far more helpful to the
Did
defense.
you see the rest of what happened?
No.
No,
No.
You see Nick walking back to your group, though. Is that right?
Sí, cuando venía, lo traía. Sí.
yes, when he was coming, yes, I saw.
And you described him to police as being white, pale, and scared. Is that right?
Sí.
Yes,
You described him as having wide or open eyes. Is that right?
Sí. Sí.
Yes.
And at one point, I think you said that Tatiana told you, don't go over there. Is that true?
Sí, mi hermana.
Yes, my sister.
So Nick, to your knowledge, what you know, Nick was by himself against that other group. Is that right?
Sí.
Yes.
No one, you said to the police, as far as you know, no one in your group went over to help him. Is that right?
No, nadie se movió, solamente Ariel al final que bajó y Eri a ver qué lo que estaba pasando.
No, nobody moved. And only at the end, Ariel and Eric went over there to see what was happening.
But that was after it was over. Is that right?
Please repeat.
Sure. When Ariel and Eric went over, the incident had ended. Is that right?
Sí.
Yes.
So in terms of assistance or help, Mr. Miu was by himself. Nick was by himself.
Sí.
Yes.
Did it appear to you that Nick was in shock when he came back to you?
Bueno, impactado. O sea, impactado, sí, no sé. Yo digo shock porque es mi manera de expresarme, pues, pero impactado puede ser.
Yes, he looked in shock. I said in shock, or something had impacted him. Yes, in shock.
Do you remember waiting some time before your group moved on down the river after the incident?
¿Puedes repetir, por favor?
Can you repeat, please?
Do you remember there being some time that your group waited when Nick came back before going back down the river?
No, no recuerdo. Y cuando él regresó, ya el Neti dijo rápido, vámonos. Fue lo que dijeron.
No, I don't remember that. When Nettie came back, when he came back, Nettie said, "Let's go."
Do you remember telling the police that you waited until you were told to leave the area? Do you remember that?
Oh. No recuerdo, pero si le dije eso, debe ser sí.
No, I don't remember, but if I said that, it must be right.
You were asked by Attorney Anderson about a statement that you said that you didn't dare look at Nick. Do you remember that?
Sí.
Yes.
He wasn't threatening toward you, right?
No.
No.
He wasn't being aggressive or angry toward you, right?
No.
No.
You said the group was pretty quiet once you got back.
Sí.
Yes.
So when you said that you didn't want to look at him, it wasn't out of fear of him, right?
No.
No.
It was because everyone was in shock.
No, y sí, no sabíamos qué había pasado en sí y no sabía cómo preguntar. Bueno, sí, todo el shock, sí.
Yes.
Accidente.
We didn't know what had happened, so we were in shock. Yes, we didn't know about anything of that incident.
Mr. Anderson?
A few times, or a couple times, you said Nettie. Who's Nettie?
a Ernesto. Yo le digo así.
I'm referring to Ernesto. I call him like that. Yeah.
I'm sorry, Judge, I didn't hear that.
Can the answer be repeated?
I call him Nettie, but I'm referring to Ernesto.
How do you know Ernesto?
Desde de Cuba.
From the time I was in Cuba,
And are friends?
Sí, somos vecinos de allá de Cuba.
yes, we were neighbors in Cuba.
How long have you known Ernesto?
Bueno, él me vio crecer a mí, como que dice.
He basically, we grew up together.
Close friends?
Sí,
Yes.
How long had you known Nicolae Miu?
bueno, cuando yo llegué aquí a este país, que Nicolae Miu trabajó con Nettie.
When I came to this country, I met Nick
Y lo,
Miu.
conocí,
He worked with Nettie.
y lo conocí en casa de Nettie.
So I met him at Nettie's house.
So, is Nick a friend too?
Mm, Solo conocidos, nos reuníamos una vez o dos veces al año así.
We were acquaintances. We met twice a year.
Are Ernesto and Nick good friends?
Sí, creo.
Yes, they are.
Defense asked if Nick looked like he was in shock. Do you remember that?
Sí.
Yes.
What you told police was, I don't know if he was scared or worried.
Que no se veía cuando una persona estaba preocupada en el semblante de la persona, se ve cuando está preocupada o
Because you see somebody when that person is worried, you can see in his face.
Obviously, you didn't know what he's thinking at that time.
no.
No,
You don't know if he's in shock or worried about what just happened.
No,
no.
no, solo la cara que se le veía blanca, pálida y con los ojos grandes, así ya más nada.
No, I just saw he was white, he was pale, his eyes wide open.
And I just want to clarify, defense asked you about the interview with the Spanish-speaking detective on August 3rd at your house.
¿Sí?
Yes,
That transcript I was asking you questions about, that's from that interview, right?
Sí.
yes.
And I just want to make sure I understand what you saw. You saw Nick, I think on cross, you said. You saw Nick push the blonde girl and someone push Nick. Do you see anything else besides that you remember?
No.
No.
You said in your interview you didn't dare look at Nick, and defense asked if that was because the group was in shock. Do you remember that?
Sí, estaba nervioso.
Yes, I was nervous.
You didn't say about anyone else that you didn't dare look at them, right?
No dije, solamente hablé de mí, no sé lo que piensan las demás personas.
No, I only talked about me. I didn't know what the other people were thinking.
When Nick came back, did you see any injuries on him?
No me fijé.
No, I didn't notice.
Nothing else.
Mr. Trophy?
So I'm going to just ask you,
So that's the state always ends up falling back on these pointless questions at the end. Did you see anyone else with a knife? Did you see the defendant with injuries? No one else needed a knife for that group as a whole to be reasonably perceived as imminently about to inflict deadly force on this defendant. You're not required to suffer an injury before you can use force in self-defense.
you were just
The other people were thinking.
When Nick came back, did you see any injuries on him?
No me fijé.
No, I didn't notice.
Nothing else.
Mr. Trophy?
Sir, I'm gonna just ask you, you were just asked about what you saw. And you told police that you saw Mr. Miu get hit, correct?
Sí.
Yes.
You saw people surrounding him.
Yo vi el grupo de personas, no es que, no sé si lo estaban rodeando, no, solamente vi el grupo de personas.
I saw the group of people. I don't know if they were surrounding him. I saw a group of people.
You agree that you told police they were surrounding him, though, right?
¿Puedes repetir, por favor?
Can you repeat that, please?
When you spoke to the Spanish interpreter, or when you spoke to the Spanish-speaking officer, you told that officer that you observed people surrounding him, correct?
Sí.
Yes.
You told that officer that those people jumped on him, correct?
Sí.
Yes.
And you told them that you saw Nick on the ground, correct?
Sí, ahí cuando lo empujaron.
Yes, when they pushed him.
Thank you, Mr. Ruiz. Leyva, you may sit down.
So Corey there got one answer he didn't like. It happens to the defense too sometimes. You saw people surrounding him. Oh, I don't know if people were surrounding him. I saw a group of people. But Corey recovered nicely. You told police they were surrounding him. Yep. You told police they jumped on him. Yep. You told police you saw the defendant on the ground. Yes, when they pushed him. Good finish. Good strong finish for the defense.
Yes.
Up, the white noise again. Yeah, so just so people know, you're not required to suffer so much as a scratch before you can defend yourself. You're allowed to defend yourself against the attack,
Members of
the
the jury, we
injury
need
that's
about 5
about to
minutes before
happen.
the next witness, so we'll excuse you for that moment.
Oh, sorry, what did the judge say?
Members of the jury, we need about 5 minutes before the next witness, so we'll excuse you for that moment.
Okay. I don't know if they're going to chat or they're just waiting for the witness to show up. I'm going to fast forward.
River traffic still do a confrontation.
I don't want to hear this chatter. Never know when you're going to get a copyright strike. Oh, this is interesting, though. I had not seen this before. Let me fix this. The jury. Oh my God, they have a 90-year-old on the jury. Male. So 1, 2, 3, 4, 5, 6, 7, 8 males. 1, 2, 3, 4, 5, 6, 6 females. 14. They'll get down to, of course, 12. 2 of these will be alternates. That'll be dismissed before deliberations. And 3, 4, 5, 6, 7, 8. 8 of these are 50 or older. 8 of these are 50 or older. 2 are in their 20s. So even if 2 of the older ones get dismissed, it's still 6. Half the jury is 50 or older. That's the worst case scenario for the defense here. You think these 50-year-olds ever imagine themselves facing a group of young men, 6 foot, 170 pounds, 13-to-1 odds on a river, being threatened, being screamed at, being falsely called a pedophile, a raper, more people coming over, not to help them? I think this is going to be a tough conviction for the state. Just going to make a note of this. Let's see, where can I save that? So I'll be able to find it later. All right. Preserved for my records. And we should be back.
Sí.
Yes.
You didn't know what happened. Is that
Oh, I thought we were back, but we're not back. I really don't like it when the lawyers ask questions sitting down like this. I much prefer the lawyers are standing up. All right, next witness, little Bo. Is that a Bo?
Ms. Ruiz Leyva, please come forward. Please face the clerk. Raise your right hand. She'll administer the oath.
Do you swear that the testimony you are about to give in this matter shall be the truth, the whole truth, and nothing but the truth? So help you God?
Sí. Yes.
Please have a seat in the witness chair. Mr. Anderson.
Can you please state your full name?
Tatiana Ruiz Leyva.
Tatiana Ruiz Leyva.
Tatiana, were you tubing with a group including Nicolae on the Apple River on July 30, 2022?
Sí,
Yes.
Do you see yourself in that photo over there?
sí.
Yes.
Which one are you?
La que está con el sombrero al lado del pullover blanco.
¿Al lado de qué?
Del que trae el pullover blanco.
Oh,
La que
I'm the one wearing the hat right next to the guy in the white t-shirt.
tienes tu Emi.
Ernesto.
Emi, al lado
Emi.
de Emi.
Oh, correction from the interpreter. And next to Emmy.
Who is Emmy?
La que está al lado mío, la blanquita chiquita. La
De-
esposa de Neti.
¿La que qué?
Oh, sí,
The
¿verdad?
one that is right next to me, the white girl who is short, and she is Neti's wife.
And do you recall a time when you were on the river that day where you saw people with bloody injuries?
Sí.
Yes.
Did you see anything before that on what led to that?
No.
No.
When you spoke with police, you told them you didn't see anything, you weren't looking in that direction?
Correcto.
Correct.
Did you, after you saw people with the
Correct.
injuries, did you call 911?
Sí.
Yes.
Can I have exhibit 63?
They're going to play the 911 call. They established foundation for the call by having the 911 manager come in earlier.
Tatiana, do you remember, did you have trouble speaking with the person on 911?
Sí.
Yes.
Did you hand the phone to someone else?
Sí, se lo pasé a Rosy.
Yes, I handed it to Rosie.
And then, does Rosie speak fluent English?
Rosy se lo pasa a Emi later.
Rosie handed it to Emmy later.
And just to clarify, this is Emmy,
Sí,
Yes.
the purple t-shirt?
sí.
Yes.
Did you have any idea what happened?
No.
No.
Do you remember seeing Nick come back to the group?
Sí.
Yes.
Did you notice anything about him? Was he calm, worried, angry?
No, normal.
No.
Ah, viene del agua, normal.
Just normal. He was coming from the water. Just normal.
And what was the tube ride to the exit like? Were you guys talking? Was it quiet?
Muy callados.
Very quiet.
you remember Nick saying anything on the tube ride out?
No, nunca.
No, never.
I don't have anything else.
What? That's it?
Good morning.
Good morning.
Good morning.
Ma'am, do you remember being interviewed initially? Well, you remember being interviewed by a Spanish-speaking police officer on August 3rd of 2022?
Sí,
Yes.
Do you remember where you were interviewed?
sí.
Yes.
Can you tell me where that was?
En la casa de mi hermano.
At my brother's house.
Sí.
Okay. And that officer was asking you questions about what happened about 4 or 5 days earlier when you were on the river with Nick Miu.
Sí,
Yes.
sí.
And
Yes.
your memory was better in August of 2022 than it is today. Is that fair?
Sí,
Yes.
Okay. And you knew on July 30th of 2022 that at some point on your trip, Nick was looking for a phone. Is that right?
sí,
Yes.
And you knew that he had left your group to go look for that phone, correct?
sí,
Yes.
You knew that Nick was by himself, separated from your group while he was looking for that phone. Is that right?
sí,
Yes.
And Nick was with you guys in terms of that group, but he was also with his wife is in that picture. Is that right?
sí,
Yes.
So it was Nick and his wife were part of the group that was tubing.
sí.
Yes.
Did Nick appear to be in a good mood that day? He didn't appear to be angry or anything?
No, nunca estuvo enojado. Estaba muy bien.
No, he was never angry. He was just fine.
And when Nick is, you see that he has a snorkel and goggles, is that right?
Sí,
Yes.
And when he's looking for the phone, he goes off with those snorkel and goggles looking, right?
sí,
Yes.
Your group is waiting for him to come back. You're over on the side of the river at that point, right?
sí,
Yes.
And you were asked by Attorney Anderson if you saw what happened, and your answer was that you didn't see anything.
no, nada.
No, nothing.
Did you hear anything?
¿Cómo que escuché algo? ¿En qué momento?
What do you mean if I heard anything? At what moment?
Did you hear anything that sounded like an altercation or a fight?
¿Pero en qué momento? ¿En el momento que ni baja o cuándo? No, no escuché nada.
But at what moment when Nick came down or when? No, I didn't hear anything. What time are you talking about?
There's a time when Nick's gone away from you guys with his snorkel, right?
Now she sounds like me trying to explain a new gun to the wife. What? No, honey. What are you talking about? We've always had this one. We've had it. It's been here forever.
Ujú,
And then there's a time that you see him come back, right? You see him come back to your tubes.
Uh-huh.
In between those two times, do you hear people yelling or fighting?
Cuando él regresa ya había pasado y sí, se oía la bulla y eso, sí.
When he came back,
Se oía la bulla.
things had happened and you could hear the loud noise. Yes.
Ujú.
And you were asked when Nick came back, did he say anything to you, to the group? Do you remember being asked that?
Sí, pero no se habló nada, no se habló nada, no se preguntó nada.
Yes, but we didn't talk about anything. We didn't talk about anything. Nothing was asked.
Do you remember telling that Spanish-speaking police officer that when Nick came back to your group, he told you the kids jumped me?
No, no recuerdo.
No, I don't
No se habló
remember.
nada, todo el mundo quiet.
Everybody was quiet.
So I just want to make sure you don't remember telling that to the officer back on August 3rd of 2022.
Time for the transcript.
Bueno. ¿Qué? No, no recuerdo.
No, I don't remember.
If I showed you a transcript, would it refresh your
And
recollection?
you described Nick as when he came back, he was quiet.
Sí, callado.
Yes, quiet.
Before he left to go look for this phone, was your group talking and laughing and having fun?
Sí,
Yes.
And when he came back to your group, the talking, the fun, that all stopped. Is that right?
sí, todo se acabó.
Yes, everything was over.
I don't know.
Mr. Anderson?
You spoke with a Spanish-speaking detective at your house some days after the incident, right?
Sí,
Yes.
You also spoke to an officer right after you got out of the river.
al salir del río nos pararon allí, pero no, no recuerdo. Mucho policía, no sé.
When we got out of the river, they stopped us there, but I don't remember. There were a lot of police presence. There was a lot of police presence.
The officers that when you got to the exit didn't speak Spanish, right?
No, no
No,
hablamos, no se habló, yo no hablé.
no, we didn't say anything. Nothing was said. I didn't say anything.
You told an officer there, you heard boys yelling, "Help, help, help." Do you remember that? You said that in English.
Ah, no, eso sí.
Oh, yeah, that
Sí,
I did, yes.
Do you remember when you heard the boys yelling, "Help, help, help"?
Sí, una chica.
Yes, a girl.
Oh, was it a girl who was injured?
Sí, tenía su mano en el estómago.
Yes, she had her hand on her stomach.
Do you know why you said boys?
Can you repeat the question?
Do you know
for the
why you
interpreter?
said boys were yelling for help?
Please, could you please repeat the question?
Do you know why you said boys were yelling for help?
Sí,
Yes.
Why?
yo iba bajando y ellos estaban gritando, help, help, y vi el grupo de chicos allí, un grupo, pero no estaba yo cerca de ellos. Y ahí fue cuando yo mismo me retiro porque como que fue lejos y llamé a la policía.
I was
La chica,
getting
la
off,
mujer.
and there was a group there, and the kids there were yelling "help, help!" But I was kind of far away. But that's when I called the police.
When you heard the boys yelling for help, was that before Nick came back to your group?
Sí,
Yes.
Nothing else.
Mr. Trumpet?
Ma'am, do you know that people were injured on the river, right?
sí,
Yes.
And one of the people that was yelling or asking for help was this girl that had been injured. Is that right?
sí.
Yes.
Do you know now that there were some males that had been injured?
Sí,
Yes.
Do you know when you heard help? If that was after those males had been injured?
sí,
Yes.
So if I'm hearing you right, those males are injured, then they're yelling, or somebody is yelling for help. Is that right?
ujú,
Mm-hmm. Yes.
Yes or no? She translated to yes.
Thank you, Ms. Ruiz-Leyva. You may step down. You are excused.
Again, helpful for the defense, not for the state.
Who is the next witness? Yes. You can do it now while I'm making this announcement. Right, members of the jury, you may remember at the beginning of the trial, I explained that the state will proceed first because the state has the burden of proof. Once the state finishes its evidence, then the defense may, if they choose, present evidence of their own. Sometimes we deviate from that rule to accommodate a witness. Today, we're making an accommodation because we have interpreters present. So rather than waiting until some other day, we're going to take those witnesses today, even though they're being called by attorneys for Mr. Miu. Mr. Nelson, who will be the witness?
Ernesto. Apologize. Torres.
Ernesto Torres.
All right, the first defense witness. Out of order. I see in the comments that the state's rested today, the morning of Tuesday, April 9th. We're watching Friday, April 5th.
See, Mr. Torres? Right here. Please raise your right hand. She will administer the oath.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
See,
Yes.
please have a seat in a witness chair. Mr. Nelson.
Good morning.
Buenos días.
Can you tell all of us your name, please?
Ernesto Torres Chagas.
Ernesto Torres Chavez.
Chagas.
Chagas.
It's got to correct the translator.
Call you by Ernesto.
Sí.
Ernesto, do you know
Yes.
this man over here?
Sí.
Yes.
Who's this?
Nick.
Nick.
Nick who?
Nick Miu.
Nick Miu.
How long have you known Nick Miu?
Aproximadamente más de 10 años.
Approximately, well, it's over 10 years.
Do you did you work with Nick?
Sí.
Yes.
Sí.
Yes.
Who's your wife?
Emi.
Emmy.
Is up here? Is this a picture of you and Amy?
Emmy.
Sí.
Yes.
Do you have any family in here other than that?
Mi hermana está a la derecha.
My sister on the right side,
Rosy.
Rosie.
That's your sister.
Sí.
Anybody else family?
No, familia no, todos amigos.
Not relatives, all friends.
Amigos.
Did your wife Amy work with Nick as well?
Sí.
Yes.
And when you said you're friends with Nick, obviously sometimes when we're adults we have lots of different friends. How close would you consider Nick as a friend?
It's my best friend.
You're at his house, he's at your house.
Please, for the interpreter, could you please repeat the question?
You've been to his house, he's been to your house, you guys hang out together.
Sí.
Yes.
Would you consider Nick to be kind of a handyman?
Sí.
Yes.
Why do you say that?
Porque él siempre está arreglando cosas en su casa o cuando va a la casa de alguien y
Because
necesita ayuda.
because
Él está ahí para ayudar.
he's always there helping things in his house, or he goes to other houses to help fix things.
Have you ever seen him use tools to fix things?
Sí.
Yes.
Have you ever seen him with a pocket knife?
Sí.
Yes.
Have you ever seen him use the pocket knife as a tool to fix things?
Sí.
Yes.
Can you tell me about some of those things that you've seen him do with the pocket knife to fix things?
Lo he visto arreglar cosas en su casa o en mi casa cuando
So, folks, I'll interrupt this for a second. There's an important lesson we can take from this line of questioning where the defense keeps asking these witnesses, did you know Nick to be a handyman? Did you know Nick to carry a pocket knife to fix things? Did you ever see him fixing things? Can you give us examples of him fixing things with the pocket knife? The defense is asking those questions because they're trying to present Nick's possession of the knife on the river as simply being a tool. That's why they keep asking about him using the knife to cut the strings holding the tubes together. That's why he was asked to bring the knife specifically for that purpose, as a tool on the river, not as a weapon. Now, is there anything wrong with Nick carrying a folding knife as a weapon for self-defense? Is that against the law? I mean, I don't do knife law, but I presume not. It looks very similar to, I mean, got one right here. I mean, I carry a knife every day. I use it to open packages and, of course, cut strings if I need to and that kind of stuff. But it's also an implement for self-defense, should it come to that. There's nothing wrong with that. But how will the state try to present it? That Nick went to the river with a knife to kill people? You think that's beyond the prosecution to say things like that? No, it's not. And it's become increasingly popular in the self-defense community in recent years to carry not just a folding knife, but a fixed blade knife, usually center line of the body, for self-defense purposes. And a fixed blade knife has definite tactical advantages over a folding knife, particularly in the speed of deployment. But how do you think a prosecutor would present a fixed blade knife? It's going to look different than a pocket knife, right? It's a little more unusual. It's not that common for people to carry a knife that way, what you might think of as normal, boring people. It's an unusual implement to carry for self-defense to people who would be normal people on a jury. Now, I'm not saying there's anything wrong with it. There's nothing unlawful about it, let's presume. Again, I don't do knife law, but let's presume. But would it be easier for the prosecution to portray it as something indicating a state of malice? Or would the prosecutor attempt to do that? Yeah, the prosecutors, they're in it to win it, folks. They'll take anything. If you've been following along the last few days, you'll remember I talked about the George Zimmerman trial, where the prosecutor screamed at the jury about the fact that George Zimmerman was not only carrying a Kel-Tec, well, they called it a Kill-Tec pistol. He was carrying it with a round in the chamber in the ready-to-kill position. Is there anything wrong with carrying a round in the chamber when you're carrying a pistol for personal protection? Of course not. Every bailiff in the courtroom, when this prosecutor was screaming this nonsense, had a round in the chamber. Every police officer carries that way. I carry that way. Everybody carries that way if you're carrying for personal protection, absent the same, some weirdos. No offense, you empty chamber people. So the prosecutor would be willing to say anything. Now, I'm not telling you not to carry a fixed blade knife in a centerline position. First of all, I don't tell people what to do. Second of all, we always have to balance, can this be used against me in court? And the answer is always yes. I don't care what this is. Whatever you're doing, as far as the prosecutor is concerned, is going to be the wrong decision. They'll present it to the jury as the wrong decision. So that can't control your decision-making in self-defense, because they'll make look bad whatever it is you're doing. But just make informed decisions. So there are, downsides to particular methods of carrying weapons. The same would be true if you were carrying a really unusual firearm or really unusual ammunition. The prosecutor would try to use that against you. Now, you have to balance, all right, I could take a hit on this if I were in a courtroom as a defendant. What's the upside? Does it actually better position me to win the physical fight? If it does, it may be worth the risk of a political hit in a courtroom. And I think something like a fixed blade knife, if you know how to use it, may well fit that criteria. But just be aware that that is the balance that has to be evaluated. Okay, back to the trial.
Compré mi piscina. Él fue uno de los compañeros que me ayudó.
I've seen him fix things
Usaba
in
su
his
navaja
house
para cortar cosas.
and my house. When I bought my pool, he helped me fix the pool and in general fixing things. And he used the knife. Sorry.
Want to ask you some questions about the trip down the river on July 30th of 2022, okay?
Sí.
Yes.
Is that a trip you and your wife have made before?
Sí.
Yes.
Prior to leaving your house that day, did you have a call? Did you call Nick Miu that day and ask him to bring anything?
Sí.
Yes.
What did you ask Nick to bring?
Que llevara su navaja.
To bring his knife.
Why did you ask Nick to bring? And when you say his, start over. his knife? Is that a pocket knife or some other knife?
No, la de paque.
No, the packet.
And why did you ask Nick to bring his pocket knife?
Porque la vez anterior que fuimos al río, a la hora de salir, no podíamos, no teníamos con qué cortar las sogas y tuvimos que arrastrar todas las balsas juntas y era muy pesado.
Because the last time we went to the river, we had all the inner tubes tied together and we couldn't cut the cords, so we had to pull them out of the river all together and bring them up to the place where we had to leave them.
So you wanted him to have the knife to help cut the cords at the end of the trip.
Y al principio también cuando amarramos todas las balsas.
And at the beginning too, it's useful to tie them up.
Why didn't you just bring your own pocket knife?
Yo no tengo.
I don't have one.
And who's the guy that tends to have a pocket knife in your group of friends?
Nick.
Nick.
Is he the handyman amongst your group of friends?
Sí.
Yes.
Is he? You said he had that pocket knife with him sometimes when he's come over to your house, right?
Sí.
Yes.
That day when you called him and asked him to bring the knife, were you worried about Nick Miu having a knife?
No razón ninguna.
No, there's no reason for that.
You've known him for a long time.
Sí.
Yes.
Seen him in your home, seen him in his home,
Sí.
Yes.
seen him at work with him.
Sí.
Yes.
Fair to say you've had opportunities to observe his character. Would you agree with that?
Sí.
Yes.
Would you agree Nick Miu has a character for peacefulness?
Sí.
Yes.
Were you worried at all about Nick Miu bringing a knife based upon what you knew about Nick?
Overruled. You can answer the question.
Repite la pregunta.
Repeat the question, please.
Were you worried at all about Nick Miu having a knife out on the river?
No.
No.
So now I'm going to ask you some more questions about the river, okay? Being on the river.
Sí.
Yes.
When you were on the river, was Nick there with his wife?
Sí.
Yes.
You see the picture there? I think it's 26. Sorry. 12A. Do you see that big photo?
Sí.
Yes.
Nick in that photo?
Sí.
Yes.
Nick's wearing a shirt and sunglasses in that photo. Is that what he looked like on July 30th?
Sí.
Yes.
Yes.
It's been marked as Exhibit 110. Do you see this picture? You see the picture?
Yeah.
Yeah.
And you see Nick is wearing a hat in this picture?
Sí.
Yes.
This picture, Nick doesn't have a, in 12A, he doesn't have a hat, but on 110, he does have a hat. Do you agree?
Sí.
Yes.
There are times that day that you saw Nick wearing a hat?
Sí.
Yes.
Were there times that day where you saw that Nick had taken the hat off?
Sí.
Yes.
Did you see Nick with some goggles and a snorkel?
Sí.
Yes.
Did you see him use that goggles and snorkel prior to Ariel losing his phone?
Sí.
Yes.
Would he use the snorkel to swim in the river?
Sí.
Yes.
When he used the snorkel to swim in the river, do you remember, was he wearing his hat?
No.
No.
Was he, when he had on his goggles and snorkel, was he wearing sunglasses?
Repite la pregunta.
Can you repeat the question?
When he went swimming in the river using the goggles and snorkel, did he also wear his sunglasses?
No.
No.
Was there a time when you were on the river that you saw, or that you came to learn Ariel had lost his phone?
Sí.
Yes.
When he lost his phone, did you guys stop and have a discussion?
No, really, en sí no paramos. Estuvimos conversando y él dijo que iba a buscar el teléfono.
We
Yo le
didn't
dije
really,
que se olvidara el teléfono, que se subiera a la balsa. Y él dijo, no, I go to find it. O sea, que lo voy a encontrar.
no, we didn't stop. We didn't stop. We continued. Then he said, I'm going to look for the phone. And I said, no, don't go. And then he said, I'm going to go look for it.
The he you're referring to is Nick Miu.
Correcto.
Did you eventually?
Correct.
Did you eventually see Nick go look for the phone with his goggles and snorkel?
Sí.
Yes.
Did you see him go in the same direction that the water was flowing?
Sí.
Yes.
Can we call that downriver?
Sí.
Yes.
Do you know why he went downriver to look for the phone?
Bueno, pienso que se fue río abajo porque el teléfono estaba como una bolsa de eso que se usan para proteger el agua.
I think that he went down the river because the telephone was inside a pouch, those bags that you use to put them in the water.
On Exhibit 12A, that photo, do you see some people have lanyards with, looks like maybe a phone inside of them?
Sí.
Yes.
You even see Ariel and Gilma right there, same?
Yeah.
Is that,
Yeah.
is that what you're describing?
Sí.
Yes.
Let's just slow down and wait for the interpretation.
I was going too fast. I'm going to slow down. When Nick then left to go look for the phone, were you watching him?
Sí.
Yes.
Did you look for the phone at all?
No.
No.
Were you sitting in the tube, standing near the tube, or doing something else?
Sentado.
Sitting down.
Did you eventually see Nick and another group of people or multiple people interacting in some way?
No.
No.
Did you eventually learn that Nick was interacting or people were interacting with Nick?
Sí.
Yes.
How did you learn that? From something you saw or from something you heard?
Su esposa dijo, Nick está en problema.
His wife said Nick is in trouble.
When you heard, did that surprise you?
Sí.
Yes.
You ever, you know Nick, you must.
Su esposa dijo, Nick está en problema.
His wife said Nick is in trouble.
When you heard, did that surprise you?
Sí.
Yes.
You ever, you know Nick, you must know his wife Sandy.
Sí.
Yes.
You guys must hang out together as a couple often, or as couples.
Sí.
Yes.
Had you ever heard Sandy express concern about the safety of her husband like she did on that day?
Overall,
¿En ese día? No entiendo la pregunta.
During that day, I don't understand the question.
Sure. When Sandy said Nick's in trouble, you took that as Sandy expressing concern for Nick's safety.
Sí.
Yes.
Had you ever prior to that day or any time before that, heard Sandy express concerns about her husband's safety when you were around?
Nunca.
Never.
It must have surprised you then on that day when you heard that.
Sí.
Yes.
What'd you do?
So I looking down where people was, and I saw Nick in the water, and I stand up and I try to get her.
When you saw Nick in the water, did he appear to be snorkeling and looking for the phone? Or was something else going on?
No, estaba en el agua y había mucha gente a su alrededor.
No, he was in the water and there were people around him.
How many people?
Número no puedo decirle, pero sí eran bastantes. Pueden haber sido más de 10, 15 personas. No, no.
I can't tell you the number, but there were many, maybe 10, 15. I don't know.
When you made that observation, were you worried for Nick's safety?
Sí.
Yes.
What did it look like that group of 10 or 15 people was doing to Nick?
So, estaban gritándole y cuando él estaba en el agua, alguien le estaba dando.
They were shouting at him. And when he was in the water, somebody was yelling at him.
Did you ever see anybody have physical contact with Nick?
Bueno, en el momento en que yo vi que él estaba en el agua, alguien le pegó.
When
Esa fue la primera vez que...
at that moment, when I saw Nick in the water, I saw somebody hitting him. That's the only thing I saw.
After you saw him in the water, did you keep watching?
So, yo traté de llegar hasta allá, pero en el medio del río perdí mis zapatos.
Well, I tried to get over there, but I lost my shoes in the middle of the river.
So on your way, were you able to continue to watch or did you need to tend to your footwear?
No. Estaba tratando de caminar, pero no podía. En son pares, miraba para el grupo, pero en otro momento no.
I tried to keep walking, but I couldn't. And I did watch the group at some point, but not always.
Did you see anybody being violent to or at Nick?
After when they was in the water, estuvo en el agua, no. Después que vi que estaba en el agua, no volví a ver nada.
After I saw him in the water, I didn't see anything else.
And it sounds like you don't know how he got down into the water. When you first looked, he was already in the water.
Correcto.
Correct.
At some point, did you see Nick walking back to you in the group?
Después que yo vi que él estaba parado, que yo le dije que viniera hacia esta parte de acá, él regresó.
After I saw him standing there, I told him to come back, and then he came back.
And so if we're on the river, you're Ernesto, and I'm standing where Nick is, roughly. Does that make sense?
Mm-hmm.
The river flows that way to downstream. Does that make sense?
Correcto.
Correct.
Guys, if I understand that Nick Miu may be testifying now. If he is, as soon as we're done with this witness, I'm going to cut out of this stream from Friday and hop over to today's stream of Nick testifying. I'll just cover that in this show. It's important enough to skip. In fact, I'll do that as soon as we're done with direct here.
And you see Nick walking somewhere in your direction, not exactly this angle, but somewhere towards you, correct?
Correcto.
Correct.
And what had happened is behind Nick by the time he's walking to you. Agreed?
Antes,
You mean before?
repite la pregunta, por favor.
Repeat the question, please.
After you saw Nick down in the water, eventually you see Nick coming back to you because you called him back.
Sí.
I want to
Yes.
ask you about that moment in time.
No entiendo la pregunta.
I don't understand your question.
I want to ask you about what you saw when Nick was walking back to you when you called him back.
Oh,
Does that make sense?
que yo le dije que regresara.
Did I tell him to come back?
I want to ask about that moment in time, what you saw.
Okay.
Okay. Okay.
When
Okay,
Nick's
okay.
walking back towards you, is he looking at you in the group or is he walking backwards looking behind him?
No estoy seguro.
I'm not sure.
You're looking in Nick's direction, correct?
Sí.
Yes.
When you look in that direction, do you see somebody else other than Nick approaching you in your group, or you focus your, do you see somebody else that draws your attention?
Sí.
Yes.
What do you see?
So, cuando el Ni venía por esta parte, hacia la izquierda mía, alguien trató de acercarse y me hizo así con el dedo.
When Nick was coming over on my left side, someone else tried to approach and pointed at me with the finger.
When you say the finger, that might have different connotations. So do you mean like a pointing finger or something else?
Dedo que no apuntaba.
Pointing with with the finger.
And when they're pointing with their finger, is Nick near you?
Iba pasando.
He was going by me.
By me.
So if I'm Nick in that scenario, Nick is walking this way, you're pointing in that direction.
Yo estoy mirando hacia donde está la persona y ahí tienen, stay there, stay there, stay there.
I'm looking at the person who was there and say, stay there, stay there.
Can you describe that person?
No tengo ni idea.
I have no idea.
Why were you telling that person, stay there, stay there, stay there?
Porque la persona que estaba apuntando hacia mí, o hacia mí, no sé si era hacia mí o hacia él, estaba yelling and he tried to walk.
Because the person
hacia
pointing,
mí.
because there was a person there pointing, I don't know if they were pointing at me or at Nick, but they were approaching.
Did you think it was safe for that person to come towards you and Nick?
Bueno, yo lo que traté de que esa persona no se acercara a nosotros porque quizás el problema iba a seguir si venían hacia el grupo nuestro.
I tried to prevent that person from approaching us because I thought maybe the problem was going to continue.
You thought the solution to that problem was to keep Nick separated from the group that was pointing at you.
Sí.
Yes.
When Nick, I'm going to now ask you about when Nick's back at the tubes with you after you pointed at this person, okay? Make sense?
Sí.
In that time, what did Nick look like?
Y se lucía muy preocupado y estaba como blanco.
He looked worried and he was pale.
I think there was a time you also used the word he looked white or he looked wide-eyed.
Sí.
Yes.
Did you see those things when you looked at Nick?
Sí.
Yes.
You said you've known Nick for a long time. He's your best friend. You ever seen him scared before?
Nunca.
Never.
Did he look like he was scared then?
Sí.
Yes.
Have you seen people when they're in shock before?
Sí.
Yes.
Did he look to you like he was in fear and in shock?
Sí.
Yes.
Were you worried about him?
Sí.
Yes.
And is that why you were pointing at other people because you wanted to protect your friend and keep him there because you were worried about him?
Sí.
Yes.
Would it be fair to say you didn't really know what had happened down there at that other group? You just didn't want anything more to happen?
No. Sí, sí, correcto, sí.
No,
No sabía
I mean,
qué había pasado.
I mean, yes, it's correct because I knew what had happened. I didn't know what had happened. So.
Right.
Did Nick stay then with the group at the tubes? Did he stay there that whole time?
Poorly phrased question.
Sí.
Did he ever ask you or make any motions to or indicate in any way, tell you in any way that he wanted to go onto the shore or on the woods or sit anywhere other than in his tube?
No.
No.
What did you see him do while you guys were waiting there?
Solamente se sentó en la balsa y más nada. Ni siquiera dijo una palabra.
He just sat in the inner tube and he didn't say anything. No words.
Did your impressions about him being in fear and shock, did that change over that time or did he continue to look like he was in fear and shock?
No, él seguía en shock.
No, he continued in shock.
How long did you guys in your group wait there at the tubes before you eventually floated back down the river?
Yo diría como 30 minutos o 35, no sé exactamente, pero fue un buen rato.
I would say 30 minutes, 35 minutes. I don't know exactly. It was a while.
Why did you eventually go back down, float down the river? Did anything prompt you?
So, yo no estoy seguro si fue la policía o alguien que estaba en el grupo donde estaba todo el mundo allá. Hicieron así para que como que la...
I don't know how much longer this has to go. I thought they were going to wrap it up. Let me see if I can find the Miu testimony. Okay, I found it. Let's hop over to Miu. Oh, there we go. All right, folks, let's take a look at this. Whoops, that's not what I wanted to do. Hold on. All right, so we've moved from Friday. We're now watching only a few minutes behind today's trial proceedings. About, looks like we're, just a few minutes behind today's proceedings. Watching the testimony of the defendant, Nicolae Miu, in this case. I'm surprised. I predicted yesterday he would not testify, but here we are. All right, everybody ready? Let's see what Nick has to say. Let me note my timestamp here. In his defense, he's almost certainly the last witness, so I would expect closing after this. Here we go.
All rise for the jury.
Yeah, sometimes the defense says you'll hear from the defendant, and then they change their mind. So they're not locked in just because they mentioned that in opening statement. You think he has an interpreter? He's going to testify in Romanian?
All right, please be seated. All right, thank you, members of the jury, for your patience. We are ready to resume. The state has rested its presentation of evidence. Now we'll turn to the defense and see if they have evidence to present. Mr. Nelson.
Judge, the defense calls Nick Miu.
Mr. Miu, please stand. Raise your right hand. The clerk will administer the oath.
Do you swear that the testimony you're about to give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Please have a seat in the witness chair.
All right, so a point I've wanted to address, and I've been putting it off to what seemed like the right moment, and now seems like the right moment. So when you look at the video and the credible testimony in this case of the actual fight on the river, I see very little that's helpful to the state to disprove self-defense beyond a reasonable doubt, which is the state's burden. A lot of people are focusing, and we skipped over this evidence so far, this testimony, are focusing on Miu's police interview and his apparent dissembling and lying to the police and throwing his knife away and all that kind of stuff, and saying, whoa, that undermines everything. That's what he'll get convicted on. Folks, that kind of conduct, consciousness of guilt conduct. So Miu dissembling to the police, apparently lying, pretending he didn't know anyone had been killed when he'd been informed he'd been charged with a homicide, throwing his knife into the woods, purportedly. All that kind of conduct is called consciousness of guilt conduct. It suggests that even the defendant believes that he's guilty. But it's most powerful to the state when the facts of the self-defense are ambiguous. So imagine there were no video. Imagine it was just Nick Miu's word against that of the 13 other people involved on the other side. So all we had to go on was the credibility of these two parties. Nick Miu on the one hand, 13 witnesses on the other hand. In that scenario, absent the video, the consciousness of guilt evidence is decisive because the jury will readily conclude they can't indulge believing this guy who lied to the police when asked what happened. That's not the same when we have the video. So, and the consciousness of guilt, that's not an element of self-defense. It doesn't inherently undermine a case of self-defense. It can do it in a way that circumstantial evidence can do it. It's circumstantial evidence, in effect, that you can't trust what the defendant is saying. So if all you have supporting self-defense is what the defendant is saying and you can't trust it, then the claim of self-defense becomes very vulnerable. But if you have other evidence consistent with self-defense, the damage that can be done by this kind of consciousness of guilt evidence is very minimal. So if you imagine, for example, that someone has, in fact, a perfect claim of self-defense, and afterwards they lie to the police about it, that doesn't mean they suddenly don't have a perfect claim of self-defense. Their claim of self-defense is as perfect as it ever was. There's lots of reasons people might lie to the police. In fact, this comes up very frequently in criminal prosecutions where, for example, another form of consciousness of guilt evidence is flight from the scene. Well, courts today in 2024 don't like to use flight as consciousness of guilt evidence because they've concluded there's lots of reasons people flee. People might flee because they have an outstanding warrant. People might flee because they don't trust the police. People might flee because they're someplace they're not supposed to be. Their wife doesn't know they're there. That doesn't go to them believing they did something wrong. So I think a lot of people are putting too much weight on this dissembling by the defendant to the police because that only matters if his underlying claim of self-defense is already inherently fragile. But if it's robust, as it certainly appears to be here, it's just odd behavior. It doesn't negate an otherwise robust claim of self-defense. He is, of course, going to have to explain now to the jury why he engaged in that dissembling.
Mr. Nelson.
You're the Nick Miu we've been talking about for the past 7 days.
Yes, sir.
Nick, I want to right away talk to you about exhibit number 104, if I could have the screen. You were on the Apple River on July 30th.
Yes.
I want to ask you about this exhibit, which says it's from frame 2592 at 149 into the video. Have you seen this before?
Yes.
Do you remember that time in your life when you were on the river in that position as shown in that photograph?
Yes.
Sometime after that, did something happen to you?
Yes.
Were you punched? And
Not,
attacked?
not before
Sometime
that.
after this, were you
After
punched?
that, yes.
Okay. I want to talk about the time between this and the time that you get punched, okay?
Okay.
Exhibit number 104 there is on the, with it. Where are you on that?
I'm standing in front of two ladies.
In which, if you were going to just describe the symbol on exhibit 104 symbolizing you, which one is that?
The one with the M.
Okay.
you
What
want
color?
Do you want the
Blue.
annotator?
At that point in time, you said there's two people in front of you. Who are those two people in front of you?
A blonde lady to my left and the red hair lady to my right.
Were there other, does this accurately reflect how you remember roughly people in general around you?
Yes.
The blonde lady in front and the other woman, you understand now that through the trial that the blonde woman is named Madison Cohen?
Yes.
Can we use her name when possible?
Yes.
And the you said red-haired woman, her name's Riley Madison. Can we use her name when possible?
Yes.
Possible? So when Riley and Madison are standing in front of you at that point, just before you get punched, right? What are they doing?
They're yelling at me. At one point, they were pointing downriver and saying, go, get away.
What are they doing with their hands?
They're touching me.
When you say touching you, is that something gentle?
No, they're pushing. Madison, she pushed against my left shoulder. She pushed against my chest. She was pointing her finger right at my face. She was yelling at me very close to my face. Riley had one of her arms, I believe it was left hand, on my right arm, squeezing and pushing me back.
And when you just gave that description, you put your hands distance apart. Can you show us that again? How far away were they?
About a foot.
Okay.
Less than a foot.
You've heard it described through trial as in your personal space. Would you agree with that?
Yes, right in my face, I would describe.
When that was happening, what did it sound like to you?
The volume was very, very high.
Let me ask you about how your body was responding in that moment when people are pushing you, poking at you, the volume is high. How's your heart? Could you tell us about what your heart rate was?
Oh, yeah. My heart rate was getting really high. My breathing was getting very high. I was...
How about your vision? Did you have normal vision in that moment?
No. At that moment, because of the situation, I was getting tunnel vision.
And can you describe what you mean by you say in tunnel vision?
I couldn't see peripheral vision, but I could see center and right before my eyes.
How about hearing? Could you hear the noises?
I could hear the volume very high, but I couldn't understand what they were saying. The noise became garbled. I mean, the sound became garbled.
Did you feel threatened at that point?
Yes.
Did you have your knife in your right hand?
Yes.
What did you do with your left hand? Tell us what you did with your left hand.
Yeah, with my left hand, I pushed her away from my face.
Can you show us what you did with your left hand? Why'd you do that?
She was very close to my face. She was in my personal space. She had been there for a while, and I felt threatened.
Did you intend to harm her in some way?
No.
Did you try to harm her in some way?
Absolutely not.
Do you know where, if at all, you had contact with her body when you raised your left hand in that manner?
No.
Do you think you had contact with her?
No.
Okay. I want to take us out of that space now for a second, okay, Nick?
Okay.
If I could have the screen again. You were here in court when we talked about, when we watched the video of you speaking with Brandy Hart, is that right?
Yes.
And I think you told her about your health condition. Can you just tell the jury now, what was your health like on July 30th of 2022?
It was very poor. Yeah.
Had you, I think you mentioned to her again, had quadruple bypass surgery before?
Yes, sir.
And when did you have that?
2020, about the same month. So about August.
Showing you here what's been marked as exhibit number 108. Can you tell us what those are pictures of, starting just on the left?
Yep, on the left, it's me right after the surgery, holding a red heart pillow against my surgery.
What was the purpose that you knew of for that red heart pillow?
That was to protect my surgery from hits, bumps.
Was that something that the hospital provided? It looks like there's like almost a picture of heart and lungs on there.
It is. The hospital provided that.
And then the picture in the middle, what is that?
My first walk, my new life.
Did it take you some time to recover and be as active and mobile as you were before?
Oh, yeah.
Do you think you ever reached the same level of mobility and fitness that you were prior to the quadruple bypass?
Never.
What's the picture of you on the right there? You can tell us.
My baby.
Okay. Is that a dog?
Yeah.
Is that dog important to you?
My angel.
Okay. And that's the cushions helping you to enjoy time with her, but still keeping your chest safe.
Yes, sir.
Okay. You've had other surgeries in the past, is that right?
Yes.
Did you have a hernia surgery?
2 hernia surgeries.
Have you had back surgery?
Yes.
And again, in general, would you consider your fitness on, if you were going to put it on a scale for July 30th, what would you consider your overall health and fitness on July 30th of 2022?
With my weight and very poor.
I want to ask you now about moving on to the Apple River on July 30th, okay?
Okay.
On that, this was a planned trip, is that right?
Yes.
Did you get a call from your friend Ernesto sometime before that trip?
Yes, sir.
What was that call about?
He wanted to remind me to bring my knife to cut string when we tie the tubes together.
Okay, when you say, do you have a pocket knife?
Yes.
Okay, can you tell us about that pocket knife?
I owned it for about 10 years. I have it a lot on me. I use it as basically a dual tool. I call it my Swiss Army knife, basically because I use it as a screwdriver. I cut insulation when I do electrical work. I use it pretty much everywhere.
Okay.
I'm an engineer. My tool.
Is it something that you've carried on your person, I don't want to say all the time, but somewhat routinely?
Yeah, when I knew I was going to work on something or need it for something, yes.
Okay. Now I want to skip ahead again now to the river, okay? At some point, did Ariel lose his phone?
Yes, he did.
Did you go to look for that phone?
I volunteered to go look for it.
When you went to go look for that phone, what were you wearing?
Before that?
Nope, right when you left your group to go look for that phone, what were you wearing?
So I took my goggles, my snorkel, and my swimming trunks.
Did you have anything on your feet?
Yes, I had on my feet, I had a pair of really, really torn up sandals.
Can I approach, Judge?
Yes.
Showing you what's been marked as Exhibit 113. Is this a packet of 9 photos of your sandals?
Yes.
You've seen those?
Yes.
Does that accurately show the condition of the sandals that you had?
Yes.
Can you just move to the admission of Exhibit 113?
Any objection?
I think I've seen them, so if I can take a look at it.
Yes.
Oh, pardon, never mind, Mr. Anderson.
All right, 113 is received.
These weren't taken by you, were they?
Pictures? No.
These were taken by the Sheriff's Department, correct?
Yes.
Permission to publish, Judge?
Yes.
Can I just, because we're going to go through the PowerPoint, can I?
Yeah, just pass them to the jury.
Can you use your words? I know we have a picture that better does it, but just briefly describe the condition of those sandals.
Horrible.
Okay.
They were just coming apart. I couldn't walk on them unless I tried to mend them.
Okay.
As you can see, I used leftover string to mend them.
When you left wearing those sandals and your shorts, did you have your pocket knife with you?
Yes.
Where was it?
In my right pocket, clipped to my.
Did you have that there pretty much all day?
Yes.
You were here when we watched the video of your interview with Brandy Hart, is that right?
Yes.
When you spoke with Brandy Hart, were you truthful to her about the knife?
No. I lied about the knife.
Was that your knife?
Yes, it is. It was.
Did you bring it with you when you went to go look for the phone?
Yes, I did.
When you went to go look for the phone, did you have any intent to harm anybody?
No.
Why'd you go leave your group?
To go look for the phone.
Okay. At some point, did you have some contact with a group of teenagers?
Yes.
And you were here in court when we saw the 9-second video, is that right?
Yes.
I want to show you just a couple of slides from that, if I could.
Oh, they should definitely play it. They should play everything.
Do you see those slides up there?
Yes.
Are those from that video?
Yes.
What are you doing in those 3 slides in general?
I was scanning the water, looking for the phone.
And are you in that position? Are you walking upriver or downriver?
Upriver, away from that group of boys.
Did you hear them say some things to you
Yes.
prior to your walking upriver and them? Did you hear those words that I have written on that slide?
Yes.
Prior to your hearing those words when you were walking upriver, had you had verbal contact with that group?
I think so. They asked me what I was looking for, and I told them I'm looking for a phone, a lost phone.
Did you ever tell them that you were looking for little girls?
No.
Were you looking for little girls?
Absolutely not. It's pathetic.
When you, at the end of this, when you watch the video, at the end of the video, where I'm not going to play it, but do you remember what you did right there at the end?
At the end, I was walking away.
Did you eventually turn around and face in the direction of the group that was yelling at you and calling you a raper?
Yes.
When you,
Yes.
Your Honor, we object. We object. He's coming across as way too reasonable. We don't like the way his testimony is going. We'd like you to order the witness to say something, maybe something racist. That would be helpful. Maybe something having to do with kids, little children. I mean, honestly, I can't imagine what the state's objecting to here, or what they think the judge is going to do on their behalf when the defendant's taking a witness stand. The judge is going to give incredible discretion to because cross is coming. The state's going to get their opportunity to cross. I'm sure that's what the judge is telling the state right now. You're going to have a unique opportunity here. How many times you get the defendant on the witness stand, state? You'll get your shot. Yeah, the dissembling to the cops afterwards does not fundamentally undermine the legitimacy of his claim of self-defense. I understand there's people in the comments who can't grasp that concept conceptually.
I'll sustain the objection. The question was leading.
That's
Please
it?
continue.
what did you do at the end of the video?
I was walking away.
At some point, did you ever become in a position where you were looking at that group of teenagers that had yelled at you?
Yes.
What did you see when you were looking at that group of teenagers after the end of this video?
I saw one of them holding a phone in a bag, and I believed it was what I was looking for. So I turned around and I started approaching them.
Why did you approach them?
I wanted to get a closer look at the phone to see if it was the one that that belonged to Ariel.
Did you eventually get near them?
Yes, I started walking, then I rushed the pace, stumbled, and fell on my knees, held on to their tube, at which point I lost my goggle and snorkel kit in the water.
You saw in the video, or excuse me, you saw during your interview with Brandy Hart that you said things different than what you just said now about what happened to your snorkel and goggles.
Mhm.
Is that right?
Yes.
Is your memory sometimes different than what you see in the video?
Yes.
Was your memory, in your memory, what happened to your goggles?
In my memory, the goggles got
knocked away?
Knocked away, yeah.
Objection leading.
So,
One second. When there's an objection, just wait on your answer. It is leading, sustained. Next question, please. It's a leading question. Let's move on.
Is your memory perfect?
Never.
Now that you've watched the video, do you realize that you were wrong about that?
Yes.
What happened to your goggles?
My goggles fell in the water.
When they fell in the water, what did you do?
I started looking for them, searching right where they fell.
Oops, it's on already. Showing you here some slides, 220, 225, and 279. Can you tell us what you're doing?
I'm searching for the goggle kit.
And where are you in relation to the 6 teenagers' tubes? Are you on the side? Are you upriver? Are you downriver? Are you in some other position?
I'm upriver. So, yeah.
I'm going to then show you another group of slides, 575, 600, and 625. What does that show you doing?
So what I did from that point, I went around the inner tubes to the other side, and I continued looking for the goggle and snorkel set.
Why did you walk around from the one side to get to the other side of the tubes?
Well, I thought that the water current would bring him over to the other side, and I was walking away from the boys at the same time.
Okay. During that time that you walked in that direction, did you have any physical contact with them?
No.
Were you confronting them?
No. Didn't say a word.
This next set of slides, what does this show you doing here?
I'm walking away from the group. Still,
go ahead.
Still looking for my goggles at that time.
When you were doing that, did you ever hear the kids say anything?
They gave me a warning.
What'd they say?
You got 10 seconds.
In response to that, what did you do?
I ignored them, and I actually continued doing what I was doing.
Okay. And show you the next set of slides here. Were you in a position to see here 963, 1140, and 1155, what the teenagers were doing behind you?
They were getting closer and closer to me. They were walking towards me.
Were you in a position to see that? Was that behind you, or had you turned around?
Well, I could hear their voices. I could hear that they were getting closer. At some point, I may have turned my head and witnessed that. They're coming towards me.
Showing you 1170, 1213, and 1284. What's happening here?
I'm at an angle to them, but I could say I have my back at them, still scanning the water, and they were right behind me. They got that close. Within seconds, they were right behind me.
At some point, did you see other people from another group?
Yes.
What did you see?
I saw what seemed to me at the time adults coming over from the other side of the river.
And when you saw adults coming over from the other side of the river, what did you do?
I walked towards them. I walked towards this. The first one was Madison.
When you walked towards Madison, where were the 6 teenage boys that had been yelling at you?
They're following me.
Okay. Were you in their path as you walked across the river towards Madison?
No.
Did they have as far as you know, did they have a clear path down the river if they wanted?
More than plenty.
Showing you this next group of photos. What's going on here?
So in this frame here, the first adult that came to me was Madison. She already had her finger pointing downriver and yelling at me and used some awkward words, ordering me to go down.
We see it looks like you're doing something with your right hand. Do you remember what are you doing with your right hand?
Yep, I was trying to explain to her what I'm looking for.
When you tried to explain to her what you were looking for, did you get the impression she was listening to you?
No, her voice was too loud to.
As to what Madison had as an impression.
Okay.
Hold on, wait a second. Sustained speculation.
I'm asking about his impression, so I'll rephrase. Did you get the impression that Madison Cohen was going to listen to your words?
No,
Why not?
because she was too loud. She never stopped to give me a chance to talk, and she kept pointing and ordering me to go downriver.
We've all heard the tape, but was she using polite language?
Polite? No.
Did you hear anyone saying anything behind you when you walked over to Madison Cohen?
Yes, they're all calling me names.
Showing you the next set of slides here, 1776, 1840, and 1824. What are you doing here in this set of slides?
I'm turning my back towards Madison and the rest of the people.
Why did you turn your back to Madison and the rest of the people?
It felt to me like I couldn't have a conversation with her at that point. She was not listening, and I didn't want to interact any further.
Had you at that point found your snorkel or goggles?
No.
Had you at that point found the phone?
No.
Did you hear anybody saying anything while you stood there with their back to them?
Oh, yeah.
What did you hear?
They were still yelling, he's looking for little girls.
Were you looking for little girls?
Absolutely not.
When you heard them, did you consider that to be a lie?
Objection, Your Honor. Leading.
Sustained.
I asked, did you consider that to be a lie? I don't.
Yes,
think
of
that's-
course.
Please.
Don't think that's legal.
I sustain the objection. Please move on.
When you heard that, did you consider it to be truthful or did you consider it to be untrue?
Untrue.
And when you heard someone say an untruth about you, did that change how you were feeling?
I felt frustrated. I felt annoyed. They kept saying it over and over, so it annoyed me and frustrated me.
And when you heard them say this untruth about you, did it appear to you as if the other group that had come over agreed with what these the teenagers were yelling about you?
Objection, leading.
Sustained.
Did you think anybody in the other group was going to help you or listen to you when you were being called these names and accused of being a pedophile?
Objection, leading.
Sustained.
How did you feel?
Well, I felt overwhelmed at that point. I felt still annoyed, frustrated. I felt like she wasn't listening. She was the adult I thought I was going to reason with or get help from. She obviously didn't even attempt to reprimand the children from yelling.
Showing you another slide here. Some 1838, 1846, and 1865. Is that you?
Yes.
What are you doing?
Judge, can we protest?
Yes.
Well, that wasn't leading. Is that you? What were you doing? I don't really understand what the state would be objecting to here. They just don't like the testimony? I mean, these are his personal observations. He's allowed to testify to that. I will get to Q&A after Nicolae's testimony, folks. I meant to do it after that last witness from Friday that we were covering, but jumped ahead to this. Closed caption unavailable. This is normal speed, by the way. I've been playing most of the trial at 1.25, but for the defendant's own testimony, I wanted it to be as true to delivery as possible. Bland is good. It's good when he's bland. You want him to be boring.
Just one moment.
Is judge going to instruct the jury? Maybe the judge will give us a hint what that was all about. He's been in prison for 21 months. In prison. He's been in jail for 21 months. They set his bail at $1 million. There's no bond option, so he had to come up with $1 million. Like most people, he didn't have $1 million hanging around. If you're asking if he's acquitted, does he get anything back for the 21 months? The answer is no.
Showing you photos 1838, 1846, 1865.
We're back to the
What are
photos.
you doing in those? Do you remember what you were doing?
Yeah, I had my back towards the group of people.
In the two photos there, which direction are you looking?
I'm looking downriver.
Okay. Are you looking at, there's two different groups, if I recall, from Exhibit 104. Is that right?
Yes,
One came from one side of the river and the other one's on the other side of the river.
correct.
Where are you, in the photo on the upper left, are you looking at one particular group as opposed to another group?
Yes, I'm looking at the boys group
And why are you looking at the boys group?
because they were yelling at me.
And what were they yelling at you?
They were yelling things that were not true and pointing at me.
When this, I want to, after that happened, showing you the next group of slides, 1875, 1883, and 1889. Do you remember what Madison did, if anything, to you?
Yeah.
What did she do?
She grabbed my right arm and she pulled me towards her, and I lost my balance, so I moved towards her.
Did you consider that in that circumstance to be a gentle or a gracious touch?
No, that was not a gracious touch. No, not at all.
Had she been using any gentle or gracious words with you?
Not that, no, not that I remember.
In those photos, can we see the footwear that you were wearing on that day?
Yep, those sandals that we saw earlier.
Did you have confidence in your footing in that area with those sandals?
Objection, leading.
Sustained.
How did you feel about your footing in that area?
Very unstable.
Want to show you the next set of slides here. Do you remember what you say to Madison after she pulled on your right arm?
Yeah, I told her not to touch me
And why did you tell her that?
because she pulled on me without my invitation.
Did you say that in any particular tone?
No, not in a mean tone, but I made it sound so she could hear me. Don't touch me.
Okay. Why didn't you want her to touch you?
I didn't give her permission to do so
Sure, but why did you not want to give her permission to do so?
because she was one track mind. She just wanted to get me away from that, point me down river and tell me to go there.
What's your comfort level at this point?
On a scale from 1 to 10, comfort level is very low.
Okay. Are you, if you had that same thing, a scale of like a fear scale, a 1 to 10 fear scale, right? And so with 10 being the most fearful you've ever been in your life, and 0, let's call 0 to 10 being the most safe you've ever felt.
Mm-hmm.
Where are you at here on a fear scale?
In that particular,
Yeah.
About 1.
Okay. So you're more uncomfortable, but not necessarily afraid. Is that what I understand?
Correct.
At where was your group in relation to you then?
was upriver.
And did you do anything in order, in relation to your group?
Yep.
What did you do?
I turned to them and I called them. I was trying to call them to come over and help me.
Are these slides, does this 2127, 2140, 2131, what does that show you doing?
I was waving at them and calling them to come over.
When you say you were calling them, did you do something physical or did you do something verbal or did you do both?
Physical.
Did you make any verbal comments at that point?
No.
Why not?
It was very loud. All around me was very loud. I don't think that anybody could have heard me at 100 and some feet away.
With everybody else yelling, did you think your yelling was going to de-escalate or escalate the situation?
When everybody's raising their voice, I don't think having another raised voice would help the situation.
After you raised your hand to call for your friends, did you see Madison Cohn doing anything?
Oh yeah, she was looking towards her group, and then she waved to them to come over to her.
Is that what we're seeing here in 2261, 2262, and 2263? What do you see?
Yep, she's calling her group over.
Did you remember when she called her group over, did her group respond?
Yes.
Did they join that?
Yes.
Showing you now these slides, is that what you saw? Her group over, did her group respond?
Yes.
Did they join that?
Yes.
Showing you now these slides, is that what you saw?
Yes.
I think we asked you questions before about Exhibit 104 with you with the blue dot and the other red dots. When you were, were you standing there? Were other people around you?
Yes.
When you were standing there in that moment with the other people around you after you've called your friends once, was that other group, did they appear to be afraid to you?
Afraid from me?
Afraid. Did they appear? When you look at them, do they look like they're in fear?
No, absolutely.
What does it look like to you?
They're all laughing and enjoying themselves.
At whose expense?
At my expense.
And
wait. Speculation as to what these other.
Sustained. Speculation as to what other people think. Next question.
How did you feel in that moment when they were around you saying those things? Did you think they wanted you to join in their laughter?
No.
Did you want to join in their laughter?
No, absolutely not.
If this fear scale is going, is it staying at 1 or is it moving in a particular direction?
It's creeping up.
Showing you another set of slides here, 2328, 2311, 2382. Do you remember, what do you remember about that?
I remember the young boys are yelling, pointing at me, saying things that are not true.
Were you able to see, like in this next slide, this 2429, 2440, 2401, were you able to see as you stood there what everybody was doing, and were you able to scan and see that?
For a brief second, yes.
Okay.
They were very close. They were really close to me. I could see and hear them.
How about your fear scale there? Where is it? Where is it?
About 2 or 3.
Okay. I see in the one on the right there, you have your hand someplace. Can you tell me what you're doing with your right hand?
Yes, I'm reaching for my pocket knife.
Why?
Because at one point my fear was getting really high, and
Okay.
I was getting ready to pull it out.
Okay. Do you remember, other than what you've talked about, Madison Cohen pulling you, which we saw, do you remember anybody else touching, pushing, grabbing you in any way?
The 2 ladies, yeah.
Showing you here what's 2472, 2478, 2481. Do you remember what's happening in those photos?
Yes. This one, the lady on my right side, she grabbed my arm and she was pushing against my arm.
And did that increase your level of comfort or increase your level of fear or something different?
So it decreased my level, the level of comfort, and increased my my fear.
Do you remember at some point, do you take your knife out of your pocket?
Yes, I do.
Do you know when that is in relation to these slides? Do you have a memory exactly of when that is?
Not exactly, but when they were pushing and poking at me, I remember I pulled it out then.
Okay. Do you remember, did you have it out before you were punched or after you were punched?
Before I was punched.
Okay. Showing you another set of slides here. It looks like do you remember doing something with your left hand?
Yeah, at that moment, I really needed my people to come over and help me. So I was trying to get their attention.
One more slide here. Do you, what's happening here in the slide?
Madison is pushing on my left shoulder and basically yelling at me right in my face.
And then on the next slide, we see something in your hand. Is that right?
That's a knife.
Why did you take out your knife at that point?
I was beginning to be afraid.
And what was it about that moment where everybody is that made you so fearful that you took out your knife?
I was surrounded. They were yelling. They had just pushed me. Well, the lady, they squeezed my arm. I mean, it seemed like they were not backing away.
Previously, you turned around. Is that right?
Yes.
Did you feel comfortable turning around in this situation?
No.
Why not?
They're too close to me.
What happened the last time that you turned around?
Nothing good.
Judge,
He wants you to say
Is this a
it.
place to break?
May as well be.
All right, it's 12 noon. Let's break for lunch. You'll be taken downstairs to the assembly room again. Please, no conversation about the case amongst yourselves or with anybody else. Do not conduct any independent research or investigation. And excuse me, do not use your devices to access any news report.
Well, this is one of the downsides of streaming the proceedings live. Now we're at the lunch break, and we won't be back before the lunch break. Darn it. All right, so what do you guys think? I think it comes across as very credible. There's nothing he's saying that's inconsistent with the objective video evidence. For example, in contrast with this notion that he viciously punched into the water Madison Cohen, zero objective evidence of that, zero evidence of any injury to her, zero evidence she went into the water. So I think he's doing a great job so far. The risk, of course, the risk is always the cross-examination. So the good news for the defense here is that the prosecutors don't seem very good. So maybe they'll muff the cross-examination. Always very dangerous. Very dangerous. And if you remember from the Kyle Rittenhouse case, I believe the cross was like 3.5 hours of cross-examination of Kyle Rittenhouse by Prosecutor Binger. Lunch is usually an hour. So, but we're a little bit behind in terms of the live stream. Let me see. We stopped right about here. We're about 14 minutes behind, so maybe in about 45 minutes we'll have lunch. I'm going to set a timer for 40 minutes. And I guess I'll go back to the previous testimony of Ernesto. All right, folks. So continuing with the Ernesto, break for lunch. Back to Ernesto. This is his friend Ernesto's testimony from last Friday, April 5th. Yeah, so it's worth keeping in mind before I actually jump back to Ernesto, what we're actually seeing here. Who is the initial physical aggressor in this confrontation? And if you're going to argue it's when he touched her tubes, there's an explanation consistent with innocence for that, right? He says basically he stumbled through the water and fell and put his hands on the tubes. And then he immediately walked away. So even if it was intended to be some kind of offensive touching and lost him the element of innocence as the initial aggressor, when he turns and walks away, he regains his innocence. There's no innocent explanation for the battery being committed on him by Madison Cohen and Riley Mattison. That's intentional, offensive, unwanted touching. So he doesn't do anything until he's been subject to a battery by multiple people, backed up by other people. The 6 teenagers, the 17-year-old football players are still there with feet away, shouting, pointing, calling him a pedophile. Madison Cohen is waving over adult men from her group to come join her, obviously antagonistic to the defendant. And that initial aggression, the physical aggression, and the threatening is implicit in the combination of the the shouting in his face, the pointing and the pushing and shoving and grabbing. They're the initial aggressors in this confrontation, not the defendant. So if the element of innocence, up to 5 elements of self-defense, right? Innocence, imminence, proportionality, avoidance, and reasonableness. Technically, Wisconsin is a stand your ground state. It's a soft stand your ground state. So let's walk through it. Innocence, imminence, proportionality, avoidance, and reasonableness. What do we have so far? Well, innocence, who was the initial physical aggressor? Unless we're going with the defendant when he touched their tubes in the 9-second video, which I think is ridiculous because he has an explanation consistent with innocence for that basically he tripped and fell on the tubes. Plus, then he gets up and turns around and walks away. So even if you were to characterize that as some initial aggression on his point, that ends. That ends when he turns around and walks away. He's regained innocence. The next physical confrontation is not initiated by him. It's initiated by Madison Cohen and Riley Mattison, pushing, pulling, squeezing, and shouting at him with profanity in his face, in his space, pointing him away from his own group, while they're backed up by those 6 howling teenagers, high school football players, pointing at him, shouting, laughing, smiling, calling him a pedophile. And Madison Cohen is waving over adult men from her group to join her, clearly going to be antagonistic and are ultimately physically antagonistic to this defendant. That's the initial aggression in this fight. That's not resolved. The Madison group and the teenagers, they don't walk away before defensive force is required, before they're punching this defendant. So the first physical contact, aggressive, offensive physical contact, the battery by Madison Cohen and Riley Mattison. So innocence is on this defendant's side. In 2 forms, both in the non-deadly force sense, when they're committing simple batteries on him, and he says he raises his hand to push her, Madison Cohen, out of his space, which of course he would be privileged to do. Even if he did punch her, you're privileged to use non-deadly defensive force to stop an unlawful battery on your person. It wasn't a sustained beating. So even if he punched her, he'd be legally privileged to do that. And that's when the other side escalates what was merely a non-deadly force fight into a deadly force fight. Now suddenly he's got multiple attackers, adult men, punching him into the water, pushing on his back to hold him down into the water, hitting him again while he's down in the water. 10 inches of water, but when you're face down, how many inches do you need to drown? Quadruple bypass surgery patient. Does it matter that the people attacking him don't know that? No, the defender knows it. He knows he's exceptionally vulnerable to injury. He knows that he doesn't have the strength, endurance, fighting ability that he might otherwise appear to have because of his impaired physical condition. He can take all of that into consideration in defending himself. So they've escalated what was a non-deadly force fight into a deadly force fight. So even if you blame the whole start of everything on the punch, the supposed punch of the defendant by against Madison Cohen, and pretend that her battery and Riley Mattison's battery never occurred, even if you pretend that it was the defendant's punch that was the first unlawful use of force here, it's still non-deadly in nature. And they responded with force reasonably perceived as threatening imminent death or serious bodily injury. They've started a new fight in which they are the unlawful deadly force aggressors. So, 5 elements: innocence, imminence, proportionality, avoidance, and reasonable. Innocence for the defense. Imminence, that simply means that what you're defending yourself against isn't some past threat or some speculative future threat. It's a threat immediately about to happen or actually taking place. Is the attack on the defendant actually taking place when he brings that knife to bear? Obviously, it is. Innocence, imminence. So now imminence is on his side. Proportionality. I already addressed this. Deadly force attack upon him. He can respond with deadly force in self-defense. Avoidance. Wisconsin is technically a stand your ground state, so there is no legal duty to retreat before you can otherwise lawfully defend yourself. It is a soft stand your ground state, so that opens a door to the prosecutor saying, hey, there's no legal duty, but a reasonable person would have done it. But he had no opportunity for retreat when he brought that knife to bear. He's already under attack by multiple aggressors. More are coming in all the time, putting hands on him. He's not safely retreating in those broken sandals. A quadruple bypass 52-year-old running where? Away from the safety of his own group, further downriver, pursued by a pack of 6 high school football players and other young men, young adults. So avoidance in favor of the defendant. So we have innocence, imminence, proportionality, avoidance in favor of the defense here, in support of self-defense. Keep in mind, this is in the context where the burden of proof is on the state to disprove self-defense beyond any reasonable doubt. And finally, we have reasonableness. The defendant had to have a genuine, subjective, good faith belief to act in self-defense, as he did. Usually in these kinds of cases, this is implicit. I mean, we don't have mind reading machines, so we have to base it on the testimony and conduct of the defendant. He's providing that here. And that subjective belief has to be objectively unreasonable. In other words, would a hypothetical, reasonable and prudent 52-year-old quadruple bypass, overweight, out of shape, mechanical engineer with a reputation for peacefulness, dealing with this group of screaming, pedophile shouting high school football players, plus the adult males from the second group, plus the screeching, howling Madison Cohen and Riley Madison, would a person in that circumstance have reasonably perceived, punched, shoved in the water, hit again while down in the water, hit again while down in the water, have reasonably perceived that they were facing an imminent threat of death or serious bodily injury? Was the fight de-escalating before he went to the knife? Did he chase people down to stab them? Nope. Nope. I suggest to you that anybody in this defendant's position could have had that reasonable perception of an imminent fear of deadly force, death or serious bodily injury. Those are all five factors, folks. And to my mind, they're unambiguously in favor of the state, of the defense, where the burden of proof is on the defense to disprove any one of those beyond a reasonable doubt. Which one is subject to disproof beyond a reasonable doubt? Where's the argument? That he lied to the police after the fact? That doesn't undermine an otherwise meritorious claim of self-defense. Now, if the claim of self-defense were more ambiguous, if we didn't have the video, if all we had was this defendant's word, yeah, then lying to the police afterwards would be a serious problem, because it would suggest we can't credibly rely on the defendant's word. But we're not stuck with the defendant's word here. We have the videos. So, with that little impromptu bit of analysis. Of course, there's more to come. You know, the defendant's on the stand. He's going to be subject to cross. Maybe he'll implode on the witness stand. We'll have to see. But so far, that's where I'm at. All right. Bring back Ernesto. Summon Ernesto. Here we are from Friday.
El tráfico siguiera, la gente siguiera bajando.
I don't know
Y
if
ahí
it
todo el
was.
mundo empezó a bajar.
Maybe the interpreter needs the witness to repeat this answer.
Ok, no estoy seguro si fue la policía o alguien que estaba parado donde sucedió el problema. Hicieron así como que para que la gente ya podía seguir.
I don't know. I'm not sure if it was the police or if it was something else, somebody else who was trying to guide people, and they were telling people to move, and to continue.
And based upon what you saw, then you kind of helped your group say, we got to go, and you moved down the river.
Correcto.
Correct.
During the float down the river, it continued to be quiet.
Completamente. Que yo recuerde, nadie habló hasta que llegamos a la salida.
Totally quiet. As far as I remember, nobody talked until we got to the exit.
What happened at the exit?
Solo recuerdo que cuando llegamos a la salida, creo que había, no sé si era un policía vestido de verde o alguien que estaba cortando la soga de la balsa.
When we got to the exit, I don't know if it was a policeman who was there. Somebody was cutting the ropes.
Pasamos el puente.
Then we crossed, we passed the bridge.
Cuando íbamos pasando allí vimos que habían policías.
When we passed the bridge, we noticed there were policemen there.
Y cuando íbamos pasando, ellos estaban como aquí así. Íbamos pasando por aquí.
They
Vieron el grupo de nosotros.
They were over here, and we were on the other over here. And then they approached the group of where we were.
And when they approached the group, did you see them somehow indicate or say something to Nick?
¿Quién?
Who?
¿Los policías?
The policemen?
Bueno, en el momento que nos pararon ahí, yo no sé porque eran muchos policías que estaban ahí, pero después de eso yo vi que vino un policía y le dijo, tiene que venir con nosotros.
Right at that moment when they stopped us, I don't know if they were policemen or not, but then one of them came and he said he has to come with us.
The policeman asked Nick to come with them.
Mm-hmm.
Is that a yes?
Sí.
Yes.
Did you then see Nick go with the police?
Sí.
Yes.
Caminó normal.
He was walking normally with them.
Were you surprised at that point?
Sí, nosotros estábamos en shock. ¿Por qué lo detenían a él? Porque realmente nosotros no sabíamos qué había pasado.
Yes, we were in shock because we didn't know why they were detaining him. We didn't know what had happened.
And you couldn't believe your friend who's peaceful would have done anything to harm someone.
Nunca.
Never.
That's all.
Mr. Anderson, do you have any questions?
You've tubed on the Apple River several times, including with Nick, right?
Nosotros sí, pero con él la segunda vez.
We have, but it was the second time with him.
And the Apple River, it's kind of a party scene, agreed? The Apple River, it's kind of a party scene. Lots of people on the river drink.
Sí.
Yes.
Your group was drinking.
Sí.
Yes.
Probably most of the groups you saw on the river were drinking.
Sí.
Yes.
Were you intoxicated?
No.
No.
How many drinks did you have? Do you know?
Probably like 4 beer.
Probably like 4 beer.
And you said you told
More
Nick
honest
not
than
to
the
go look
teenagers.
for the phone, but he insisted, right?
Correcto.
Correct.
And Ariel wasn't worried about his phone because he had insurance, right?
Correcto.
Correct.
And after Sandy said Nick's in trouble, you started walking towards Nick, right?
Correcto.
Correct.
And you got pretty close to where Nick was, right?
No.
No.
You got a lot closer than Sergio did, right?
No sé, porque en ese momento yo no sé dónde estuvo Sergio.
No,
Pero sí no estaba cerca.
I don't know because I don't know where Sergio was at that moment, but yes, I was close.
And you saw Nick in the water, you said, right?
Sí.
Yes.
You never saw Nick do anything to anyone?
No.
No.
You said you were concerned for Nick's safety, right?
Correcto.
Correct.
You walked over there, right?
Sí.
Yes.
And you told police, I didn't see, we don't know what happened because Nick didn't tell us anything, right?
Correcto.
Correct.
And you said that multiple times.
Correcto.
Correct.
You told police multiple times that Nick ran away.
Bueno, en lo que se refiere a usted huyendo, corriendo, me refiero a cuando él salió del grupo y vino hacia este lado, para nosotros.
When you're referring to running or running away, I'm referring to when he left that group and approached our group.
When he
on this side.
When he went back to your group, you said he ran back to your group, right?
Correcto.
Correct.
You told that to police multiple times.
Correcto.
Correct.
So you remember him running back to your group.
O sea, no diría yo corriendo, simplemente venía hacia el grupo, caminando a prisa, pero no, I don't know. Venía de regreso hacia el grupo.
I mean, he didn't come running. He was walking fast. He was just coming back.
He actually just walked casually back,
Objection.
right?
What's the objection?
Well, first of all, it's leading.
Overruled. He can answer if he understands.
Or no, we're back to
No entiendo la pregunta.
No, I don't understand the question.
I hate it when they go out of order.
He wasn't walking fast back to your group, was he?
Él no iba caminando.
Él venía caminando.
He was walking.
But not quickly, right?
No, no.
No, no.
And then after he walked past you, you told police the groups were fighting each other.
Bueno, yo no puedo decir exactamente si estaban peleando, simplemente como estaba todo el mundo gritando y eso, no sabemos exactamente lo que estaba pasando allí.
I couldn't say they were fighting. Everybody was shouting. We didn't know what was happening there.
But what you told police was that the groups were fighting each other after Nicolae left.
No recuerdo en este momento, pero puede, desde mi punto de vista, a ver las discusiones que tenían allí, puede ser que yo pensé, o puede ser que estaban peleando, o puede ser que no.
I don't remember right now, but in my opinion, because of the way they were talking and they were loud, they may have been fighting.
You didn't see any injuries on Nick when he walked back, right?
No.
No.
And your group stayed at the sandbar for a while because Eric was helping with the victims, right?
No sé.
I don't know.
Was Nick helping with the victims? Was Eric helping with the injured?
No sé.
I don't know.
Eventually, when you did leave, it was because Nick said, let's go, right?
Repite la pregunta.
Can you repeat the question?
Eventually, when you did leave, it was because Nicolae Miu said, let's go.
No.
No.
When you got to the exit, there was a lot of police there, you said, right?
Sí.
Yes.
There wasn't any belligerent people approaching you or anything like that?
No podría decirle si personas cercanas o no, simplemente cuando va saliendo del río sabe que van personas adelante y van personas detrás. No sé a qué se refiere.
I couldn't tell you if there were people approaching us or getting closer to us. There were people in front. There were people behind us. I don't know what you're referring to.
You didn't get threatened or anything when you got out to the exit, right?
No.
No.
When Nick came back to your group, he told you they took my knife, right?
I don't remember.
You told
I don't
police.
remember.
You told police multiple times they took Nick's knife out of his pocket, right?
Si se lo dije a la policía, está, pero no recuerdo.
If he gave it to the policeman, I don't know. Interpreter needs to correct. If I told that to the policeman, maybe, but I don't remember.
You don't remember if Nick told you they took my knife?
I don't remember exactly. She tell me something.
So Nick
And I
was,
don't remember where because when we sit down in the tour, we not talking nothing.
Didn't bother translating that.
you saw Nick among the group of people when you were walking up, right?
Correcto.
Correct.
You could see how the group was acting. You could hear them, right?
Sí, estaban gritando toda la gente. Yelling people.
Yes, they were yelling.
And when police talked to you about it, you didn't believe Nick stabbed anyone, right?
Nunca.
Never.
And you said, he's a big guy. He was in the army. He doesn't need a knife to defend himself, right?
Sí.
Yes.
And he was in the army in Romania before coming to the US, right?
I'm not sure, o sea, no estoy seguro, pero si dije eso porque en los países comunistas el servicio militar es mandatorio. So, él vive en un país comunista, yo vivo en un país comunista, al servicio nos mandan obligados.
I'm not sure if I said that, but I know that he comes from a communist country and the military service is mandatory. I come from a communist country too, where you have the mandatory military service.
And you answered questions about Nick had his knife because he used it to cut ropes. He was going to use it at the beginning and going to use it at the end. Do you remember that?
Correcto.
Correct.
But you told police that you thought Nicolae put his knife back in the vehicle before floating down the river, right?
Correcto.
Correct.
And you also told police you never saw Nicolae with a knife on the river, right?
No. Bueno, cuando hablamos del río, solamente lo vi con la navaja al principio cuando se amarraron todos los tubos.
No, well, when we were in the river, I only saw him with the knife at the beginning when we were tying the tubes.
When Nicolae got back to the tubes after he walked past you, did you walk back to the tubes?
I'm sorry, please interpret repetition.
Nicolae walked past you, going back to the tubes, right?
¿Sí?
Yes.
And he didn't say anything to you then.
I don't remember because I pay attention to the guy punch us and I say, stay there, stay there. I don't want it coming to us.
Nicolae didn't ask for your help or anything?
¿Ayuda cuándo?
Help when?
Ever. He never yelled for help, right?
Yo no vi nada hasta que la señora me dijo que estaba en problema.
I didn't see anything until the lady told me that he was in trouble.
You also didn't hear him yell anything, right?
No.
No.
When Nicolae got back to the tubes, did you walk back to the tubes too?
Sí.
Yes.
No one followed you, right?
No, en el momento que él pasó al lado mío que iba para la balsa, yo estuve quizás unos segundos parado ahí con la persona que me estaba apuntando y yo le decía, stay there, stay there, stay there. Después de eso, yo me regresé a la balsa.
When Nick, he was walking by me on this side, I stayed standing there and I told the guy who was approaching us, stay there and pointing. And then I followed Nick.
you didn't answer my question. I asked, when you walked away, nobody followed you, right?
Que yo recuerde, no.
As far as I remember, no.
Si estoy
This
de
is
espalda,
not
no puedo
helpful
ver.
to the state.
If I'm walking, I can't see from my back. I can see in the back.
And once Nicolae got back to the tubes, he put on his shirt, right?
Correcto.
Correct.
It got a little confusing because they were switching things around, but I believe this is one of the defense witnesses that was brought in on Friday before the state closed. So this is the state on cross-examination of a defense witness. Ernesto, the defendant's good friend and work colleague.
And you didn't see what happened before Nick, you saw Nick in the water, right?
No.
No.
So you don't know if he did something violent before you saw him in the water?
No.
No.
We have the video.
You said Nick appeared very scared, worried after he walked back, right?
Sí, es normal.
Yes, it's normal.
And you'd never seen him scared like that before, right?
Nunca.
Never.
And he wasn't smiling, right?
Like the boys.
¿Cómo?
He wasn't
What do you mean?
smiling.
No.
No.
That would be, you wouldn't expect him to be smiling if he was afraid, right?
¿Quién se va a reír en medio de un problema?
Who's going to smile when you're in the middle of trouble?
Who's smiling though?
I wanna
The
show you some
teenagers were
slaps
smiling,
and
weren't
frames.
they?
Why don't we break here for lunch, since there seems to be more questions? Members of the jury, we're going to break until 1 o'clock. Same reminders, no independent investigation, no research. Do not speak with anyone, including yourselves, about this case. We will resume at 1 p.m.
I'm keeping an eye on the live stream from court. They're still on the lunch break. They're going over. They're displaying his interview with Lieutenant Brandy Hart. Brandy, another stripper name, Brandie. Brandy. Ponytail and a baseball cap. All right, let's fast forward here. See when Ernesto comes back. Oops. Here we are.
Long way to go to that point. We don't know if eventually some lesser amounts of and we about for campground can be feelings,
Well,
but that wasn't her son.
I thought I was closer.
Defense attorney Corey, attorney out of in the along accomplished located and here, but again, we're just, as I mentioned, to welcome back the approaching about 124 County Circuit. Thank you so much.
Okay.
Please be seated.
You know what? Before we do that, I've been remiss in mentioning the sponsor of today's content, which is none other than Law of Self-Defense itself, our upcoming Law of Self-Defense Advanced course. This is our full-day class on everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. If Nicolae Miu had taken this class and done what I advise, he would not be at risk of life in prison. He almost certainly would never have been in this fight in the first place. He certainly wouldn't have been dissembling to law enforcement in an interrogation room. This class is taught live by me, streamed to you using Zoom on Saturday, April 20th. We only teach this class twice a year, folks. Twice a year. If you miss this April 20th class, it'll be October before, at the earliest, before we do it again. lawofselfdefense.com/advanced for our advanced class. And we're currently in the, this is the last week of the early registration period. So you can still get 50% off your registration. Don't miss it, folks. You don't know when you'll be attacked. Nicolae Miu didn't know he was going to have a bad day when he started floating down the Apple River the morning of July 30th, 2022. But in fact, that's what happened. So, lawofselfdefense.com/advanced. Keep it in mind. And it looks like we might be back.
Can I just have a brief moment?
Yes.
I'll rewind it a little bit here.
Discuss state
Courtroom in
partway
Hudson,
through. My judicial assistant told me to stop reading and that the state no longer intends to use it.
That's correct.
So, is there anything else to discuss?
Can I just have a brief moment?
Yes.
Oh, interesting. It looks like because the defendant took the witness stand, it looked like the state was preparing some evidence to submit to the judge to impeach the defendant. The judge started reading it over the lunch break so he could make a decision about whether to admit it or not. And then the state changed their mind. Interesting. All right, here we go. Whoops. Note to self, get my timestamp for my records. Pretty good timing. We paused for lunch for Ernesto, just in time to come back from lunch for Nicolae Miu.
They
come
can begin
on.
repairing. They can begin repairing what he told the investigator.
All right, so I guess we're not back yet. That was deceptive. You know what? I'll take a look at Q&A. How about that? Whoops, I don't want this guy displayed while I'm doing that. Let's see. Bum, 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 bum. First, of course, the Law of Self-Defense members get their questions answered first. And for free. Law of Self-Defense members putting their questions in the member chat, where we're also live streaming this, get their questions answered for free. Become a member for 99 cents. 2-week trial membership, lawofselfdefense.com/trial. After the 2-week trial, it's still dirt cheap, only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member at lawofselfdefense.com/trial. Or if you'd like to put a question or comment into a super chat, that's fine too, but it needs to be a $10 super chat on YouTube. I don't recommend that. I recommend you become a Law of Self-Defense member. Don't pay $10 a question. Pay $10 a month to get all your questions, but that's up to you. Let's see. Law of Self-Defense member Kyle says folding knives are just pre-broken. Yeah. I prefer fixed blade knives, but they're a little more awkward to carry around. Let's see. TSA is weird about what they confiscate. They'll certainly confiscate a folding knife. So I personally have a fondness for Kershaw folding knives. They're good utility knives. There's nothing fancy about them. And most importantly, they're inexpensive. I think they're 35 or 40 bucks. I just buy them like 5 or 10 at a time. And many times I get to the airport, I forget I have it clipped to my pocket. For 35 bucks, I don't feel too bad throwing it in the garbage. I have more waiting for me at home when I get back. But if I was carrying a really nice $200 folding knife, I'd have a dilemma about whether to get on that flight or save the knife. Let's see. Yeah, I'm surprised that the defendant is testifying, but he's doing pretty well. Comes across as pretty reasonable. And of course, defense counsel would know him a lot better than I do, which is not at all. I'm nervous looking over at the questions, and I can't see when he's coming back. So it's a little hard for me to monitor both. If any of you see him come back in real time, feel free to let me know in the comments. And I would expect this to be the last witness the defense has, is their own client. Usually that's, you want to end right there. And then the jury will go into deliberations. I'll keep covering the trial proceedings. I'll probably skip around a little bit to try to get the sweet spots rather than continue to do it sequentially. Let's see. Hey, Will Parker says his new GSA, that would be a BMW R1250 GS Adventure. His new GSA was dropped off this morning to get the Michelin Road 6s on it. Those are the tires. Those are tires. Those are the tires I put on my own BMW R1250 GS Adventure. They are great road tires. They are very confidence-inspiring on asphalt or cement. And they're not too bad on like fire roads and stuff like that. I wouldn't take them in mud. I mean, they're not knobbies for sure, but for road touring, they're fantastic. I love those Michelin Road 6s. Will and I are taking a motorcycle trip together. He's gonna come down. He's picking up a new trailer from my local town where we have a big trailer manufacturer, and he's gonna spend a few days. We're gonna ride around Colorado. I'll show Will some of the Rocky Mountains from Denver out to Durango, up to Glenwood Springs, and then back to Denver. So do a big loop like that. It'll be a great trip. I've done that trip many, many, many times. I'm sure Will have a great time. Fantastic roads, some of the very best in the world. Not Cupcake says, I don't own a gun. I'm here to support your great coverage and analysis. I love to learn and learn most from you. Yeah, I noticed that somebody had commented a while back, hey, why don't you do gun self-defense? Sorry, why don't you do knife self-defense? Folks, it's all the same self-defense. So my instruction on use of force law is not determined by whatever particular tool or method you use to defend yourself. The law doesn't really care. To be honest, the law cares a lot about whether you're defending yourself with non-deadly force or deadly force, those two buckets. But like if you're in the deadly force bucket, the law doesn't care if you used a gun or a knife or you dropped the piano on someone's head from a great height. It cares if you were privileged to use deadly force. But if you are, the precise method doesn't really matter. Doesn't make any difference to the legal analysis. Let's see. Yeah, some airports I go to, they do have envelopes at TSA where, in theory, if you discover you have something that they're not going to allow on, you can drop it in the envelope and mail it to yourself for a modest fee. I don't see that everywhere, though. Yep, unfortunately, you should be very careful interacting with police around any circumstances in which a crime's been committed, and especially if they come to you and want to ask you questions. All right, let me see. That was the member chat. I think I got it all. Yeah, it would be an interesting line of questioning. Somebody mentioned this here in the chat. Let me go back and see if I can find it now. Madison Cohen testified, but apparently she was not streamed. I don't even know if she was in trial or if she testified virtually. Testifying virtually is not that unusual these days. But she was not streamed because she's deemed a witness and therefore has certain privileges that she's termed a victim and therefore has certain privileges that a non-victim witness would not have about testifying in open court. Let's see. Oh, not back yet. I can't find the comment now, but someone was saying, hey, this guy's from Romania, communist country, as we know, fairly corrupt. And maybe when you grow up in Romania, you learn to not trust the police. You know, there's a lot of criminal defendants in America who lie to the police, and it's not much held against them because we simply accept that if you come from certain demographic groups in America, you don't have a good relationship with police. And that should not be held against you, therefore, if you lie to them, because the police are arguably out to get you because of racism. Still earlier today. But so that would be an interesting line of question for the defense. Hey, when you were in Romania, any experience with police? Police have a particular reputation there? Might have colored your interaction with police here? Let's see. Yeah, those GSAs, those BMW GS Adventures, they make great touring motorcycles, especially if you're taller, if you're 6 foot or above. If I was average height, if I was like 5'10", I'd be riding, almost certainly at this point, I'd be riding a BMW 1250 RT. I think it's the RT, right? Let me just make sure I'm looking at the right picture. Oh, come on. Of course, I gotta. Yeah, the RT. That's their classic touring motorcycle. Yeah, I'll pull it up. Why not? There it is. It's a beautiful motorcycle, great for touring. It's a little tight in the legs for me, which is why I use the Adventure instead. But this is basically, let's see. I thought I had it here. This is basically my bike here. I have a different color scheme, but no, that's not the Adventure. That's the Trophy. It said it was the Adventure. Is it the Adventure Trophy? I guess. I don't know. Yep, great bike. Ooh, not inexpensive though, as we can see there. All right. Bavarian money waster. It's not a money waster. It's a great motorcycle. Dan asks, Andrew, what's your opinion on defendants testifying in their own trials? Would you recommend it considering the potential risks? Well, it's really a call you have to make on a case-by-case basis. For the vast majority of defendants, it's a terrible idea. You have to remember that most criminal defendants are criminals. They got a lot of arrests, a lot of convictions, that they're probably guilty of what they're being tried for. So those guys you can't put on the witness stand because they'll be impeached by all their prior crimes. So generally, you just, as a practical matter, you just can't do it. Plus, a lot of criminals are stupid. A lot of criminal defendants are stupid. You put them on the stand and they're going to say stupid stuff that's harmful to their defense. So as a practical matter, you generally can't put the traditional criminal defendant on the stand. Is it different in a good guy case of self-defense? You know, someone like this guy, Nicolae Miu, who's never been in trouble with the law a day in his life. It's better. You don't have to worry about that impeachment. Kyle Rittenhouse, right, took the witness stand. Never been in trouble with the law a day in his life. I think apart maybe from some tickets or something. But it's always perilous. I mean, for one thing, it's very stressful. For most people, it's stressful just being a witness. We've heard several of the witnesses in this trial testify about that. They're nervous. It's normal to be nervous to take the witness stand. Everyone's looking at you. It's a very formal setting in court. You don't want to do anything wrong. You don't really know the social rules or the process that's supposed to be followed. You don't want to make any mistakes. So imagine being the defendant, the person who's actually at risk of legal consequences if you screw it up. Very, very stressful. So, and do people tend to perform better under stress or worse under stress? Mostly worse under stress. And the prosecutor is going to be taunting and goading and insulting. Many of you saw the cross-examination of Kyle Rittenhouse for 3.5 hours. He was being taunted by Prosecutor Binger, trying to break him on the stand, get some kind of outburst out of him. Didn't work. 17-year-old or thereabouts, Kyle Rittenhouse did a great job on the stand. under cross-examination. But you don't know that ahead of time. And the prosecutor knows exactly what words he's trying to get out of you that he wants to include in his closing statement, closing argument at the end of the trial. You don't know what those words are. That's what the prosecutor is fishing for. Anytime prosecution or defense is interrogating a witness, one of the things they're doing, one of the most important things they're doing, is they're fishing for specific words and statements they know already they want to have available to build into their closing argument at the end of the trial. The defendant on the witness stand doesn't know what those words are. So it's, and we saw this when Binger cross-examined Rittenhouse. He kept asking the same question in slightly different forms to try to elicit those specific words he was looking for. And they come out of your mouth. You don't even know you've damaged yourself, but maybe you've crushed yourself. All right, now it looks like we're coming back for reals this time. Let me get it back. Okay, not that. Where is it? This. All right. Make a timestamp for myself. And here we go. Hopefully this is it.
Mr. Nelson.
Thank you. Can I have the screen?
Yep, we're back.
Mr. Miu, when we finished, I think we were getting to the chronological space that we had begun the morning on. And so I want to start from there again and then move forward from there. Does that make sense?
Yes.
When I had asked you before, you talked about how you felt, but since that time, you've told the jury that you had this fear scale. Okay?
Mm-hmm.
So I want to ask you about, at this time, what we see here, what you've previously described the scene, right?
Mm-hmm.
How were you feeling on the fear scale?
About a 6, 7.
Okay. And at some point, I think you told them before, but just so we can put it into the context here, did you do something in response to something that was done to you when you're standing there in this moment?
Yes. After I was pushed and both sides, I would say, squeezed, I was afraid, so I pulled out my knife.
Okay. Did you do something with your left hand at some point?
Yes, I did.
What'd you do with your left hand?
I pushed her away. I
And when you
pushed
say you
Madison.
Push Madison away. Was the purpose in that to have contact with her and to get her to back up?
Yes.
Did you have a purpose to cause her pain?
No.
Were you trying to hurt her?
No.
What were you trying to do?
I was trying to push her away from my space. She was right in my space, in my face.
Why didn't you just back up?
I couldn't back up at that moment.
Okay. When you say you couldn't back up, why not?
I
Because
would've-
you felt uncomfortable, or were you?
Objection leading.
Because I would have had.
Wait. There's an objection.
Sustained.
Leading. Next question.
Wasn't done with it. Were you uncomfortable, or was there a wall behind you, or was there some other reason? Why did you feel like you couldn't back up?
I didn't feel safe turning my back on those people.
Okay. How about just taking a step backwards?
Well, I was standing my ground. I didn't move towards anybody.
Okay.
They're coming at me.
When you raised your left hand and you did that, do you recall when you pushed her away having contact with her?
I may have, yes.
Okay. Do you remember in particular where, if at all, you touched her?
No.
Okay. Would it surprise you if you touched her?
No.
Was that, in fact, your purpose in pushing her away?
Absolutely.
Okay.
She was in my space.
I want to move forward here. And you can turn the slide off, I guess. After you did that, right? Did something happen to you?
Yeah.
Did people do something to you?
Yeah.
What was done to you?
Yeah, almost right away I got punched and fell in the water.
Where did you get punched?
On my face, on my side of the head.
Now, you've had a chance to watch this video, correct?
Yes.
Have you had a chance to see these 4,800 slides?
Yes.
Prior to seeing that, did you remember everything?
No.
Have the video or the slides help you to refresh your memory in some way?
A lot.
Have you remembered everything because you've seen that?
Not everything, no.
Okay. Do you remember something different than what you see in the video?
No.
You don't remember any of the things different in that you see in the video? Like you talked about the goggles.
Objection leading.
Overruled. We're just trying to reorient the witness to a place where examination can continue.
Are there some times when your memory is different from what the video is?
Yes, of course.
Okay. Now, this series that I want to show you is about things that were done to you, okay?
Yes.
Do you have a specific memory about everything that was done to you?
No.
Do you have a specific memory about everything that you did in response to what was done to you?
No.
Do you have a memory about how you felt in those moments?
I would say yes, I do.
Do you have a memory of what you believed in those moments based upon those feelings?
Of course.
So I want to show you the slide here. Again, this is slide 2661, 2662, and 2681. That's fine. Do you remember how you felt when you fell back into the water?
I was, number one, I was stunned. That's why I fell backwards. I was very afraid, of course.
On this fear scale that you've talked about before, where are you on that scale from 0 to 10?
Right at the top, 10.
Have you ever been at that 10 before in your life?
Never been in a situation like this or a fight in my life.
Have you ever been at a 10?
Never.
When you did that, as we see on the right, what happened to your head?
Oh, well, I fell in the water. Obviously, that's a river, and I hit my head on river rock, and my whole body went under. Well,
okay.
My head went underwater.
When you say your head went under, is that what it felt like?
Yes.
Did you feel water come over your face?
Over my entire body.
Hold on,
Yes.
hold on. What's the objection?
Leading.
Sustained.
Where did you feel the water on your body?
Over my face, my mouth.
Okay.
I felt like I was submerged in water at the moment.
Did you try to get up?
Yes.
Why did you want to get up? Why didn't you just lay down there peacefully in the water?
To drown? No, I wouldn't want to do that. I wanted to get up out of the water.
At that moment, when you're down in the water, had anybody like AJ Martin come up to you and said, just lay there and rest?
Somebody came from behind, yes. I found out later who he was and pushed me down and to keep me in the water.
Before that, when you tried to get up, do you remember feeling anything before that? Did you told the,
Yeah,
did you feel anything to any part of your head?
yes, of course.
What did you feel?
Felt punched in the head.
Showing you the next slides, is that 2701, 2705, 2706? What's happening to you there?
I'm getting hit on the head.
How many times at that point is your memory of watching the video and your memory of experiencing this, have you been hit in the head now, but either by people or by the ground or by the water?
4 times at least.
Okay. At this point in time, where's your fear scale?
A 10.
When this happened to you, did you immediately get up or did you fall back in the water or did something else happen?
I tried getting up, but I couldn't.
Did you, at some point, did you feel something on your backside?
There was somebody pushing me down.
And when you felt that on your backside, did you feel anything else anywhere else?
I got hit in the face, in the front of my head.
And is that exhibit here, 2147, do you see that hand through the underarm there?
Yes,
Do you remember getting hit in the head there?
yes,
Was that a gentle hit?
no.
When you're getting hit in the head here again, where are you at on the fear scale at that point?
10,
Have you been able to get up out of the water?
no.
How many people do you know? How many people are attacking you?
At the time, I didn't know, but I knew there were more than I could handle.
Did it feel like it was, how many people did it feel like?
Like 10.
Okay.
Yeah, AJ Martin was pushing on his back behind him, pushing him down into the water.
You've seen the video and you responded at some point, is that right?
Yes.
And you used your knife in response.
Yes.
Why do you use your knife?
I feared for my life.
Did you think you could get out of there without using your knife?
I couldn't even get up. You're pushing me down. No, so the answer is no.
In that time when you're down on the ground,
there it
did
is.
you think there was a way for you to escape?
No.
Did you feel like you could just crawl away or run away or walk away or do anything else to escape?
Not in that position.
The next day after this, July 31st, were you in the, did you feel, how did your body feel the next day?
I hurt everywhere. My head hurt, my throat hurt. Obviously my back hurt. I hurt everywhere.
You said your throat hurt. Is that something you remembered that day before when you were speaking with Brandy Hart?
Yes.
Okay.
Yes.
Did you mention it to Brandy Hart?
I don't remember.
Okay. Did you see anything when you felt the pain about your throat? Did you see anything that refreshed your memory about what caused that pain to your throat?
After watching the video, yes.
Okay. What happened?
I got hit in the throat.
Do you remember that now?
Yes.
If I can.
Another terrible picture for the state.
Showing you the slides,
This is Isaac
2993, 2994, and 2997. Is that you?
Yes.
What's happening to you there?
Somebody is going for my throat, squeezing my throat.
Do you remember how that felt?
I felt pain. I couldn't breathe. Scared, afraid.
And showing you the next set of slides here, 2998, 99, and 3000. What did you think was going to happen to you in that moment?
The whole time I felt like I was going to die. So basically I feared for my life.
And in response to that, here's slide 3000. Did you do something in response to that?
I reached out and stabbed him.
When you used your knife, and again, this is open-ended. You can ask it any way you want. Were you trying to kill somebody?
Absolutely not.
What were you trying to do?
I was just trying to defend myself.
After this was, again, we've seen the video, you talked to Investigator Hart. So I want to ask you a little bit about that for a moment. Make sense?
Mm-hmm.
Do you independently, well, let me say, you've watched the video here in court, correct?
Yes.
And you watched the video prior to that. We've watched it together, right?
Yes.
Does watching that video refresh your memory? Do you have an independent memory of that conversation with Investigator Hart?
No.
Do you remember what it is you said other than seeing things on the video?
Other than I lied about the knife. That's what I remember, afterward. Yeah, I lied about the knife.
Do you remember actually saying that in that moment, or you just remember seeing that and that's what you remember seeing?
I remember seeing it in the video.
Okay. Do you remember how you were feeling during that time at all? Do you have any memory about that?
Not much.
Just one other thing out of the timeline here. Since that time, we've heard testimony, you have a twin brother.
Yes.
Is he here in the courtroom?
Yes.
Objection relevance, Your Honor.
Overruled. You may continue.
Just briefly, because I want to ask you about conversations that you may have had with your twin brother. Just briefly. How do you feel about your twin brother?
I love him.
Objection, that's irrelevant, Your Honor.
During this time, have you had conversations with your twin brother?
Yes.
Do you consider there to be anybody that you're really, maybe your wife, anybody you're closer to than your twin brother?
No.
You and your twin brother, when you speak, what language do you speak in?
Romanian.
Why do you speak in Romanian with your twin brother?
It's the easiest way to find words to describe what we're thinking.
Okay. Is that where you grew up?
That's the first language.
Are there times when you've spoke with your brother that you've talked about this, what happened to you on the river?
Yes.
Is your memory about what you did or what was done to you, is it any better when you talk to your brother than it is when you talk about other times?
No.
Are you always getting it right?
No.
How about your feelings? Your memory about your feelings?
Mhm.
Do you get those right?
Yes, but almost all the time. The feeling is imprinted in my heart, my soul, my mind.
Let me, just for a moment, I'll bring us back to the river on July 30th, okay?
Mhm.
At some, I think you'd said on the video and maybe you testified that people attacked you. Is that right?
Correct.
At some point, did people stop attacking you?
No.
At some point, did people stop attacking you?
Yes.
Okay.
Yeah.
When people stopped attacking you, what did you do?
I walk away.
Okay. Why didn't you stay?
Oh God. I walked away towards my group where it was safe. I was afraid of the people that I just had contact with.
When you're walking away, where, and you've talked about this fear scale, where are you on the fear scale? Does it just go down right to 0? Does it stay at 10? Does something else happen?
No, as soon as I saw the people I trusted, my fear level started creeping down.
When you say creeping down, when you're walking back, can you give us where are you on that scale?
As I was getting closer to my group, the fear factor is going lower and lower.
But when you first start walking back, what's the number value?
About 8.
When you get back to the tubes, what's the number level?
About 4, 5.
I think we didn't talk about it. We've talked a little bit about your body response during this brief time. When you start walking back, how's your body responding to you?
I had cramps. I felt like I had diarrhea, so I felt like I lost my bowel.
Was that
which I did?
Was that when you were walking back, or was that when you were in that 10 seconds of things happening to you and you responding?
I was when the action was going on in the 10-second frame.
You got diarrhea.
Yes.
When you were walking back, what else is your body? What are you feeling with your body?
Well, heartbeat is getting, when I'm walking back, the heartbeat was very, very high. Now it's going down a little bit. Breathing, that's what I remember. Remember, I was super, super stressed.
How about your head? As you're going back, is your head clear? Is your head in a different state? How can you describe like what's going on in your head?
My head was in a fog. It was like thick fog. I couldn't think. I couldn't realize what I've been through.
Were you trying to make sense of it?
I was trying, but there was no sense to be made. I was completely confused and in a fog.
And when you walked away, you had the knife in your hand. Is that right?
Yep.
When you got to your group, did you still have the knife?
No.
What happened to the knife?
On the way back, I tossed it on the bank.
And you just made with your right hand kind of a underhand motion with your right hand from, at your side, raising up to maybe level with you. Is that fair representation of what you were describing?
Correct.
Why'd you toss the knife?
I don't know. I was afraid. I felt like I had to throw it away.
What were you afraid of at that point?
I was overwhelmed with just fear, residual fear. And I didn't want to have anything to do with that.
Okay. We've heard testimony that eventually you get back to the tubes. Does that happen?
Yeah.
Where's your memory about that? Right now, as you sit here, because we don't have a video about that, we don't have photos of that. What's your memory like about that?
Barely remember anything.
Okay. Do you remember talking to people?
I remember people trying to talk to me, but I don't know. I don't remember what I said.
Okay. You've heard some testimony about things that you might have said. Are you denying you said any of those things?
No.
Do you know what you said?
After watching the video, yes.
The video isn't I'm confused. The tubes, there's no video of you at the tubes. When you say,
After.
were you talking about Brandy Hart statements?
Yes, yes.
Okay. About what you said to the people at the tubes. Do you have any memory of that?
No.
Okay. When you're sitting there at the tubes, how are you feeling in your head? You talked about this fog, right? If you could put that on a scale, where is that?
I still couldn't, my head was in a thick cloud. I couldn't understand what just happened. Still trying to process everything. I was overwhelmed.
Did you think at any point you were just casual about what had happened?
No.
Did this feel casual to you in any way?
No.
At some point, you saw the video here. You had contact with the police, is that right?
Yes.
You had sat in the back of a squad car of the Sheriff Knutson, is that right?
Yes.
Do you remember much of anything about that?
No.
Do you remember, you've seen some of the videos today. Can you tell us, what do you remember?
Nothing.
Okay. Nothing at all? How about a feeling? Do you remember a feeling at all?
Yeah, I was still very afraid.
Okay. When you say very afraid, what were you afraid of at that point?
Well, I've been through a horror situation, but in their presence, I wasn't that afraid, but I was stunned. I don't remember much about it.
Do you remember watching the video here in court when the police were talking about a guy with the bat?
Oh, yeah.
Do you remember anything about that?
A little bit.
Do you remember how that made you feel?
Oh, yeah. I felt very afraid of him. Very afraid.
We watched the video of you with Sheriff Knutson. That was about 23 seconds long. Do you remember that?
Yeah.
Have you watched a longer portion of that video with your attorneys?
I don't remember.
Okay. Do you remember saying more things to Sheriff Knutson after that?
I don't remember.
Okay, that's fine. We saw a video here about your being arrested and told that you were arrested for homicide. Did you remember that?
After watching the video, memory came back, but I don't remember that.
Okay.
Naturally.
When you're talking with either, at some point you go and you meet with Investigator Hart, is that right?
Yeah.
When they were talking about homicides and injuries, can you tell me what's your mindset? Did that make sense to you? Did you understand that?
No, I couldn't make any sense of anything that she was telling me. I just couldn't make sense of it.
Okay.
Plus, I don't remember the meeting with her.
Okay. Right now, as you sit here, you're like, I don't remember that.
Right.
The feelings. Now, some of the times that you talk with Brandy Hart, you talk about what you saw happening or heard happening or what you did. Do you remember that?
Yes. Yeah.
Do you get all of that right?
No.
Your feelings, when you're talking about your feelings about and how you believed and your fear.
I feared for my life. That's one thing I can't deny. That's embedded in my head forever. I feared for my life. I know that. I have nightmares about it.
You've talked to, or yeah, tell us about those nightmares.
I have them every night.
What happens in those nightmares?
Objection, Your Honor. It's irrelevant.
It's just, his nightmares are irrelevant. The fact that he had them, maybe, but not the content. No.
Can I
He's-
approach?
Yes.
Yeah, so annoying. Yeah, the state wants to get him to testify that in his nightmares he drowns. He's held underwater or he's beaten unconscious and he drowns in that river. And of course, the state doesn't want anything like that spoken in front of the jury. Let's see if the defense can come up with a good argument for sneaking that in. Ba-ba-ba. Can't really judge whether this was a good idea or not to have the defendant take the stand until we're done with cross. See how he does on cross. Okay, waiting. I don't want to fast forward because I want to have a sense of how long this argument is taking place. Hopefully he doesn't say something like, well, I see dead people. Yeah, I don't know if this prosecution is tricky enough to break this guy in cross. I mean, I would be concerned about it. Most prosecutors would be. But I've just been thoroughly unimpressed by this prosecution team. Even beyond the fact that they don't really have the law and the facts on their side, just their kind of demonstrated skill set. Just thoroughly unimpressed as legal practitioners. Funny. Anyone saying lying in a murder trial doesn't matter is ignorant at best and an idiot at worst. Well, there's an idiot in front of us. First of all, what about if you're lying about something immaterial? What if you're lying about the shirt you wore because it's a shirt your ex-wife gave you and your current wife hates it when you wear it, so you don't want to talk about that? But it's got nothing to do with the underlying merit of the case. Does that matter in a murder trial? The lie needs to be material. In other words, it could change the outcome. We have the video of what happened. We have the video. So if, for example, he were here saying, no, it wasn't me, I didn't stab anybody, and then they can match the knife to him, that would be an important lie. That would be a material lie. But he's not saying anything like that. He's saying, I stabbed those people, and we have it all on video, and we have the circumstances in which he stabbed them, and they overwhelmingly support the use of deadly force in self-defense. In that context, I don't think the lies do matter that much, if at all. I don't want to hear anyone criticizing my discussion of wives until you have had as many as I've had. I think that's a fair standard. Yeah, I thought he's been just imperfect enough that he doesn't look like he's perfectly prepared for his testimony, which just makes him seem sympathetic. Let's see. Wow, it's a long discussion. Not surprisingly, the state wants this stuff in. Did the white noise go away? We're back.
Nick, I want to ask you some questions about those nightmares, okay? Just to put it in just this tight little box, okay? You've had nightmares?
Yes.
And the nightmares have been about what happened to you on the Apple River when you were attacked.
Correct.
And the nightmares are essentially a replaying of what it is that happened. Agreed?
Correct.
And when you have those nightmares, your body responds in
Objection, Your Honor, to approach.
Yes.
So what happened at bench was the state's like, this is BS. He's just making crap up about these nightmares. There's no evidence you could possibly have to support any of this. Nothing's in the record. We didn't have notice. All this stuff. And the defense is saying, no, I've got a relevant purpose. And they found a little niche argument they could make, and they convinced the judge, all right, well, I'll let you talk about it in a very limited way for this very limited purpose. And of course, now the state's on a hair trigger to jump all over this, to object if there's any argument to be made that they went outside the judge's very tight constraints of what they're allowed to ask about. When you're having these nightmares, what happens? I drown 1,000 deaths being held underwater by a pack of laughing, screaming hyenas. His nightmares weren't in the video. All right.
Those nightmares that you've had about what happened on
We're
July
back.
30th, have you sought medical treatment for that?
Yes.
Just a couple of, I want to just make sure we check a couple of legal boxes, okay? When you used the knife, did you believe?
So the defense didn't get what they want. They wanted to get into the substance of the nightmares, and the judge obviously said no. But they were able to get on record that the nightmares occur. It makes the defendant more sympathetic, of course.
Believe you were under attack?
Yes.
Why?
Because at that point they've already been pushing and tugging, and
when you used the knife, had they done anything more than pushing or tugging? Did you?
They punched me. They pushed me down. They threw me in the water. I hit my head. Yes. So
when you decided to use your knife, were you using it to prevent an attack or stop the attack that was happening?
To defend myself.
Did you believe you needed to use that knife?
Absolutely.
In that moment in time, again, as you've described it, they pushed you down into the water, you've been punched. That's the moment of time I want to ask you about, okay?
Yeah.
In that moment of time when you were down in the water, did you believe you could escape?
No.
What do you believe would have happened to you had you not used your knife?
I would have died. I believe I would have been killed that day.
Why'd
Or at
you,
that specific time.
why'd you use your knife?
To defend myself.
Those are the only questions I have, Judge.
It's just missed that.
Oh, the lead district attorney. The lead district attorney is not doing the cross on this. I'm going to do a poll. Now that direct of defendant is done, before cross, let's see, guilty, hung jury, not guilty. And of course, I mean, it would be all the charges, really. So, all right, this is on YouTube, folks. Sorry, members, I don't know how to do a poll on. I don't think I can do a poll on the member, but I'll do it on YouTube. Now that the direct of defendant is done, but before cross, guilty, hung jury, so a mistrial, or not guilty. And I'll let that. I should let that play for a little bit before we jump into the cross, because the cross will start changing people's opinions. I do find it interesting that it's not Anderson. It's it's Brian Smestad, the second chair for the prosecution, apparently, who's going to do the cross-examination of this defendant. I wonder why. I wonder why the elected DA would not want to take this opportunity in the spotlight. It's curious to me. It would have been like having Corey during the direct instead of lead attorney Aaron Nelson. Well, the lead DA is not that good, but most people who are not that good don't know they're not that good, right? That's the Dunning-Kruger effect. All right, so it's only been up a few minutes, but I want to get into this cross. So guilty has 5%, 225 votes. Guilty has 5%. Hung jury, 16%. Not guilty, 78%. 78%. I guess I'll leave it running. Well, no, I'm just going to end it because once we start cross, it'll bias the results. So that's where we are. 77% now not guilty. Of course, that can all change the moment cross-examination starts. So let's get into it. No closed captioning available. Speed is normal. So we get a true rendition.
You can approach, Judge. Mr. Miu, you've been drinking that day, right?
Yeah, I had a
And
like
showing what's
beers.
marked as Exhibit 12A. You recognize that?
Yes.
That's the group photo of you folks from the beginning of the river.
Yep.
In fact, you're holding a beer.
Correct.
Looks like everybody in your group has some sort of alcoholic beverage.
Looks like it.
You see numerous people in your group with these phone cases around their necks.
Yeah.
And as you're going down the river, you saw lots of people with phone cases around their necks, right?
Mm-hmm.
All day long.
Yeah.
In fact, River's Edge sells or rents out those phone cases, right?
I don't know that.
Did people in your group rent or buy phone cases from the tube rental?
I have no
stand?
idea.
All right. You've testified that
This is not a good start. He's what, 5 questions in? And already he's asking questions he doesn't know that he's going to get a positive answer out of? What's this whole point of this is the strongest thing he's got to start with is the phone cases? Where's that supposed to go? In any substantive way.
you were told to bring the knife before you left your home, right?
Correct.
And the reason for bringing your knife on the river was to cut strings or ropes for the tubes, right?
Correct.
And that was the reason you brought it.
Correct.
In fact, you told the police that after your tubes were tied together, you thought you put your knife back in the car, right?
Correct.
But in fact, it was in your pocket.
Yes.
Was it in your pocket the whole day?
No.
All right, well, we're going to get to that. Once the tubes are tied together with the rope, and you said that you thought that you put it back in your car, you don't have a reason to have the knife anymore, right?
Does this prosecutor sound like his voice is shaking? I don't remember his voice quavering like this when he was doing questioning of other witnesses.
Tubes are tied together with the rope, and you said that you thought that you put it back in your car, you don't have a reason to have the knife anymore, right? It accomplished its purpose, right?
This
I
is
didn't
not a
know
good
that
argument.
At the time.
All right. Did you tell the cops, that the police, that you didn't think you were going to need it, and that's why you thought you put it in the car?
I may have.
All right. Were you present when Steve Kaufman, who owns River's Edge, testified first day of the trial?
Yes.
And you heard him say that they sell pre-cut cords for $1, right?
Right.
All right. And then, did you see in the picture, when you got on the river, you were wearing that long sleeve camel shirt, right?
Mhm.
A hat and sunglasses?
Correct.
All right. Ariel's phone was in one of those cases, right?
Sure. Yeah. Yeah, I can see it.
All right. And is it your understanding that those cases are float cases?
That's what I was told.
All right. And in fact, you told Lieutenant Hart that it was in a float case, right?
Correct.
Once the phone disappeared, there was conversation amongst the folks in your group about whether it was even worth it to go look for it, right?
That's what I learned.
And in fact, you were told that they didn't care about the lost phone because they had insurance to cover it, right?
That's what I learned here, but I don't remember that as a conversation.
Nobody asked you to go look for the phone, right?
Correct.
You chose to do that on your own.
I volunteered.
And in fact, members of your group were a little annoyed that you were stopping again so quickly after having been at the hideaway where you'd stopped for lunch.
Objection, speculation.
Sustained.
Did you hear anybody in your group say, why are we stopping again?
I didn't stop the group.
The group stopped when you decided to go off on your own to look for this phone, right?
Objection, speculation.
Overruled.
Right?
They already stopped. I got off the tube to look for so I didn't stop them.
In any event, you're the one who insisted on looking for it. Nobody asked you to do that, right?
Objection, answer.
Sustained.
And when you left to go look for the phone, you had your goggles and your snorkel, right? You knew that the phone was in a float bag. At least that's what you told police afterwards, right?
Mhm.
Is that a yes?
Yes,
So the bag, the phone and the float bag would have been floating, right?
supposedly,
All right. And so you wouldn't need a snorkel and goggles to find a phone floating on top of the water, right?
I wasn't sure if it was actually floating or not, and never tested it.
All right. Well, you would agree that a phone has some weight to it.
Yes,
And if it wasn't a float bag, it would sink to the bottom, right?
yes,
Where it was dropped.
correct. Well, or remember, it's a river, so
Sure.
it could have flown down.
The river has current, right?
Right. So it
How
could
do I
have
get
flown.
approach? I'm going to draw something here.
Yes.
You remember when you met with Lieutenant Hart, you drew a diagram of the river. All right, and this is your group up here at the sandbar, right?
Mhm.
I just don't hear anything here that's substantive. It's all these little, there's an innocent explanation for all these things. It's not a crime to look for the phone, even if the owner doesn't want you to. If they're already stopped in the sandbar, why not? It's not a crime to choose not to purchase little pieces of string for $1 a piece when you can bring a whole cord of string and cut your own. I just don't understand this. Where's this going? How does this disprove self-defense? It's not a crime to have that pocket knife in your pocket. What difference does it mean? I carry a pocket knife in my pocket every
Boys
day.
down here. I'll put initials IS for Isaac Shuman, right?
Correct.
This is the diagram that you wrote,
Mhm.
drew for Lieutenant Hart. The phone was lost over here, right?
Mhm.
Instead of looking downstream for it where the current was going, you went this way, across the current,
No,
to look for the phone. You made contact with Isaac Shuman's group on the other side of the river.
but that's not where I started looking for it, straight across the river.
That's where you ended up making contact with
I
him.
ended up there, but I didn't start there.
All right. The phone would not have floated across the current, right?
Well, I don't know where he lost it. That's where we pulled over. He could have lost it minutes before we even anchored.
So when you testified a minute ago that the phone was lost, where your group was labeled M, now you're changing that story?
In that vicinity.
Objection. Mischaracterize his testimony.
Again, members of the jury, what the attorneys say is not evidence. Rely on the witness's testimony. Next question, please.
In any event, it's your testimony that you had reason to go over to the south side of the river where Isaac Shuman's group.
I mean, are we supposed to conclude that it wasn't self-defense because he had imperfect understanding of the flow dynamics of the river?
was. To look for a phone. That's your story?
I had reason to search in that area. I didn't know where that phone fell in the water. I don't think even Ariel knew where he lost it. We didn't drop the phone when we anchored. He dropped the phone before we got there.
Fair to say that at that point in the river is 150 feet wide,
Yep,
and Isaac Shuman's group was on the south side of the river.
correct.
Your group's on the north side of the river.
100 feet.
Rather than searching the north side, you went to the south side of the river. Is that fair to say?
I already looked in that area.
That's not what I'm asking. You went over to the south side of the river, right?
Objection, asked and answered.
Overruled. You can answer the question.
You did, right?
What was that question?
You
again?
went over to the south side of the river to supposedly look for this phone, right?
I ended up there at that point, yes.
And you chose to go over there and look for it, where these boys were.
Overruled. You can answer the question.
Oh,
You chose to go over to where these boys were to look for, supposedly look for this phone, right?
chose to look in the area, yes.
There was other areas of the river where there was, these boys weren't located that you could have searched until they floated past. Right?
A million other spots.
Sure. But you chose to go to that spot.
I didn't even notice those boys there at the time when I was searching.
You were present in court when Eric Williams, who was a member of your group, testified, right?
Right.
You heard him testify?
Yes.
And you were here when he testified that he had some concerns about you going over to snorkel by this group, Isaac's group.
I heard him.
And one of his concerns is that he thought that they would think you were a predator, right?
Sustained.
This is not a good performance by the states.
He testified that you didn't have your knife in your pocket the whole time, right?
Correct.
When you decided to go snorkel over by Isaac Shuman's group, you had the knife in your pocket.
Yes.
Did you go back to your group and get it?
No, I had the knife. I testified I did not have the knife in my pocket the whole time. When we pulled over there, I fixed my shoes. Then I left it in my pocket.
All right, but somehow, so when you get ready to snorkel,
Yes.
you've taken off your shirt, right?
Yes.
Your hat,
Yes.
your sunglasses.
Correct.
You left the knife in your pocket.
I forgot it in my pocket.
Well, on the video, we can see you touching your knife, right? You knew it was in your pocket.
Well, when you walk, it starts, yeah, but
It has weight,
Right,
right?
yeah.
So you can't forget it's there because it's got weight. Correct?
at some point I forgot I had it in my pocket when, yeah.
You
When
weren't
you
gonna,
walk-
you were not going to need your knife to snorkel and look for a lost phone.
Correct.
Overruled.
You weren't going to need your knife for that task that you set out to do, right?
I wouldn't even need anything.
But you brought it with you anyhow.
It happened to be in my pocket, yes.
When she got over to where Isaac Shuman's group was, they made it readily apparent.
I mean, this line of questioning is inane. What are we supposed to believe from this? Are we supposed to believe that he maliciously put the knife back in his pocket, snorkeled over there, and then wait to get yelled at, taunted, called a pedophile, called a raper, falsely claimed to be looking for little girls? There were no little girls on the river. Walked over to the adults coming over from the other side of the river, who, unbeknownst to him, were just going to help the teenagers already taunting him. Stood there. He knew, I guess, that the two female hyenas were going to be screaming at him on the river and pushing and shoving him, and then get punched in the head, into the water, pushed down, face down into the water, hit twice more. And then he said, "Now's my time. This is why I brought the knife, for this moment." I mean, this is crazy.
They did not want you over by them, correct?
That's not true.
They didn't call you names?
Yes, but they asked me what I was looking for. And I thought they were polite people. I said, I'm looking for my lost phone.
They did not want you by them, and they told you that, right?
At some point, yes.
And that's the short video. You turn around and you're walking away, right?
Yes.
But then Joanne Cockfield calls you a raper, right?
Yes.
And then you turn around
Yes.
and you were angry.
I was not angry.
Oh, you were not angry that someone called you a raper.
No.
All right. You look at Joanne, who's filming you, right?
Yeah.
And for some reason, your testimony is that even though many people on the river have these phones and these float cases, you decided that was the phone and you needed to run up and check?
Objection argumentative.
Sustained.
Your testimony earlier was you thought he had the phone, right?
I thought he had the phone, yes.
Right.
I wanted to investigate.
And you, instead of walking up and saying, hey, is that the phone I'm looking for? You ran up on these boys, didn't you?
I ran up and stumbled, and then I fell right by their, yes,
That's my next question. You're claiming now that you stumbled.
yes.
You've never said that before today, ever, to anybody, any law enforcement or anybody else. Right?
But I have seen the videos now.
Well, we're going to take a look at the video.
I hope so. I don't think that's going to be helpful to the state. I can't believe the defense didn't play the whole video.
And since you reviewed the video, you know that before you ran up on them, you were touching your knife in your pocket to make sure it was there, right?
I don't remember that.
All right, well, let's take a look.
Yeah, the defense will get redirect, but I would have already done it. What I would have done is I would have shown the stills, all the stills of the touching, every single one. The girls, the punch to the head, the hands on the back, the other hits to the head, and said, you remember these, right? Now let's see this in the context of the video, and just play the video and just freeze it at each one of those points. Bop, bop. And then while it's playing, the portions you're playing, you hear the screaming and the taunting and the yelling, and then you see the blows coming in. I would never have missed an opportunity to show that video again. Not just the screen captures, the actual video with the audio.
Stop.
Back up one. So he's going to show a frame. He's not going to show the video.
That's you with your right hand touching your pocket where your knife was clipped in, right?
It appears so.
What is he on? Whoa! 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 Get away!
So you're claiming today that where you reach down and grab at these boys' legs where their tubes are, that was a stumble. Is that your story?
Objection argumentative.
Overruled. You can answer the question.
I know I hit a stone, yes, but I grabbed onto their inner tubes.
And you know where you grabbed onto their inner tube is where two of these boys had their legs draped over their inner tubes, right?
I see that.
And you made contact with their legs, didn't you?
I don't remember that.
Did you see it on the video?
I see it on the video. I don't remember actually making contact.
And as soon as you did that, these boys jumped out of their tubes to get away from you, right? You remember that?
Yeah.
And you held onto their tubes so that their tubes couldn't float away.
For how long?
Well, I'm asking you. You did.
Yeah, it looks like for a brief 1 second.
And you were searching through their tubes.
Or what?
You walked around their tubes. Rather than letting their tubes go so they could get back in their tubes and be on their way, you walked around their tubes.
So after my goggles dropped in the water, I went around their tubes to go to the other side and look for my goggles.
Let's talk about your goggles for a second, because you told the police, specifically Lieutenant Hart, that these boys knocked your goggles off your face and that you were looking for your goggles at that point, right?
I don't remember my interview with her, correct?
But you heard yourself say it in the interview.
Yes. Yes.
And in fact, that nothing of the sort ever happened, right?
So the interview with Brandy Hart was not accurate.
What you said at the time is what you wanted the police to believe happened, right?
That's what I remembered at the
Okay.
time.
And from the video, you can see that you actually put your goggles in your mouth so you would have two free hands to be able to grab onto these boys' tubes, right?
Yes.
So you were preparing for your stumble before it actually even happened?
I wasn't prepared for anything.
These boys were calling you names to go away, right? After you grabbed onto their tubes, touched their legs.
I don't remember any of that stuff.
All right, you
but-
don't remember them calling
but-
you, asking you what you were doing?
Watching the videos, yes, but unnatural remembering, no.
Do you remember as you're running up, they're saying, whoa, 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 what's he doing?
I don't remember that.
All right, but you've seen it on the video.
Yes.
And then once you've made contact with two of these boys' legs and grabbed onto their tubes, they started calling you a pedophile, right?
I don't remember when they started calling me.
Do you remember them calling you a pedophile at all? Or do you just know that from watching the video?
Correct.
You testified that they were calling you names earlier, right?
Right.
And that upset you.
It did not upset me.
Okay, we've talked, your attorneys talked about your comfort scale and your fear scale. Let's talk about your anger scale, okay?
Mhm.
At the time you were called a raper, what was your anger scale at?
This is a bad line of questioning for the. This is stupid. This is the state just entrapping themselves. What was your anger scale at? What was your anger? What's he going to say? I wasn't angry.
Maybe.
Where's the objective evidence of anger? He was criticized because he had a flat demeanor, because he wasn't saying anything.
He won.
1 out of 10?
Yeah.
And that was enough to get you to run up on these boys, grab onto them, stop their tubes at a 1. Is that what you're saying?
Objection, argument, that's not what he said.
Sustained.
You don't like being humiliated, right?
Nobody does.
Your attorney has said that these boys were humiliating you.
Objection as to his making.
Sustained on the form.
You're claiming that you were being taunted.
Objection, did not testify to that.
Sustained. Form.
His defense attorney said that, but he didn't say that.
You had testified earlier that your shoes, there was problems with your shoes, but as you can see from the portion of the video we played so far, those shoes didn't prevent you from running up on these boys, right?
Yes, they did. There was, if I had better shoes, I could walk better, but I could still walk.
If you had better shoes, you would have been able to run up on them faster.
No, I mean, I could walk better. I wouldn't stumble. I wouldn't have a hard time walking.
Another self goal by the state.
All right, we're going to watch the video again, and I want you to, if you can, point out for everybody where you stumbled.
I just want to point out, what is the actual legal argument here? What does the state need to be addressing here on the legal merits? This guy concedes, I stabbed one person to death and stabbed 4 others. He's charged with 1 count of murder, 4 counts of attempted murder. His legal defense is self-defense. If it's perfect self-defense, if the state cannot disprove self-defense beyond a reasonable doubt, the jury is instructed to acquit. Right after this stupid encounter with grabbing onto the tubes and the stumble and all this, he turns around and walks away. That encounter's over. It's over. It's done. So it's irrelevant to this claim of self-defense. He's not saying, I stabbed these kids then. No one is saying that. This is a completely pointless line of argument.
What is he on? Whoa! 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 Get away!
Did you watch it?
Yes.
So the stumble, is that something you remember or something that you think you see in the video?
Something I remembered.
After you grabbed onto their tubes, stopped them, walked around their tubes, you took a few steps downriver and stood in the path they were floating in, right?
Has to form multiple.
Overruled. You understand the question, Mr. Miu?
Could you say it again?
After you left their tubes that first time, you took a few steps downstream and stood in their path where they would need to float, where they were floating, right?
For a few seconds, yes.
You didn't walk off to the south shore, which was close at that point, right?
I thought I walked far away from them, that they, I mean, I didn't even watch them anymore at that point. So I don't know where they were you know, at that point in time. But I was still looking for my goggles now.
Are you denying that you stood right in the path of their tubes?
Overruled. You can answer the question.
At that moment in time, yes.
Now, when you ran up on these boys and grabbed onto their tubes and made contact with their legs, you weren't saying anything at that point, right?
No.
You didn't say anything like, hey, I think that's my phone or Ariel's phone.
I don't remember saying anything.
You've seen the video.
Right.
You just ran up and grabbed onto them, right?
It appears that.
Was saying nothing.
Not a question.
We can go up to the screen. We're going to look at some more frames here. We're starting 22nd mark, I believe. You stood in front of their tubes, right? This is at the 23-second mark.
For a brief moment.
All right, keep going. Stop. At that point, you had the entire river open to move in any direction, right?
Right.
You chose to just walk a few steps directly downstream from where their tubes were, right?
Correct.
The boys were yelling at you at this point, right? You remember that?
Yep.
They were making a commotion, right? They were loud,
Mm-hmm.
and that attracted the attention of the folks in the Carlson group, right?
Mm-hmm.
You've testified that Maddie Cohen walked over, right?
Yep.
You walked towards her.
Yes.
And the water level at the spot that you had contact with Maddie was about ankle deep from the video.
From the video, yes.
And you told Lieutenant Hard you were standing in really shallow water, right?
Yeah.
Maddie told you to leave the area, right?
She didn't say it that way, but yes.
She said, go, go, go.
And?
She swore at you too, but she was telling you to go, right?
Yeah.
You didn't go.
I was trying to communicate with her what I was doing in the river.
You didn't leave, right?
No, not down the river.
Hold on.
Irrelevant of legal basis.
Overruled. It's relevant.
You did not leave, right?
I
At the
didn't
time
go
that
in
she
the
came up
direction.
and
No,
when she came up and said, go, 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 you chose to stay, right?
I wanted to talk.
You didn't like that she was yelling at you, right?
I only had like 2 or 3 seconds of direct verbal or whatever.
And you clearly didn't like she was swearing at you, right? And what you told her was not that you were looking for a phone, but that these boys took your goggles, right?
I don't remember what I told her.
If it's on the video, did you say it?
If it's on the video, yeah.
You never mentioned you were looking for a phone.
I don't remember my conversation with
And
her.
in fact, after you told her that they took your goggles, you never said another word, right?
After that?
Right.
Of course I did.
Talking about your anger scale, at the point where Maddie Cohen was yelling at you and pointing at you and swearing at you, where was your anger scale?
1.
And even with your anger scale being only 1, you started touching, fidgeting with the knife in your pocket, right?
I don't remember that.
Let's take a look at the video.
I did so many self goals by the state. So they said, well, you told her the boys took your goggles. I don't remember that. You never told her you were looking for the phone. I don't remember that. But if it's in the video, that's correct. If it's in the video, so play the video. Show us. You got the video right there. According to the state, apparently the evidence of being afraid is a big smile and lots of laughing.
We're ready. It's timestamp 135. That's you touching your knife in your pocket, right?
Correct.
And at this point, you've got your back to the two girls who were yelling at you, right?
It's possible.
So even though you were fearing for your life, you turned.
That's not what he said at that time.
Overall, let's get the question out.
You turned your back on these folks, right?
Where am I in that location as reference to the other people?
I get to ask the questions at this point. Okay.
All right.
You're back at the 135 mark that we just watched. You've turned your back on these folks, right?
Okay.
Is that true?
Yes,
You
I
saw
see
it,
that. Yeah.
Right. You're touching your knife, but you got your back to them, right?
I see that in the picture.
And so at that point, you wouldn't have turned your back on these folks if you had fear of them, right?
Objection mischaracterizes his testimony.
Overruled. You can answer the question. Yes.
Yeah, this is just at this point, this is just abusive by the state. I mean, they're just repeatedly mischaracterizing the evidence in the testimony. And if you do it enough, you can tell the jury all you want that what the lawyers say is not evidence. But if you let them get away with it enough, the jury will start to believe that might be the evidence. So the defense is objecting. The state's, the judge is allowing it. But I would think this is the point that the defense is making to the judge. Judge, this is just becoming cumulative. If they have the evidence to support their argument, they need to point to the actual evidence and the actual testimony, not stuff they're just making up. He's not stabbing people at this point. He never said he was in fear for his life at this point. The state is saying that. The state is fabricating testimony. I don't know why the judge isn't stopping it, unless he's thinking, well, you can address it on redirect.
We'll play a
Mr.
clip
Smesta,
here.
next question, please.
We're going to play a clip here, Judge. Go back.
Well, I guess the defense won there. We'll see.
We're starting at 126. Just play it. We can have the screen. Stopping at 135.
The only time this defendant needs to have been in fear for his life is when he's stabbing people, not prior. It's irrelevant prior.
So in that clip, that's the point where you had waved at your friends, right? You had turned your back on the groups of people that were in the area, and you're touching your knife, right? And at that point, you called out to your friends because I think you had said, and maybe I'm wrong, that your fear scale was going up at that point. Is that not right?
I see lots of people around me, and I wanted somebody to be on my side.
Right. Your fear scale was going up, so you tried to wave your buddies over, right?
Creeping up, yeah.
And as it's creeping up, you're fidgeting with your knife.
It appears that way.
At some point,
is he charged with fidgeting with his knife? Is that the crime?
and even though your fear level is creeping up at that point and you've called for help from your friends or at least waved for help, you turned your back, right?
Yes.
At one point, you turn your head and you stare at the group of 17-year-old boys, right? Do you remember doing that?
I don't remember it, but if I could see a video.
Put it into context, it would have been at the point when Maddie Cohen tried to turn you away from those boys. Do you remember doing that?
Yes.
And 1 second. If we can get the frame up.
Is that the crime, that he stared over at a group that was yelling and screaming at him and calling him a pedophile? You're not allowed to do that?
We're at timestamp 116. That's the look that you gave to those boys, right? At that time, at 116?
Yes.
That's the look on your face.
Yeah.
That's an angry look.
Not to me. I was annoyed more than frustrated, but not angry.
At the point where you looked at the boys with that expression on your face, whatever it was, you had the entire river in front of you open to walk to, right? That's true.
Correct.
And instead you chose to turn back around where Maddie Cohen was, right?
I stood my ground. I basically stayed in the same location.
Right.
I didn't go towards anybody at that point.
You didn't take a step away either, did you?
No.
And at that point then, that's when Riley Madison joins her. And you've got Madison and Riley standing in front of you, right?
I suppose that's the time, yeah.
Two girls.
Yeah.
And these two girls standing in front of you touched your shoulders somewhat, right?
Mm-hmm.
You never, is that a yes?
Yes.
You never stumbled backwards or anything like that?
It wasn't somewhat, but.
Well, let's take a look at the video.
Two girls and 11 men.
We're going to start a little bit earlier than the part I wanted to start at. It's at the 135 mark again, if we can put this screen up.
Why would you even say that?
You take the screen down.
That was useful.
Starting at 134. So at that point, you're touching your knife before Maddie and Riley are standing in front of you, right?
Appears that way.
Stop. You had said that your fear level was rising.
Mm-hmm.
You had waved to your friends, right? That was the look on your face at the time, correct?
Mm-hmm.
You're smiling.
I'm confused.
You're smiling.
I'm confused.
You're not smiling?
That's not a smile.
Yes. Let's move on, please.
Can't we do that with the
We'll
children?
get the screen back.
Folks, I do a lot of video, as you might imagine. I do a lot of video and then I do post-production on it. You think I don't see in every post-production? I don't see freeze frames of myself, of my face with a bizarre and apparently bizarre facial expression. Eyes closed, eyes open, mouth in this thing, in this shape or that shape, one eye open, one eye closed. Faces always look weird when you freeze them frame by frame. Look at the anger. Look at the anger.
All right, so you had been fidgeting with your knife multiple times. You've got Riley Madison in front of you. I believe her testimony was she's a 115-pound woman. You got Maddie Cohen on your other side. This is when you choose to pull out your knife, right?
Objection as to form.
Overruled. Understand the question?
What does her way have to do with me?
Sir, you don't get to ask the
Oh, I'm
questions
sorry.
at this point. You pulled out your knife at this point with these two girls standing in front of you, right?
Yes,
And you held it down by your belt line, right?
yes,
And you opened it up, right?
yes,
And this is before you had been punched or anything like that. You had that knife ready with these two girls standing in front of you.
Objection as to use of the term girls or women.
Women, pardon me,
Mhm.
right?
Mhm.
And you didn't hold it up and say, hey, I have a knife, right?
To me, that would be a threat.
Well, I'm not asking you that. You did not hold it up.
No,
And you didn't, in fact, you held it down by your side, right?
Objection asked and answered.
Overruled.
Isn't that what you did?
yes,
You didn't take a step back and brandish it and say, hey, back up, I have a knife, right?
correct.
You opened it down low and then you,
This is a perfect example of how whatever you did, it's always the wrong thing. It's always the wrong thing as far as the prosecutor. Imagine if he had taken a step back and held up the knife and brandished it. The prosecution would have said, well, that's clearly a threat of deadly force. Of course, all 13 people would have been privileged to beat you to death right there in the river. It's always the wrong thing to do.
you held it down low by your side, right?
Correct.
And as you're doing that, you're smiling, right?
That's not a smile.
Well, let's take a look at the video.
I'm overwhelmed and annoyed.
And of course, it's not just the two girls.
And that's you holding your knife down by your belt line, right?
Yes,
When you pulled it out and opened it up, you held it with the blade facing up, right?
I just want to share this because, let's see, what can I call this? I'm sure let's see, I think it's called 104. Oh, come on. Because this is such a disingenuous argument by the prosecution. And I'm certain that the defense is going to cover this on redirect. But just so we don't forget what was actually going on. That blue dot is the defendant. Here we have Riley Madison and Madison Cohen. And the state wants us to believe that those were the only two people facing the defendant at this moment. You see all those other red dots? They were there too. If the state has an ethical argument against the defendant's legal justification of self-defense, where is it? And by the way, folks, it's not just the two girls and their weight, it's the weight of everyone there. Mass, just count up all their weights. Let's assume an average weight of 150. 13 people, 150 pounds each is a ton. Literally a ton. 1,950 pounds. Okay, back to the show.
I didn't pay attention, but in the video, yes.
And it becomes important later when you stab AJ, because you didn't try to cut him down, you cut him up, right? Right?
That was not my intent.
Overruled. I believe the witness answered the question.
You had the knife blade up and you're saying you didn't know that?
I didn't pay attention.
As you're holding it there, you've got your thumb on the bottom of the handle, right? Right?
Yeah,
Blade up.
I see that.
Blade's pointing at, looks like at Maddie Cohen, right?
Yes.
Nobody else. I'll strike that. After you opened that knife, would it be fair to say that your fear level went down a little bit because now you had your knife open?
No.
All right. Was your fear level going up at that point? I think you said that earlier.
The whole situation was boiling up.
So when you have your knife open, you take a couple step backwards to get away from the situation?
I stood my ground. I stayed in place.
You never backed up one step, did you?
No,
You had your knife out and you were prepared to use it.
to defend myself.
At that point, there's nothing to defend yourself from, right?
I didn't know that.
Well, he's not using it then.
If I understand your testimony today, now you're acknowledging that you did do something to Maddie Cohen, which started off this fight, right?
Objection argumentative.
Overruled. You can answer the question.
Objection, police probe.
Yes.
Sorry, I just want to get the phrasing of that.
If I understand your testimony today, now you're acknowledging that you did do something to Maddie Cohen, which started off this fight, right?
So that's the objection. No. No. The fight was already happening. Maddie Cohen had already committed a simple battery on him. So did Riley Madison. So it's very convenient for the state to cherry pick a point in time and say, "Well, no. You're pushing her out of your personal space, out of your face when she's screaming and cursing in your face." That was what started the fight. I suggest not. She was already committing battery on him. So was Riley Madison, backed by 11 other men. 11 men.
Right?
Objection argumentative.
Overruled. You can answer the question.
Objection, police probe.
Yes.
All right. Another bench with the white noise. Yeah, I just don't see any meat here from the state at all. I don't see them attacking any of these things. I mean, the closest would be this issue of retreat. And I do not like the way the defendant keeps saying I was standing my ground. That's unfortunate phrasing that his defense counsel should have cautioned him against.
Mr. Smestad, would you please rephrase the question?
I will, Your Honor. You're testifying today that you did actually make physical contact with Maddie Cohen, right? Before you were punched or anything else, right?
Before anything else?
I may have.
You don't remember that?
Well, I remember what I said, but I went over to push. She was right in my face. right in my space, yelling, and I could smell the alcohol in her breath.
But you had been drinking too, so might have been your breath.
I didn't have vodka and all the other garbage.
My
Right.
point is, today you testified that you did something physical to Madison Cohen before you were punched, right?
Mm,
Correct?
I don't know if I touched her or not. It's possible that I did.
If your friend Sergio testified last week that he saw you push her and she went flying back a couple of steps, that's what happened, right?
Objection as to form.
Sustained.
Were you present when Sergio testified?
Objection as to form and relevance.
Sustained.
I think the state's got nothing. Whisper, whisper, whisper.
After you pushed Maddie Cohen, only one
Objection.
person ever punched you, right?
From the video?
Right.
That's what I see. I don't remember what happened there at that time.
I'm not asking you what you remember. I'm asking what actually happened.
I got punched.
Objection, no foundation.
Sustained. Rephrase the question.
We
Started.
saw in the video that only one person ever punched you, right?
Yes.
Objection.
It's cross. It's not
Hold
legal.
on.
Can I vote?
Yes.
All these objections, of course, are perfectly appropriate. The state's trying to make something from nothing. Only one person punched him. He's getting hit while he's face down in the water. He doesn't know how many people are punching him. His act of self-defense is to be judged by the circumstances in which he found himself, not with the perfect knowledge of a video from a different perspective shown in a courtroom. He doesn't know it's the same person punching him when he's face down in the water. It's really contemptible. This is what happens when the state doesn't have a case. You know they don't have a case when they're doing this, when they have the defendant on cross-examination. And
Objection
this is all they
sustained.
get
Let's
out
move
of
on.
it. Objection sustained.
You testified that you went down and you fell down in the water when you were punched, right?
Yes.
And you indicated, I think, that you were punched in your jaw, I think on your left side of your body.
Yes.
You testified that you fell back in the water and hit your head, right?
Yes.
You did not drop your knife.
No.
Right? You held on to it when you fell down into the water.
Yes.
When Dante Carlson hit you, he was holding a can of beer in one hand, right?
Yes.
He was fighting you with one hand. You never suffered any kind of bruising or cuts to your face from this incident, right?
On the inside of my cheek?
You cut the inside of your cheek.
Yes.
Yeah, you never had any bruising on your jaw, right?
I don't remember.
Bad answer.
And
for
I
the
had a
state.
beard. I couldn't tell.
You weren't bleeding from your face anywhere.
No, not that I know.
Hey, every once in a while, you just have to take a beating. You just have to take a one-hand beating from a dude in the river holding a can of beer in his left hand. You just have to do it. You got to take that.
Once you're knocked down in the water, AJ Madison comes up to you
AJ
and
Madison.
pushes on your back, right?
Objection, no foundation.
Sustained.
We'll play the video.
How is this a win for the state? I mean, oh my God. I mean, this is what the state has just set up with these last two questions. Once you were knocked down in the water, AJ comes up and pushes on your back. Is that right? Effing right. That's right. Yeah. Face down in the water. He's pushing on my back. I've been punched in the face, knocked down off my feet into the water. I'm on my hands and knees, and AJ's pushing on my back, pushing my face into the water. That's great, state. That looks great for you. Doesn't look anything like self-defense now. You know, you always wonder what this big fat prosecutor would look like if someone punched him in the head, put him in the river, face down, and then started pushing on his back. I wonder what he'd feel like the circumstances were developing into.
You were pushed in the back by AJ Madison, right?
Objection, no foundation.
Overruled.
In response, you got up out of the water, right?
Mhm.
You take your knife in your right hand with the blade up, right?
Objection is in narration.
Overruled.
That's what you did, right?
Still in my hand, yes, that way.
You jabbed it into his belly.
About the same time he hit me in the throat.
That's not what I'm asking.
Yes.
You jabbed it into his belly, right?
Yes.
Instead of pulling it out, you pulled up, right?
Because I had so much time to think about it.
You pulled up.
I did not pull up.
Okay,
I look at the angle of my arm.
We're stopped at timestamp 156. You see your knife?
Yes.
How close it is to his jaw, his chin?
Yes.
That's because when you stabbed him, instead of pulling out, you went up, right?
I was falling backwards with the knife in my arm, in my hand, and the angle of my arm was about the same. Just got hit in the throat.
In this frame of the video, the knife's pointing straight up, right?
Yes.
Went in, pulled up, and it's by the time you got done up by his face, your knife's pointing straight up.
Objection, asked. Sorry.
Overruled. You can answer the question.
It's straight up.
At that point, Tony Carlson came in to break up the fight.
Objection, speculation. He doesn't know what Tony Carlson's doing. on water.
Overruled. You can ask the question. He can answer.
I don't know what he was doing.
You know that he told Dante Carlson to back up, right?
Objection, no foundation.
Overruled.
Do I know from video and from testimony? Yes. At the time, I didn't know.
After you stabbed AJ Madison, you were pushed back into the water, right?
Just sorry, it's AJ Carlson.
Pardon me. No, it's not. It's not.
AJ Martin.
It's AJ Madison. He's not part of the Carlson family. AJ Martin.
Thank you.
Pardon me. After you stabbed AJ Martin,
I was wondering about that Madison thing through all of this. Like, I didn't know AJ was related to Riley Madison. How do you spend 21 months on this case, all the way to trial, all the way to the end of trial, doing cross on the defendant, and you can't remember the name of the participants you've been talking about all trial? Crazy.
you were pushed back into the water, right?
Yes.
Nobody jumped on top of you.
No.
Nobody was kicking at you or punching you.
No.
You're just in the water by yourself.
By himself, like it's a party.
Apparently, yes.
We're going to take a look at the video starting at 1:55. That's you in the water, still holding your knife, right? Pardon me, this is before you got up. At this point, you're standing there. There's nobody hitting you, nobody's punching you, nobody's kicking you, right?
Objection, that's the video show. He's not standing.
Gentlemen, please come up.
Another bench conference. Of course, either side, the prosecution or the defense, can argue for reasonable inferences from the evidence that's being presented. But this is way, way beyond this by the state. This is just gross mischaracterization of the evidence. There's no evidence. There's been no testimony that this defendant pulled up on the knife. He stabbed into someone's belly as that person was hitting him in the throat, and as the defendant's falling backwards from the hit, the knife goes up.
Let's continue. Next question, please.
In any event, you were sitting in the water after AJ Martin pushed you over, right?
I landed on my butt in
Right.
in the river.
But at that point, the fight didn't continue. People weren't punching on you, right?
At that time, I couldn't tell what was going on around me.
That's at the point that Tony Carlson came over, was yelling at people to back up. Do you remember that?
From the video.
You don't have a memory of that in your head? He separated Dante from you, right?
Objection, no foundation.
Overruled.
Right?
If it's from my memory, I don't remember that.
Tony Carlson never punched you, correct?
Correct.
He never kicked you, never pushed you.
Objection, mischaracterized the evidence.
Overruled.
No.
And you turned around and you stabbed him twice, right?
I couldn't see. I couldn't hear. I didn't know who was punching me, touching me, shoving me, nothing. I was fearing for my life.
You stabbed the guy who tried to break up the fight twice, right?
Objection, form.
Overruled.
That's what happened, right?
That's what happened.
And luckily for him, he was able to block your first stab. So you stabbed him again, right?
I had milliseconds to think.
Riley Madison, after you stabbed Tony Carlson, you turned around, you got up, you turned around, and you sliced Riley Madison through her left side of her body, right?
Yes.
She wasn't punching you or kicking you.
She came at me and she had her hands on me.
At the time you stabbed her, she had her hands on you.
Yes.
This 115-pound woman attacked you while you're standing there holding a knife.
She could have been 500 pounds. I don't know. I'm sorry, sir, but
You've never told anyone ever that Riley Madison attacked you and that's why you stabbed her, right?
No.
You're saying it today for the first time.
I don't remember this whole thing.
After you stabbed Riley Madison, Isaac Shuman tries to push you, right?
And he lands his hands on my throat. Yes.
But his hands originally weren't anywhere near your throat. They were on your shoulder and your chest, right?
I didn't take measurements, but yeah, from the picture, yes.
And as soon as he touches you, you stab up into his heart with your knife, right?
Objection, no foundation.
Overruled.
He went for my throat, and I defended myself. Yes.
Are you saying, we're going to look at the video. We're going to start at 2:02, and for anybody who doesn't want to watch, you might want to avert your eyes. Ready? We're at 2:05, the timestamp on the video. That's Isaac Shuman, right? If you don't,
Right.
his left hand on your arm, right?
Right.
his right hand on your chest, right?
Right.
They're not on your throat.
In that particular frame. Correct.
And your right hand is cocked, your elbow's bent, right?
Okay.
And you've got the knife in your hand.
Yes.
Let's play it through, please. And as he's pushing you, you jam your knife up into his heart, through his rib cage, right?
After he touches my throat and pushes me back, yes, correct.
As your arm is moving up to stab him, you actually moved his arm closer up your, or farther up your body with your own movement, right?
I don't know how to answer that. I didn't see that.
At the time that this incident happened, you agreed you weighed 248 pounds.
Yes.
Not one of these people that you stabbed so far in the video were armed in any fashion, right?
Right.
You told an elaborate story about people pulling knives on you, right?
Objection, argumentative as to form.
Overruled.
Right? You made up that story.
To Brandy Hart?
Lieutenant Hart, yes.
I don't remember that, but I saw the video, yes.
At no point did anybody pull any knife on you, right?
Correct.
You're the only person who had a knife.
Correct.
You had said earlier that you had waved for your friends to come over because you were so scared, right? Right?
During we're moving back in time now?
Well, yeah, earlier you had waved. We saw the
Yes.
video. You said
Yes.
you waved to your friends because
Yes.
you were scared. Your fear level was at whatever. And in fact, Ariel came over, right?
Yes.
And he's in the group at the point that Riley Madison's standing there bleeding into the river, right? He's standing
Yes.
right behind him.
Yep. Yep.
And at the time that you stabbed Tony Carlson, Ariel's right there, right in the group, correct?
I see that in the video, yes.
And when you stabbed Isaac Shuman, he's also standing there, right?
I didn't see him there at the time, but yes, in the video, yes.
So this narrative about it being 13-on-1, you had a friend there,
Objection,
right?
argumentative form.
Overruled.
Your friend was
I-
standing right there. He's in the
I-
video, right?
In the video. I don't remember him being there.
But you saw him coming, walking downstream.
I don't remember.
You waved for him, right?
I waved at my group.
At no point when you stabbed Tony, Riley, and Isaac, did you call out to your friend and say, hey, help me, they're attacking me, right? Even though he's in the frame and he's close to the action, so to speak. You never said that, right?
I was stunned. Couldn't talk.
He's fighting for his life. He should have sent an email. You never texted your friend, did you? Never took out your phone and sent them some emojis? Send them a help emoji?
The last person you stabbed was Dante Carlson, right?
Yes.
And this is in the sequence of events, everything else had happened, right?
Yes.
Objection as to form. I don't know what everything else.
Sustained.
All the other stabbings had already occurred, right? At the point that you stabbed Dante Carlson.
Yes.
He wasn't punching you at that point.
I was surrounded. People were coming at me. I just came up a couple of times, being punched in the head, punched in the mouth. I fell on river rocks. I was in pain. I was hurting.
Tony Carlson had broken up the fight between you and Dante never hit you again after that, did he?
Objection, that's.
Sustained form. Please rephrase.
At the point that you stabbed Dante Carlson, he was not fighting with you, right?
Correct.
He had not punched you immediately before you decided to stab him.
Correct.
In fact, you took a couple steps toward him to stab him, didn't you?
I thought he was attacking me.
So at that point, you stabbed 5 people and you decide to leave the area. Is that true?
I walked away.
You walked up to Ernesto, right?
Yes.
You didn't say anything about being attacked, right?
I was in shock.
You said they took my knife, right? To Ernesto?
I don't remember that, but that's what I said according to all the video and.
Well, if Ernesto said that, that's what you
Yes.
said.
Yeah.
You still got the knife on your person, right? Even though you just told them they took your knife, you still had it. Right?
No. When I reached the tubes?
No. When Ernesto came walking up and you walked up to him, you told him they took my knife. It's the first thing out of your mouth, right?
I don't remember that.
Okay. Instead of walking to your group, you walked up to the south shore of the lake, of the river, right?
Yes.
And on the way, you washed off the knife in the river.
I don't remember that.
Well, you had blood on your hand and on the knife, right?
Yes.
When you left the area, right?
Yeah.
When you got back to your group, nobody saw any blood on your hands, or right?
Objection, foundation. You didn't know what-
Sustained.
At some point, you rinsed your hand and the knife in the water, right?
I don't remember that. But yeah.
What you do remember is throwing the knife up into the bushes on the south bank.
Right on the bank, yes.
And then you finally walked over to your group, right?
As I was walking, I threw it away, yes.
No. You walked out of your way to get to the south bank to get rid of it, and then walked back across the river to your group, right?
Objection, argumentative.
Overruled.
That's what you did, right?
Yes.
We're going to play the video taken by Larry and Davis, Judge. It's grainy,
no.
but it's of some value.
Oh, not Larry and Davis. Larry and.
Do you have many more questions?
Yes.
Well, maybe this will be a good time to take a break. Let's recess and we'll come back at 2:50. Please take the jury out.
All rise for the jury.
Okay. Go. I'll do another poll.
We're in recess until 2:50.
Is it a 21?
All right, new poll up on YouTube.
Please
And
face
good
the clerk. Raise your
afternoon
right.
from our live.
Sorry, I'm going to stop that. Partway through cross. Good idea from you to testify? What do you think, folks? Options are terrible idea, it's a wash, and it's a good idea. So I'll leave that up for a few minutes. Take a look over at Q&A. Let's see. Let's see. Okay, that's about where I was. Law and self-defense member Philip. Yeah, so you can get your questions answered for free too, folks. If you're a law of self-defense member, sign up, lawofselfdefense.com/trial. Otherwise, it needs to be a $10 super chat. Are we back already? Oh, I think we are. Sorry, folks. Let me bring it back on in. That was I was a little bit behind because I'd paused it a few times to make commentary. But let me. Here we go. We're back from the break already.
Mr. Smestad.
Mr. Miu, I want to ask you some more questions about the stabbing of Dante Carlson. Is it fair to say that you did not know that Larry and Davis was recording that part of it?
No.
And you've seen that video here in court?
Yeah.
You are the person in the dark shorts, correct? In that video?
It was not very clear, so I couldn't make out who was who.
Right. If there's a person wearing dark shorts with the same body type as you in the video, is it you?
Fair.
Hold on. Sustained.
Well, we're going to watch the video. We're going to watch it through at full speed.
You guys remember this ridiculous video with the water damage camera? Can't see anything.
We're going to play part of it, but slower, but not the end part.
You're going to play it slower because that's how people
Ready.
experience.
What's the time? Yeah. This is at the very beginning.
Just say I can't
Mr.
make
Miu, do you
anything
see
out of that
yourself
video.
in the
I couldn't.
left-hand side foreground wearing the dark shorts? Where the cursor's pointed?
I can't make out.
You don't know if that's you?
No.
Did anyone else on the river have the same body shape that you had at the time?
Objection, no foundation.
Sustained.
What a pointless, what flailing by this prosecution. They were completely unprepared for this.
Been in court since the beginning of the trial, right?
Correct.
You've seen all these people testify,
Yes.
the people that were all involved in the incident, right?
Yes.
At the time that you stabbed these folks, there wasn't anybody else in that area of the river that had the same body shape as you, correct?
Objection. No
Objection, no foundation. He doesn't know that.
You're aware that Dante Carlson's wearing shorts that are black on the bottom and light gray on top, right?
That's what I learned.
Trying to go through it slowly.
Yes.
Again, the state is literally trying to make something from nothing here. I wish they were showing this water damaged camera footage. You can't see a damn thing. And how's this guy supposed to know? The river was awash with people. How's he supposed to know if there was some... You're telling me in Wisconsin, from what these prosecutors look like, it was impossible that there was another fat 52-year-old white
Objection
dude on the
sustained,
river?
lack of foundation.
In any event, after you got rid of the knife on the south side of the river, you walked back to the north side of the river where your group was in the at the sandbar, right?
Just to be clear, the judge shut this down. He shut down that part of their nonsense. Lack of foundation. Move on to the next question.
Yes.
Sat in your tube.
All that effort by the state for nothing, for nothing. And by the way, I see someone asked in the comments, is the state trying to tire out this defendant on the stand? Yeah, sure. Of course, they're trying to wear him down, mentally wear him down, see if he makes a mistake, something they can use in closing. You heard it from the defendant's own mouth.
Did you sit down in your tube?
Yeah.
Remember, Binger had Rittenhouse on cross for, if I recall correctly, 3.5 hours.
Yes.
Eric Williams from your group, realizing that people were hurt, left.
Objection, form, lack of foundation that Eric Williams.
Sustained.
Did you see Eric Williams leave your group?
No,
At some point, did you notice he wasn't with your group anymore?
I didn't do a head count, sir. Sorry.
Okay. Did anyone else from your tubes go to help with the folks on the river that were hurt?
No foundation.
Overruled. You can answer the question.
I don't remember. I wasn't paying attention to anybody in my group.
When you went back to your tube, you put your shirt back on, right?
I was cold. Yes.
And you put on your hat, right?
Yes.
And your sunglasses.
Yes.
Eventually, you saw police officers and emergency medical technicians show up on the river, right?
Yes.
Wading up the river, right?
Yes.
Trying to help people that had been injured, and
Objection, no foundation.
Overruled.
you saw that happen, right?
Yes.
You didn't approach anybody to say you were attacked, as far as law enforcement or EMTs or anything like that, right?
No, I just pooped myself. I was afraid to go in that area.
Even
I'm
though there's
sorry.
police presence everywhere, you were afraid to walk over there and tell them, hey, this is what happened.
Yes, sir.
So you got in your tube and you floated down the river.
Not immediately. We waited there. We had people, from what I learned, not that I remember, that called 911, and yeah, I don't remember any of that stuff. So I don't remember.
So do you remember waiting for Eric Williams to come back to join your group so you could leave?
I don't remember.
All right. Do you remember saying, let's go? You yourself saying that?
Objection asked and answered. Cumulative city.
Overruled. Overruled.
I don't remember.
Ernesto Torres, he's your best friend.
Yes.
You didn't tell him what happened as you were floating away?
I didn't talk to him. I don't remember talking to anybody. I don't even remember going down the river or up the river. I was just stunned. I don't remember anything.
You didn't tell Ernesto, I was afraid for my life and I did this?
No.
You never told Ernesto that I acted in self-defense?
I don't remember talking to anybody.
You didn't say I was afraid they were going to kill me, these folks?
Objection, no foundation. He said he doesn't.
Overruled.
I don't remember.
As you were leaving the area, you saw folks giving CPR to Isaac Shuman, right?
I didn't see that.
All right. Eventually, you made it down to Village Park where the exit was, right?
Eventually.
And there's some video of you relaxed in your tube, kind of playing in the water with your hand, right?
Objection is to form.
Sustained.
Do you remember seeing the video of you
I remember seeing the video.
relaxing in your tube before you got back to the end?
Objection is to form.
Sustained.
Did you see the video or not?
I said I did.
When you got to Village Park, your group exited the river, right?
Yes.
There was multiple police in the area, right?
Yes.
You saw a uniformed officer with his gun drawn, walking towards you, right? You didn't approach that officer.
I was afraid of everybody at
You were
that
afraid
time.
you were afraid of the officer?
I was afraid of anything and everybody. I was afraid of anything. I couldn't. I was still in shock, so I was afraid of everything. Yes.
You didn't approach the officer and say, they tried to kill me, I defended myself, nothing like that, right?
I don't remember saying anything like that to anybody.
You walked right by him, right?
By the way, folks, this is what happens when you literally say nothing to the police, right? All those people on the internet never talk to the police. That law professor has that YouTube video, right? Never speak to the police. He's got, I don't know, 150 million views in that video. But what happens when you literally don't talk to the police? I mean, at all. And I'm not telling you to talk to the police. In fact, in our upcoming Law of Self-Defense Advanced class, we spend just about an hour talking about interacting with the police in the aftermath of the use of force event. It's a more complicated subject than you might think. One option is literally say nothing to the police. Literally, not one word. Don't call them. Don't approach them. Nothing. That's what he did. That's what this defendant did. And how's the state using that against them? Right here. You see it.
All that is a blur. I don't remember it.
Once you got further up the path, though, other officers were able to pick you out of your group, right?
Apparently, yes.
They stopped you, right, before you could leave the park.
I don't remember that.
You don't remember the police stopping you and detaining you in the park after this incident?
I remember being stopped, but I don't remember the details.
Sure. You were aware that the police had a picture of you from the river, right?
Okay.
Do you remember that?
I don't remember.
Do you remember the police had to take your hat and glasses off to make sure that it was you in the picture?
Nope. I was focused on one thing only. Somebody with a bat that I've seen in the woods and across that whatever bridge, the little bridge, Rainbow Bridge, whatever. I was focused on him. I was very afraid of that person.
Did you ever say to an officer, hey, there's a guy over there with a bat and that's concerning me. Can you do something about it?
No.
You're put into a squad car, right?
Mm-hmm.
But yes?
Yes.
Sheriff Knudsen came over to make sure you were comfortable, right?
I saw that in the video, yes.
You don't remember talking to Sheriff Knudsen?
No.
You remember him asking you, well, if you don't remember, you don't remember. We're going to play that video and then I have some questions for you. Your Honor, this is the longer version of the video that's been referenced. It's 1 minute and 59 seconds.
Tell us when you're ready.
Camera recording started.
Still doing all right?
Yeah.
Okay.
What's going
Temperature's okay in here?
Yeah.
Okay.
I hear somebody got stabbed, and I fit the description.
Yes, you do. All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it?
Yeah, and I seen people gather around it.
Okay. All right.
And I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah.
Okay.
All
right.
So I don't know. Okay, well.
Did you see anybody injured?
No.
You didn't see anybody injured?
No.
Did you see anybody fighting?
I heard people screaming at each other, yes.
Okay.
Yeah.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say, I don't know, just screaming.
Okay.
You know, yeah, calling each other names. But, that's I've seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're doing, I don't know, kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Oh, I drove from Prior Lake.
From Prior Lake.
Yeah.
Okay.
Actually, we didn't drive it. We came here alone.
Your wife and you? And you met the group here?
Yeah, but we know each other.
Okay. All right. As long as the temperature's good, I'll check back with you in a minute, okay? Thank you.
Still got poop in his pants.
Right?
I don't remember that conversation, but yes.
You
I
told him that you heard there was a stabbing, right?
I don't remember any of this stuff.
You're fishing for information about what happened, right?
I don't know what you could say. I was fishing. I don't know.
You asked him some questions about what had happened, right?
Again, I don't remember this conversation.
But you were pretending that you didn't know what happened. Is that true?
No.
At the point that you're talking to Sheriff Knudsen and saying these things, you didn't know there was a video of what happened on the river, did you?
I didn't know whether I was dead or alive at that point.
But you also didn't know that there was a video, right?
No.
Best thing that ever happened to him was that video. Imagine if there
The
hadn't been a
sheriff
video.
asked you what had happened. One of your responses was it was kids being kids, right?
No. Mischaracterization.
I don't remember any of that conversation.
You just heard yourself say it on the video, though.
No.
Objection, no foundation.
I'll move on. Prior to being taken to jail, you were transferred from that squad car that you were in to a different squad car, right? Remember that? You remember at some point Deputy Thomason telling you that you were under arrest for homicide and attempted homicide?
I don't remember any of that.
When you spoke with Lieutenant HARD, even though you'd been informed that you were being arrested for homicide, you pretended to know that, to not be aware that someone had died, right? Right? When you were talking to Lieutenant HARD, you...
Over here at the jail?
Yeah.
I don't remember any of that conversation.
You don't recall pretending to not be aware that someone had died.
Objection assumes a fact.
Sustained.
When you're talking to Lieutenant HARD, that was about 4 hours after you had been arrested, right?
Yeah, that's what I learned.
And said you had time to put together a story, right?
No.
Overruled.
You had 4 hours to come up with a story about what happened on the river before you were interviewed by Lieutenant HARD, right?
No.
You didn't have that time.
I didn't put a story together.
Okay. So when you told her things like, 2 of these boys pulled knives on me, you're telling the truth?
No.
That was a story, right?
Correct.
And when you said that you somehow managed to grab one of the boys' arms and bend their wrist back and stab them with their own knife, that's a story you made up, right?
I told her what I remembered.
You remember doing that?
No, everything I told her is what I remembered at that time.
At the time you told her these things, you thought that you would grab someone's arm and stab them with their own knife?
As you can see, I was very confused.
Did you not testify earlier that you lied about the knife?
That I did.
And then nobody else had a knife on the river except for you.
That I lied about the knife.
So it's impossible then for you to have twisted someone's arm and stabbed them with their own knife, right?
I
Two
saw
different
the
issues.
video.
No, I'm asking what you said to Lieutenant Hart.
I don't remember the interview, but I saw the video. And
You're aware.
and I know that it's not right. It's not true.
Not just a couple of little lies, but lie on top of lie to Lieutenant Hart, right?
Argumentative.
Sustained.
Well, let's talk about some of the things you told her. You said these boys took the goggles off my head and threw them down the river, right? You told her that?
If that's what the video recorded, yes.
All right. You told her that these boys tried to pull down your shorts, right?
That's what I saw in the video, but I don't remember the interview.
That's a detail you added for your benefit, right?
No,
You said these boys attacked you, right? You told her that multiple times.
Well, they
Right.
did.
I saw the video.
Did you say that or not? Yes or
I
no?
said that in the video. Yes.
And you knew that wasn't true, right?
It is true. They
So-
did attack him.
In the video, I lied. I totally lied about the knife. I didn't remember a lot of details. I didn't remember of anything. I don't even remember the interview. I just looking at the video. I can look at it like anybody would look at it for the first time. I don't remember any of that.
You told Lieutenant Hart that these boys told you, don't run away from us. You remember saying that?
Objection, no foundation.
No,
In fact, it's just the opposite. They were telling you to go, right?
I don't remember.
You told her that a second boy had a knife, attacked you with the knife, and you took that from him, right?
That's what I saw in the video.
That's not true either, right? Right?
That's not true.
You said that when you walked back to your group, and this is talking to Lieutenant Hart, that Ernesto asked you if you had found the phone, right? You remember saying that to her?
I don't remember any of that conversation I had with her.
Yeah, that wasn't true either, right?
If this is all part of that interview, I don't remember anything.
Yeah.
So
That's what we're talking about. We're talking
Right.
about the interview with Lieutenant Hart.
then I don't remember the interview.
Okay, I still get to ask you questions about it.
Sure.
You were specifically asked, did you have a knife? Right? Do you remember being asked that?
I don't remember that, but I know I was.
Your
Really?
answer to Lieutenant Hart was no, no, absolutely no, right?
Right. Which I lied. I know I lied about the knife.
You said to her, why did they want to scare me with a knife? Right? Talking about the boys, I mean, the 17-year-olds. When none of them ever had a knife, right? Is that right?
Apparently not.
You said I grabbed it, meaning the knife, from him because he tried to poke me with it. Do you remember saying that?
Nope.
You said a woman hit you in the ear. Do you remember saying that?
Nope.
You know that's not true, right?
Objection, foundation.
Overruled.
You know that's not true as you sit here now, right?
Right.
You told the police and Lieutenant Hart, I think, that you thought it was two different groups of people fighting against each other, right?
I don't remember telling her that.
Right. You know, as you sit here today, that was completely made up, right?
Again, I don't remember any of that you're talking about right now, if it's about the interview.
You told Lieutenant Hart that you wanted to stay in the area and watch the police come and arrest these people for fighting, right? That's what you told Lieutenant Hart?
That's what's in the transcript, yes.
When you were told that a person had died, your response was, is it because they fought each other? That's what you told her, right? That's how you responded?
If it's in the transcript. But I don't remember.
You never told Lieutenant Hart that you punched or pushed or did anything to Maddie Cohen, right? You left that part out?
Is that what it's in there? Then
Asking if you ever told her that.
I don't remember.
You didn't mention that you had stabbed and severely injured another woman, Riley Madison. You didn't mention that to Lieutenant Hart, right?
Overruled.
You never mentioned that part.
I don't remember.
You didn't mention being strangled at any point, right?
If that's the transcript, then that we go by that, but I don't remember that interview.
And I think what you said earlier is that you were afraid you were going to die from being strangled, and that's why you stabbed Isaac Shuman in the heart, right? That was your testimony earlier? Didn't you say that today, this afternoon here in court?
Yes.
That's not anything you mentioned to any police officer, right?
If I didn't mention, I didn't mention it. I don't remember that.
That's not an important detail that you thought you might want to point out.
Objection argument.
Overruled.
Everything is every detail is important. We all know that. But I don't remember saying any of those things to Lieutenant Hart.
Because you didn't say them, right? That's why you don't remember.
Is what?
You didn't say those things to her. That's why you don't remember, correct?
I don't remember what I said or what I didn't say to her. I don't remember even having an interview with her.
So you can't remember anything about what you told her, but when Mr. Nelson's asking you questions, you can remember all these feelings you had at the time. Is that true?
Overruled.
Do you remember answering his questions about how you were feeling that day?
The feelings I had when I was attacked?
And when you were meeting with the Lieutenant Hart?
Objection, that's. Can you approach?
Yes.
Oops. I was adjusting the wrong volume. This is why I don't like the lawyers sitting down when they're asking questions of witnesses. I want them to stand up. This fat dude would be getting tired.
Objection
about
sustained.
now.
Please rephrase the question.
Objection sustained.
You testified today a lot about remembering what you were feeling that day, right? When Mr. Nelson was questioning you, right?
Mm-hmm.
Is that a yes?
Yes.
But when you're asked other details that might not be so useful, you don't remember them, right?
Certain feelings and certain, they stick to you forever.
Ones
They
that are
affect
helpful to your defense, those stick to you, right?
Objection argument.
Sustained.
You were examined by the jail nurse, the SART nurse, several hours after the incident, right?
Yes.
You never mentioned to her that you'd been strangled, right?
didn't mention to her a lot,
Sure.
not because I intentionally didn't want to do it. I didn't remember. I was still in shock.
You didn't mention anything about your throat hurting.
I don't remember what I mentioned to her.
I understand. You never at any point told anybody other than today that you had a sore throat or your throat was sore from after this incident, right?
You didn't tell anybody.
At any point during the day after you were arrested, when you're interviewed with people, when the jail or the SART nurse is talking to you, you never once said, oh, my throat is sore because Isaac Shuman strangled me, right?
I don't remember what I told those guys either. I was, like I said, I don't remember a lots of the interaction I had with anybody here at the jail.
But today,
I don't believe the defendants ever used the word strangle. I think that's just a fabrication by the state. Obviously, in the video, Isaac Shuman's hands are on this defendant's neck.
Yeah.
almost 2 years later, you remember that the next day your throat hurt. That's
Yes,
what you
because
testified.
yeah, and my back.
You can
still have-
remember that detail, but not the other details.
My back still hurts right now.
The SART nurse specifically asked you when she was doing the exam, where are you hurt? And you pointed out some things to her, right?
I may have.
Yeah, but you never once said, I had been strangled, I have an injury to my throat hurts, nothing like that.
Overruled.
I don't remember.
When she asked you what hurt, you said your butt hurt from the rocks. That was your response to the nurse, right?
Don't remember.
You had said that you're in poor health, or you were at least in poor health back on July 30th of 2022. You had had your bypass surgery 2 years prior to that, right?
Mhm.
Is that a yes?
Yes.
And typically people that have medical procedures like that are given restrictions on what they can do in their activities, right?
Yeah.
And you apparently weren't restricted from swimming, snorkeling, doing outdoor sports on a river, right?
I was for a while, but 2 years later, lots of the restrictions, I believe, got lifted.
Those restrictions got lifted because you got better, right?
You can say the doctor makes that decision, but he says if you feel a little better, do as much as you can.
Yeah, and you were in fact snorkeling and swimming and doing things that day, physical activities, right?
Snorkeling in 15 inches of water, I was mostly I didn't even snorkel. That was not a.
By the way, anyone who's ever been, snorkeling or scuba diving, it need not be a strenuous activity. I mean, most people who snorkel, they're just floating on the surface of the water. If you're scuba diving, and I am open water qualified scuba diver, Patty, if you're scuba diving, you're deliberately trying not to overexert yourself so your oxygen will last longer, so your air supply will last longer.
A lake but I was my whole plan for the day was to just float down the river and relax.
You're able to run, at least you were back on July 30th of 2022, right?
Run?
You were able to run at that time, right? You weren't restricted from running.
I mean,
You didn't have a medical restriction to keep you from running, right?
no.
And in fact, you did run when you ran up on Isaac Shuman's group, correct?
You call that run? Okay. That's not a run, but I wasn't running. I wasn't allowed to run or do any activities like that. So I wasn't running.
At the time that this all happened, July 30th,
It's running for
2022,
this fat prosecutor.
you felt sufficiently healthy to go off on your own, away from your wife and your group, to go do snorkeling on your own, right?
It's what I felt.
This is what the state has to work with? Obviously, this guy was Captain America.
I just want to check my notes. I think I'm almost done.
Somebody should ask this prosecutor, could you demonstrate this running thing you're talking about? Can you show us what that looks like?
We can have Exhibit 4, Item 10. I'm going to ask Investigator Schultz to actually handle it since it's evidence, physical evidence.
Can you retrieve the exhibit? Oh, it is now.
I think this is the knife, folks. So they don't want the they don't want the defendant to handle it. Last time he took out 5 people.
If investigator can approach the witness, Your Honor.
Yes.
We're showing you what's been marked as Exhibit 4, I guess Item 10. That's your knife, right?
Yes,
That's the knife you used to stab these people.
that's the knife I used to defend myself with. Yes.
Nice answer. Good answer.
I asked you earlier about when you stabbed Dante Carlson. You agreed that he was not attacking you at the point that you stabbed him. He was the last person stabbed, right?
He attacked me.
Earlier, when you stabbed him, Tony Carlson had already broke up the fight, right? You said you agreed to that earlier.
At that time, everybody that came in contact with me attacked me.
Anybody who looked at you?
No, anybody that came in contact with me, I felt attacked.
You felt attacked whether you're being physically attacked or not, right?
I was in the moment, so I felt attacked by anybody that had either previously attacked me or was approaching to attack me.
So you felt like you could stab folks who are not attacking you at the moment that you stabbed them.
Objection.
Sustained. Sustained.
You walked up to Dante Carlson and stabbed him in the belly, right?
I did not walk up to Dante Carlson and stab him in the belly.
I don't have any other questions, Your Honor.
Mr. Nelson?
Mr. Miu, you asked some questions about your fitness on July 30th. I want to ask.
All right. So the poll from earlier when we were partway through cross before the break. Partway through cross, good idea for Miu to testify. The results, terrible idea, 21%. It's a wash, 39%. Good idea, 40%. So 60% think it's a terrible idea or a wash, and that's not a good combination. They think it's I'd say 80%, 79% think it's a good idea or a wash. Yeah, I think so. I mean, most of what the state, what might superficially be perceived as having scored on this defendant, particularly the stuff, it was all really the stuff after the fact, right? The interaction with the police afterwards. None of that's actually relevant to the underlying claim of self-defense if you already have sufficient evidence to support the self-defense claim. And we do from the video. So if it was, again, I mentioned this earlier, but imagine a scenario in which there's no question it was lawful self-defense. And then the person who used the force is interviewed by the police and they lie their ass off. They give a fake name. They try to avoid being arrested. They fight arrest. They give false statements. They say it wasn't me, all this stuff. But there's video that makes it incontrovertible it was lawful self-defense. It's still lawful self-defense despite the lying later. The only place where the lying is relevant is where it's unclear whether it was lawful self-defense. Like in this case, if we didn't have the video, if all we had was this defendant's word against the word of the other participants, then his lying to the police would undermine his own credibility and undermine the evidence supporting self-defense. But it's not like the video made by Jawan Cockfield went to the police and lied. The video exists. It's objective. All right. So I'm going to end that poll. I'm not going to do a new one on this. I'll wait until redirect is done. So redirect this will be by Nelson, lead counsel. See, the defense went with their lead counsel for the direct questioning. Not so much the state. Okay, let me resize this. Come back here. I'll rewind it a little bit.
Stab him in the belly.
Okay.
I don't have any other questions, Your Honor.
Mr. Nelson?
Jimmy, if you asked some questions about your fitness on July 30th, I want to ask you some questions about that, okay? Just maybe we can get it done in one question. Did you feel fit enough to take on 13 teenagers and adults in a fight by yourself without a weapon?
I didn't. No.
You were asked some questions about what happened with each of these people, right? And you were shown some stills.
Mhm.
Were you in court when, do you know how many frames are in per second of these videos?
I learned they're like 24, 25.
So one frame is a 24th of a second, is that right?
Correct.
When you were in that, let me play the video. I'm going to play Exhibit 2.
Anybody remember from the Rittenhouse trial when Binger took the video of, I forget now, I think it was the shooting of the skateboard guy, but I could be mistaken about that. But it was one of those fights in the in the street there, and it all happened like in 2.5 seconds. It was all over. And Binger goes in front of the jury with this giant stack. He's printed out like every single frame, and he's doing frame 1, frame 2, frame 3, frame 4 to create the impression that Kyle Rittenhouse had like 15 minutes to make a decision. It's amazing how prosecutors will misuse this stuff.
Are you connected?
I think so. Before I am.
Anybody who can't understand why I'm comparing how things were done in this trial to another trial or a third trial or a fourth trial, I understand. And by definition, half the population has an IQ below 100. So I can't please everyone. This content that I produce is intended for the brighter than average person. If you're struggling, I'm sure there's, I don't know, some, wild country safari stuff to watch on YouTube.
Yeah, start over. I don't have anything on my monitor either.
That's not the screen I'm looking at, Judge. I apologize. My screen looks like that.
Screen is this, the library.
That was my. That's my home screen, but.
Yeah, well said. Law and crime is always available. I'm sure, and they're free too. It's
Let me take another chance here, Judge. Sorry.
This is a pretty typical size for a courtroom, folks. It's pretty normal. In big cities, they get a little bigger. And federal courtrooms can be huge, but for a local state trial court, this is pretty typical.
Right, wait, see what it looks like for a second. Okay, that's. I don't know, just maybe I need to take a break. I'm looking at my screen and it shows the video, so I apologize. I'm flummoxed.
This is Exhibit 2.
This is Exhibit 2. I want to play it from the 150 mark where you, for 14 seconds. So.
In the spirit of cooperation, are you able to use your exhibit?
Sure.
Oh my God. How awkward. So defense counsel Nelson wants to gut the state with this video clip. Can't get his working. So the judge is asking the state to use their copy. Oh, the irony. Like asking them if you can borrow their wife. Hey, make no mistake. If this, if the jury finds this defendant guilty, this judge is going to sentence him to forever time. Forever time.
The video, please. We can start the video at 150, just when he's. All right.
It's the
Before we
hyena.
press play, Mr. Miu. Do you see what's on the screen there at 149?
Queen of the river.
Yes.
Is that you falling backwards?
Yes.
I want to press play and ask him to stop it at 205, okay?
Okay.
Please press play.
He ain't a woman. He ain't a woman.
Did you observe those 16 seconds or so?
Yes.
Were you, if there's 24 frames a second and we watch for 16 seconds, as you sit here now, are you able to break down exactly what happened in each of those 284 frames? I mean, do you have a memory of
No.
1/24th of a second?
No,
For
absolutely not.
how, as far as time goes, if you can, and I apologize, but if you can, just put yourself back in that space for a moment.
Mhm.
Can you do that?
Yes.
When you're back in that space, on that river, in that time, did you seem like you had 284 different chances to do different things and feel different things?
No.
How did time feel in that moment?
It was not real. Everything was not real. Time wasn't following the same rules.
When you
slow, very slow.
Wrong answer.
When you said you didn't have a memory of some of the details, but you had a memory of the feelings, can you explain, how is that?
So feelings are brought on by what's happening, at least with me. If you get hit in the head, that's a feeling of hurt. If you fall back and you hit your head, you fall back on river rock and you get hurt, you feel pain. When you know you can't get away and you feel like you're drowning and there are people on top of you pounding you and holding you in the water, that's a timestamp in a filing cabinet that says, this is what I suffered.
Do you go ahead, sorry to interrupt you.
Yeah, it's something I would love to erase from my memory, but unfortunately, there are lots of those feelings, very strong feelings I can't erase.
How confident are you in the accuracy of your feelings?
I know my feelings. I lived with my feelings for 54 years.
How about this feeling? How confident are you in the accuracy of this feeling that you're
100% confident that is my feeling. 100% confident.
even if you can't remember the details of everything you saw?
Correct.
Even if you can't remember the details of everything you heard?
Right.
Let me, because there were some questions and I want to just make sure we cover it, right?
Mhm.
AJ Mark, do you remember each of these acts that you're charged with, each of these acts of stabbing?
No.
Do you remember the particulars, that is, I should say, the particulars of like X person did this or Y person did this or Z person did this?
No.
Do you remember, do you have any memory of just randomly stabbing people?
No.
What is your memory as to why you did what you did?
I was afraid for my life, and what I did, I had to do to defend myself.
Do you have a memory of stabbing anybody that didn't come towards you or attack you or touch you or push you or hit you?
No.
Did you ever just randomly go up and hit somebody?
No.
Do you have any memory of Tony Carlson trying to break anything up?
No.
Do you were asked about that, but I know there's some frames on that. Do you remember the frame in which Tony Carlson's coming up from behind and pushing you?
I didn't know who it was, but I remember being held in the water. I mean, it's a feeling that it gives me the nightmares, the trauma that was caused by that. That's the trauma that I remember.
There were asked some questions there at the end about the Larian Davis video. Could you make anything out in there?
No, I thought I was looking at Sasquatch.
Do you remember anything about Dante? Dante Carlson is the person on the video previously that we saw here that had hit you. You know that, correct?
Yeah.
And he's the person in those two-tone shorts, correct?
Yeah.
Do you have a memory of how it came to be that you defended yourself against him that's not on the Jawan Cockfield video?
No.
You remember him coming up to you?
I remember lots of people coming onto me. I couldn't distinguish who. I don't remember color of shorts or anything like that.
Did you ever swing or hit the knife out of anger?
No.
Why'd you use the knife?
Because I'm a mechanical engineer, I use it as a tool. But what I used it for that day, I used it to save my life for self-defense.
That's all.
Mr. Smestad?
So, Mr. Miu, we hear over and over again that there was 13 people there, and you're there by yourself, right?
Apparently, yes.
But we know that's not true because Ariel was behind you.
Objection.
Sustained.
13 people did not attack you, correct?
Looking at the evidence, correct. In the picture at the time, I didn't know that.
13 people were using words that you didn't like, right?
In action, right?
2 women touched you on your shoulders and arms, right?
They didn't just touch me on my shoulders and arms. You know that.
You were 250 pounds at the time, right?
Yes.
And these women touching your arms Caused you to fear for your life?
They're not touching.
Objection.
What's the objection?
That's not the evidence. That's not what he said.
Again, members of the jury, disregard what the attorneys say because what they say is not evidence. What the witness says is the evidence that you rely on. Next question.
Well, that
You
was the
said-
thing then. The next question.
The time slowed down for you on redirect, right? You said the
Told
rules
you.
didn't apply, time slowed down.
To me, at that time, everything felt different.
If time had slowed down, you would have time to consider your actions, right?
If it did slow down, yes. So I was wrong when I said it slowed down, but yes.
But that's what you said, right?
I understand.
You never told the SART nurse that you had been drowning, right?
Objection beyond the scope.
Overruled.
I don't remember what I told the doctor.
You ever told Lieutenant Hart that you had been drowning?
I don't remember.
Nothing further.
Thank you, Mr. Miu. You may sit back at the table.
And that's the end of Miu.
You need a few minutes.
Just a couple minutes, yes, please.
All right. Let's come back at 3:45. Please take the jury out.
All right, to the jury.
All right, I'll put a new poll up on YouTube. Whoops, that's not what I wanted. It's this other button. Now that Miu testimony is done. Let's see. Smart to have him testify. Wash. Let's see. Let me rephrase that. First choice, testimony helps. Self-defense claim. Wash, testimony hurt. Self-defense claim. Oops. So now that Miu testimony is over, testimony helped self-defense claim, wash, or testimony hurt self-defense claim. And that should be up on the YouTubes. There it is. Okay. I think in net it helped him. Or at worst was a wash. Again, most of the things where the state appeared to superficially score points is stuff that's not really relevant to the legal argument in the case. Yes, jurors can act irrationally. That's always a risk. It's up to the defense to oblige the jurors to spin the jurors a narrative of not guilty that's technically consistent with the law and consistent with a reasonable view of the evidence. Remember, the state has to disprove self-defense beyond a reasonable doubt. Always high risk. Always high risk to have your client testify. This was certainly not a train wreck for the defense by any stretch of the imagination. So, should we take a moment to step through once more? And we got another 1,000 people in here. It's crazy. Step through once more the actual legal analysis for self-defense in this case, using the five elements of self-defense. I'll do that now. Before I do, got to make a pitch for our sponsor, which is none other than Law of Self-Defense itself, in the form of our upcoming Law of Self-Defense advanced class. This is the one-day class taught live by me, streamed to you at your computer on Zoom, that teaches you everything you need to know to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. If Nicolae Miu had taken this class, he would not be in this situation. We teach you everything in a single day. This day is Saturday, April 20th. We only teach this class twice a year, folks. So if you miss this one, it'll be October at best before you can take it again. Do you know when you'll need this insight, expertise, and information to make legally sound self-defense decisions? Do you know when you'll be attacked? It's not up to you. That's up to the bad guy. The bad guy chooses the time, place, and manner of attack. Nicolae Miu did not think he was going to have a very bad day the morning of July 30th, 2022, but he did. Don't delay. Check out this course at lawofselfdefense.com/advanced. One of the things we talk about, among many, we talk about defense of self, defense of others, family, neighbors, colleagues, strangers, all different. We talk about defense of property, highly defensible property like your home, all along the spectrum to least defensible property. And you may be surprised to learn that your pets, who I know you feel are members of the family, just like the humans, your pets are actually least defensible property. We spend almost an hour talking about interacting with the police in the aftermath of a use of force event. We talk about consciousness of guilt evidence, some of which Nicolae Miu engaged in here. We talk about self-defense immunity. We talk about you developing a customized, legally sound self-defense strategy for yourself, and much, much more. If you go to that website, lawofselfdefense.com/advanced, you'll see we have a list of more than 100 very specific self-defense law questions we answer in plain English. And there's plenty of opportunity for Q&A in the course of the class. If you have a conflict for Saturday, April 20th, I understand spring is coming. Register anyway, because we'll make the playback of the class available for at least 2 weeks after the live class, so you can watch it at your leisure during that 2-week period. And this week, we're still in the pre-registration period, 50% off registration. Check it out, folks. lawofselfdefense.com/advanced. No different for service animals. When I say pets are least defensible property, I've searched and searched and searched, and I can find no difference for service animals. Sorry. If you have one, show me a statute, and I'll change my opinion. All right, so the 5 elements of self-defense, folks. Innocence, imminence, proportionality, avoidance, and reasonableness. These are the building blocks of self-defense in any American jurisdiction. These are the required elements for a claim of self-defense to be valid. Now, the good news is there's not 500 elements of self-defense. There's only the 5 elements of self-defense. Not that hard, right? Not rocket science. So the 5 elements themselves are not super complicated. What can get messy is the real world, right? A chaotic real world fact scenario. How do you apply the 5 elements to that? Well, we're going to apply it to this fact scenario. So in essence, innocence, the first of the 5 elements, means you can't have been the initial aggressor in the confrontation. If you are, you lose the element of innocence, you lose self-defense. Imminence means the threat you're defending yourself against is not a past threat that's over or a future threat that may never happen. It's either actually occurring in the moment or it's immediately about to occur. So a pulled back fist, for example, someone reaching for a gun in their waistband. You don't have to wait to get shot. You can defend yourself against the attack that's about to happen. Proportionality has to do with the degree of force involved. Generally, if you're only being threatened with non-deadly force, like a push or a shove or a typical punch, not a sustained beating, but a typical punch, that's a non-deadly force. You can only use non-deadly force in self-defense. You can't use deadly force in self-defense until you're facing a deadly force threat. Deadly force meaning it's likely, reasonably likely to cause death or serious bodily injury. Broken bone, loss of consciousness, maiming injury, rape would qualify. That's deadly force. Avoidance has to do with whether or not there's a legal duty to retreat before you can use force in self-defense. Very few states impose this element of avoidance as a blanket matter. There's only 11 duty to retreat states in the country where you have an absolute legal duty to retreat if safely possible before you can use deadly force in self-defense. 39 states are stand your ground states. Unfortunately, most of those 39 are what I call soft stand your ground states, meaning the prosecutor is not allowed to tell the jury they should deny you self-defense because you violated a legal duty to retreat. There is no legal duty to retreat in a soft stand your ground state. But the prosecutor can argue that, well, retreat was possible and you could have safely retreated and a reasonable person would have safely retreated. Therefore, your failure to retreat makes your conduct unreasonable. It's kind of a flanking attack on your failure to retreat, even when there's not an explicit legal duty to retreat. Wisconsin is a soft stand your ground state. So that argument is available. That's why the prosecution's allowed to keep talking about the fact, well, you could have stepped back. You could have walked away. In a hard stand your ground state, the jury's not allowed to consider the possibility of retreat at all. An example of that would be Texas. There's about 8 or 9 hard stand your ground states. But in those hard stand your ground states, the prosecutor is not allowed to make reference to the possibility that you could have retreated. But Wisconsin's not a hard stand your ground state. And then reasonableness. Two parts to reasonableness, subjective and objective. Subjective is you had a genuine good faith belief in the need to act in self-defense. And we saw the defense cover this aspect repeatedly in their direct examination of this defendant, that he had a subjective good faith belief in the need to act in self-defense. But that alone is not enough for self-defense, for reasonableness. That subjective good faith belief can't have been irrational or speculative. It has to have been objectively reasonable, meaning a reasonable and prudent person with the same capabilities and disabilities of the defendant in the same circumstances as the defendant, with the same knowledge, life experience, expertise, training as the defendant would have shared that subjective good faith belief in the need to act in self-defense. So, with all that spelled out, let's take a look at the facts here. Innocence. Who was the initial aggressor in the fight? And it's important to focus on the fight that matters. It's the fight that involves the criminal charges, meaning the stabbings. The murder one charge for the fatal stabbing and the attempted murder charges for the non-fatal stabbing. For the 4 non-fatal stabbings. This is the deadly force fight. The state may argue there was an earlier fight, that point where Miu runs up on the tubes and falls over, or grabs the tubes, or stumbles, whatever you want to believe, puts his hands on the tubes, makes contact with the legs of the high school football players. Maybe you believe that was an attack, that Miu actually committed a battery on those 2 young boys when he touched their legs. But even if you believe that, that's not the deadly force fight. And also, Miu walked away after that. So that fight was over. Now, if the state believed that was a battery on those children, they could have charged him with battery on a child. Did they do that? No, they didn't. So all that talk about him stumbling up to the tubes and grabbing onto the tubes and touching their legs, that's all nonsense. That has nothing to do with the criminal charges in this case. The criminal charges are all killing or attempted killing charges. They're deadly force charges. So who started the deadly force fight? Well, we have that interaction with Ms. Cohen, the screaming hyena, with the beer in one hand and the vape in the other and the cell phone in her bathing suit top. She's in the defendant's face. Riley Madison is in the defendant's face, screaming at him, shouting at him. There's no reason happening here. Pointing down the river, and they put hands on him. That's a battery. That's a simple battery. Again, a non-deadly force attack. He's allowed to use non-deadly force to defend himself against that attack. Is he allowed to push them away out of his space, stop them from touching, pushing, pulling, squeezing on him? Yes, he's allowed to raise his hand to push them away. So that use of his hand on Madison Cohen, is it Madison? I keep getting it mixed up. Someone remind me. Last time I got it wrong. Madison. It is Madison. Madison Cohen. Lawful. That's a lawful use of non-deadly force to stop her and Riley from committing battery on him. The response was for him to get punched in the face and knocked down into the water. And you could argue that's a non-deadly force response to him touching Madison Cohen. Fair enough. I mean, you have to remember, maybe the person who threw the punch didn't know that Madison had touched the defendant first. If the young men had stopped there, if they punched this defendant in the face, knocked him into the water, and stopped there, we wouldn't be dealing with any of this, right? The fight would be over. Just like if Trayvon Martin had punched George Zimmerman in the face and knocked him down and stopped there, Trayvon Martin very likely would have had a valid self-defense claim for that use of force on George Zimmerman. But Trayvon Martin didn't stop there. Trayvon Martin mounted the knockdown George Zimmerman and beat his head into the sidewalk. That's a deadly force attack, sustained beating. Zimmerman was screaming for help for long periods of time. No one was coming to help him, with his head getting smashed on the cement. And people say Trayvon Martin wasn't armed. He was armed. He was armed with his fists, with the sidewalk, and the gravity of the planet Earth that let him keep George Zimmerman in a mounted position below him. And that's why George Zimmerman was privileged to use deadly defensive force, because he was getting beaten to death. The blows to his head from the front and the fists and the back and the sidewalk were likely to cause death or serious bodily injury. That was the testimony by expert medical witnesses at trial. Here, when the fight doesn't stop there, when not only is this defendant knocked on his ass in the water, hits his head on a rock, then another person puts hands on him to push him down into the water. Then he's punched 2 more times in the face while he's face down in the water. Now that's a deadly force attack. Now he's facing a reasonably perceived imminent threat of deadly force in that attack. And that's when he becomes justified in using the knife to defend himself. Now, did he have the knife out before this? Yes. Was he stabbing anybody with it? No. He's not stabbing anybody until a reasonable and prudent person in his condition and circumstances would perceive that he was facing an imminent threat of death or serious bodily injury at the hands of those collected group of cooperatively acting 13 people against just him. Do all those people actually attack him? No. Are the only people he stabs people who actually go hands-on with him? Yes. He's facing an actual ongoing deadly force attack. So, in terms of innocence, who launches the deadly force attack? Who's the initial unlawful deadly force aggressor? It's the people attacking Miu. It's that punch to the head, the pushing down in the water, the sustained blows. Only after that does his knife come into play. So they are the unlawful initial deadly force aggressors. The element of innocence is on Miu's side. Imminence. Was this a fight that was over when he was stabbing? No. It's a fight that was actually occurring. In fact, the moment it was over, he stopped stabbing people. So the element of imminence on the defendant's side. Proportionality, we already covered. This was reasonably perceived as a deadly force attack on him, justifying his privilege to use deadly defensive force. So proportionality on the defendant's side. The element of avoidance. There was no possibility for avoidance here. Once he's under attack, deadly force attack and using the knife, all the people, it all happens within a minute or so. Everyone stabbed is coming at him right then. And he's a 52-year-old quadruple bypass patient, way out of weight, walking in a hard-to-walk-on rocky riverbed through a foot or so of water. And the people fighting him are 17-year-old high school football players and 20-year-old young men, half his age. Obviously not afraid to fight him. They're coming at him to strike blows, everyone he stabs. So avoidance would not, there was no circumstance under which avoidance would have been safely possible. So even if Wisconsin were a duty to retreat state, the duty only applies if you can retreat with complete safety. He could not have retreated with complete safety here. So avoidance, again, checked for the defendant. Reasonableness. Did he have a subjective, genuine, good faith belief in the need to act in self-defense? We don't have mind-reading machines, so we can only go by his conduct and testimony and decide whether it's credible. The facts I see would have led me to have a genuine good faith belief in the need to act in self-defense as he did. Was that belief objectively reasonable? Would a reasonable, hypothetical, reasonable and prudent 52-year-old quadruple bypass patient, out of shape, alone, facing 13 hostile aggressors who've now first committed a simple battery on him, then punched him in the head, knocked him in the water where he hit his head on stones in the water, pushed on his back face down into the water, hit him 2 more times while he's in that vulnerable position? Would a reasonable person in those circumstances in his condition have perceived that he was facing a deadly force attack? I think yes. So reasonableness also on the defendant's side. So all 5 of these elements are robustly on the defendant's side to justify his use of that knife in self-defense. In a context where the burden is on the state to disprove self-defense beyond any reasonable doubt, I see 0 possibility of that happening here if we have a good closing by the defense. The defense has to weave a narrative, a story for the jury where they lay all this out in the context of the technical law of self-defense in Wisconsin and the facts of the case as credibly presented in this trial. You need to give the jury a story they can agree with. In this case, by the defense, a story of not guilty. And of course, the state will be trying to do the same on the other side. So the defense needs to do a good job on closing. They did a good job on opening, so I have every reason to believe they'll do a good job on closing. The defense, it did. The states looked very unimpressive the entire trial, so I don't have great hopes for them having a home run closing argument at trial. I expect them to talk about a lot of things that don't matter, like Miu falling on the tubes, touching the boy's legs. He could have walked away. It's all nonsense. A good closing, and if we have a rational jury. Juries are dangerous and unpredictable creatures. That's why I don't predict verdicts in criminal trials. All I can do is lay out the legal analysis as I see it, what I think would be the just outcome in the trial, which in this case is clearly not guilty. But juries come back with crazy verdicts. It's always possible this guy gets convicted. The makeup of the jury, I can touch upon that again if I saved it. I think I did. Let's see. The makeup of the jury, according to this graphic, right now we have 14 because there's 2 alternates who will be dismissed. 8 of those are men, 6 of those are women, but look at that age breakdown. 8 of the jurors are 50 years of age, so this defendant's age or older. How many of them do you think would want to be in this circumstance? Facing 13, mostly men, 17-year-old high school football players, and young men, 20 years old, 24 years old, half their age, 13 of them on a river, and fight to defend themselves without resorting to deadly force. So that's those guys are going to see themselves in this defendant. Even if 2 of those get dismissed as alternates, that's still half the jury that's 50 or older. One of them at 90. I know, it's quite remarkable. So let me take a quick look at chat. If I can find my chat. Yeah, I was thoroughly unimpressed by that state closing. Sometimes you're blessed and the prosecutors are no good. They don't appear to me to be very strong here. Yeah, Will Parker points out the only purpose for much of the questioning by the state was to frustrate the defendant, to get him to lose his composure. And that's true. They're trying to provoke you to some kind of outburst. The state obviously badly mischaracterized the evidence repeatedly. Prosecutors slowing the event down with all their frames like Binger did in the Rittenhouse trial. I pointed that out. We had a low IQ response in the YouTube chat, of course. Yeah, I don't know why the defense didn't play the whole video again. I would have played it with freeze frames. Let me pick the freeze frames. So you hear the noise, hear the shouting, hear the taunting, hear the pedophile, hear all that. Freeze. Every time hands go on. Maybe they'll do that on closing. That'll be nice. This person, hands on, right here. This person, hands on. This person, hands on. Everyone who got stabbed, put hands on this defendant. Let's see. Tony says, I wonder if Mr. Miu ever trained at ShivWorks. ShivWorks is Greg. Oh, good heavens. What's Greg's last name? Greg Douglas. Former cop, does a lot of force-on-force training. I know Greg personally. He does a fantastic job. If you can take any training with Greg Douglas is well worth taking. His force-on-force training is exceptional. A lot of places now do force-on-force. Most of them do it poorly. He's also got a custom brand of knives out, knife training, fixed blade knives. I own a couple of those. Does great work. Highly recommended. I don't know what he thinks of me. I have a mixed reputation in the self-defense community because I'm somewhat disagreeable. But I don't care what other people think of me. I care what I think of them. And I think Greg does great work. Let's see. Yeah, I think, I say there's a risk to putting the defendant on the witness stand, and there is, but there's also a risk to not doing it, right? I mean, look at Zachariah Anderson. That trial, he didn't take the stand, he got convicted in a pretty sketchy trial, a pretty sketchy prosecution. That the prosecutor there was at least as sketchy as these, and in many ways much worse, in my opinion. Would that outcome have been different if Zachariah Anderson had taken the witness stand? I mean, I don't know, but I think often if you've killed someone, and here we have a defendant who's killed one person and stabbed 4 others, some of them pretty bad, and you're claiming, hey, I'm just a normal dude who was defending myself. Often the jury wants to hear from you. They want to hear, all right, well, listen, maybe there's a good reason why you killed a 17-year-old, but we need to hear it from you. So he certainly did not just grab his knife and go charging after children, for sure. All right, let me see if there's any super chats that need to be addressed. Super chats need to be $10 or more, folks. I don't know why you would do that. I discourage you from doing that. I would suggest that instead you become a law self-defense member for 99 cents. Get all your questions answered for free. But that's up to you. Looks like there's a couple. Susie, I think this is from earlier today. What's your opinion so far? I just did my analysis breakdown on that. In fact, I should make a timestamp. Yeah, that's okay. I got a timestamp from when they ended. Alex, what's the likelihood of a threat resulting in your end SBH required before you can use deadly force in self-defense? Can you use deadly force to prevent a 10% chance they hurt? Oh, SBH, serious bodily injury. 25%, 50%. You need to be facing an imminent prospect of serious bodily injury. It just can't be completely speculative, right? Some people like to say, well, I've seen videos where a person is punched once and they fall over and hit their head, get knocked unconscious, fall over, hit their head and die. That means punches are deadly force. No, because what the courts look like is what typically happens. And those outcomes are very rare for a single thrown punch. So it doesn't get that complicated. I wouldn't bother breaking it into percentages. Is it reasonably likely to cause you death or serious bodily injury, loss of consciousness, maiming injury, blindness, inability for you to defend yourself, rape? Some states do provide a statutory definition. They'll list a whole bunch of things like that. But then there's always a catch-all as well. And some states don't define it. They just say serious bodily injury, and then they leave it up to the appellate courts in their opinions to define it. But if the risk of serious bodily injury is 1%, it's almost certainly going to be treated as entirely speculative by the courts and not realistic. Swissgar 2322, $20 super chat. Thank you so much. Do you think this would be a good close? This is what the state wants you to see. Show still frames. This is what happened. Play the video start to finish. What part of that do they not want you to see? Yeah, I think phrasing it that way would be fine. Again, what I'd really like to see is the entire video with freeze frames every time someone goes hands-on. I think that would be pretty compelling. All right. Let me see what's going on in court, shall I? All right, so I don't think anything's happening in court. I think they're still on a break. Oh, I think I had stopped before that. All right, so all right, so they're doing some jury instruction chatter. Let's listen to what they have to say here. This is right after Miu got off the stand. Before I paused it.
Please be seated. We are outside.
Actually, before that, I see something in the comments. People often ask me, they'll say, Andrew, should I have video of my self-defense shooting? Is it good if there's video of my acting in self-defense? And the answer is, well, the video is good if it's good. The video is good if you did it right and it captures that. If you did it wrong and the video captures you doing it wrong, then the video is harmful. I mean, it seems obvious, but that's how to look at it. In this case, this defendant would be in a lot of trouble were it not for this Jawan Cockfield video. And Jawan Cockfield was one of his antagonists. So the video that saves this defendant is from his enemies. The irony. But it's helpful to him because it shows him doing it right.
The presence of the jury, Mr. Nelson, Mr. Trapacy, do you have anything else concerning the evidence? Motions?
Yes, Judge, we would renew the motion that we'd made before. The arguments are the same. I believe the burden is different. And so if Your Honor wants additional arguments, the facts haven't really changed. It's just the burden has.
I think the burden is the same, but the evidence that I can consider has expanded, correct? I can consider the entire body of the evidence, not just what the state offered.
Fair enough.
All right. Mr. Anderson, is there anything that you want to add?
No.
All right. Again, that motion is denied. I stand by my earlier rulings. I think the evidence that has been presented thus far is sufficient to warrant this case going to the jury. This morning, I handed the attorneys rough draft number.
Oh, so the defense wanted a directed verdict without the case going to the jury, that no reasonable jury could conclude guilty on this evidence. They had done that when the state closed. I'm making inferences here, so based on what was said from my experience. Because the judge said, well, they said, we're renewing our motion. And the judge said, well, now I can consider your evidence, your case in chief evidence, as well as the state's. What that tells me is they made this motion for a directed verdict when the state rested. And at that point, pretty much the only evidence in the case was the state evidence. So that's all the judge would be able to consider. He denied that motion. So he compelled the defense to put on their case in chief. Now that the defense case in chief is over, they've renewed the motion. They'd like a directed verdict again. Now the judge can consider both the state's evidence and the defense evidence, and he still denies the directed verdict. And I think appropriately so. So this is going to the jury for sure. You never get a directed verdict, virtually never.
Number 3 of the jury instructions. Have you had an opportunity to look at it, or do you need some time?
I need some time.
How much time?
Me too, Judge. I haven't looked at a page of it.
Are we going on the record or not?
Well, I'd really like to get it done if we could. I don't know how much time you need.
I haven't even looked at it. I apologize, but obviously it's been a full day. And so there are 29 pages, you know, give me till at least 4:15.
Will that be enough time for you?
Well, I'm going to defer to Mr. Anderson. He's looked at them a little closer than I have.
Should be, Judge. I know that the one, it doesn't need to be lengthy, but I think would be appropriate is something on defense of others, because there's testimony that Dante and AJ were defending or responding to Miu punching Maddie when they responded. So
okay. Let me just kind of recap where I think we are. I had initiated a rough draft of the jury instructions. It includes instructions that I knew were going to be required.
That makes no sense at all. What the state just said makes no sense at all on the jury, on the charges here. The state wants jury instructions on defense of others, arguing that Dante and AJ struck the defendant because they perceived the defendant had punched Madison. That could very well be true. What's that got to do with anything to do with this defendant? This defendant's self-defense justification is not dependent on what Dante and AJ thought they were doing or whether they might have been justified in what they're doing. This defendant's justification is based on his reasonable perception of what was going on. Dante and AJ could have been completely justified in punching him. That doesn't change the self-defense argument for this defendant. Both sides can be right in a self-defense case. Both sides of the fight can be right. It could be self-defense for both of them based on perceptions. But the only self-defense analysis that matters is the person who's charged. Dante and AJ are not charged with crimes in this case. They don't need a defense of others instruction. So why would you give that to the jury? That's crazy. By the way, there's 29 pages of instructions. And I'm looking at the clock here in the courtroom. It says about 10 minutes to 4, and they just asked until 4:15. And you might think, how do you review 29 pages of jury instructions in 25 minutes? Well, of course you don't. They've all been working on this case for a couple of years. They should have these jury instructions memorized. They are standardized jury instructions. I went over them in the first day I covered this trial. If we get a break in the proceedings, maybe not today, maybe tomorrow morning, I'll start up and go over the relevant jury instructions again. Because, of course, I have the standardized jury instructions for criminal trials in Wisconsin. Or maybe they'll publish the ones they're actually using, which should be identical to mine, just customized with the parties' names and so forth. Yeah, I'll probably go over those jury instructions tomorrow again.
Required, ones that I anticipated the attorneys would want, and instructions I thought the evidence would justify. The attorneys and I have discussed the draft. We spoke most recently yesterday. There were some areas where I needed input. I got the input. In the draft you have now, it reflects the changes that we had discussed yesterday.
I would absolutely object to any defense of other instruction relevant to Dante and AJ, because the risk is that the jury might see that and decide that if Dante and AJ were in the right, that means this defendant must have been in the wrong. That's not the proper legal analysis here. Whether or not they were in the right is irrelevant to the criminal charges against this defendant. And it's just, it risks the jury being fundamentally misled on their responsibilities in arriving at a verdict here.
Yesterday. The areas that are in red are areas that remain unresolved from yesterday or were added based on Mr. Anderson's submission late yesterday regarding the lesser included charges for counts 2 through 5. So it should look familiar to everybody with the exception of the portions in red.
So lesser included charges. I guess we should talk about that. Lesser included charges are charges that are almost identical to the highest charge, but have fewer elements. So, for example, murder might be the intentional unlawful killing of another person. Manslaughter might be the unintentional unlawful killing of another person. So the state might charge you with murder. They may say, we're going to prove that you intentionally unlawfully killed someone. But at the end of the trial, the jury's not convinced it was intentional. They're convinced that you unlawfully killed another person, but not intentionally. They think you did it recklessly, or criminal negligence, as some states call it. In that case, although you were charged with murder, the jury is allowed to consider the lesser included charge of manslaughter. Manslaughter is just murder without the intent. So if that intent element is missing or not proven beyond a reasonable doubt, they can't convict you of murder. Intent's a necessary element, a required element of murder, but they can still convict you of the lesser included charge of manslaughter because manslaughter doesn't require the killing to have been intentional. Does that make sense? And often a charge like murder could have a whole cascade of lesser included offenses, not just murder, manslaughter, aggravated battery, simple battery, a whole variety of things. States vary on how explicit the prosecutor has to be about the lesser included. Some want the lesser included explicitly stated. So you have to tell the defense, hey, we're going for murder, but we're also going for manslaughter if we can't sell the jury on murder. But most states, it's listed in the law what the lesser includeds are. So they expect defense to know, hey, if your client's charged with murder, you're on notice that you also need to be prepared for manslaughter, for aggravated battery, whatever. So here at the end of the trial now, the state's offering up, saying, hey, we want the jury to consider some lesser included, so we want to make sure they get the jury instruction on that.
Just give me a better understanding about the defense.
To give you an example of how extreme this can get, when George Zimmerman killed Trayvon Martin, he was charged with second-degree malice murder under Florida law, the highest level of murder under capital murder, below capital murder. And the state did such a bad job in that case because the law and the facts were so clearly against them. When they got to the end of the trial, they actually tried to convince the judge that the judge should include as a lesser included assault on a minor, because Trayvon Martin was 17 years old. So they said, well, he's a child, and even if you don't believe this was an unlawful killing, at the very least, it was assault on a minor. Miraculously, that Judge Deborah Nelson, who was very hostile to the defense in the Zimmerman trial, declined to bring that jury instruction. Often when the state's arguing for lesser included, it's because they lack confidence in the primary charge, lack confidence that they can get a conviction beyond a reasonable doubt, and or they're hoping for a compromise verdict. So they're hoping, you got 12 jurors, maybe a couple of them think it was murder, a couple of them think it's an acquittal, they can't agree, they argue for enough days that they all get tired, and they agree to compromise on one of the middle charges, one of the lesser included charges.
Defense of others instruction, how you see it fitting in, where do you want it?
So the testimony from Dante and AJ was they saw Miu punch Maddie, so they were defending her. So I think the jury should be able to know that not only is it legal, is self-defense legal when justified, so defense of others.
Completely irrelevant.
What's your reaction, Mr. Trofasi?
Never heard of an affirmative defense being given in a criminal case for
a witness.
Victim. And I haven't looked at it. It strikes me as completely convoluting everything we're doing. But I would need to know, are they saying that gets rid of the right of self-defense? I don't know what it means in terms of how the jury is supposed to consider that evidence. If they consider that, are they saying, if you find it's defense of others, then self-defense doesn't apply? I don't think it strikes as self-defense.
Yeah. Mr. Anderson, how does it fit into your argument?
I think when I was reading this before, I think there's a spot where it could be added in.
So this is this is what the state's hoping for, of course. As I said, if the jury decides that it was defense of others, the Dante and AJ attack on the defendant, that means the defendant's claim of self-defense goes away. That's not the law. That's not the law, and that's what Corey, frankly, without as much energy as he should have brought right here, that's what Corey is trying to point out. How would this even work here? Because just because they think they were acting in defense of others, even if they were legitimately acting in defense of others, that has nothing to do with our client's claim of self-defense.
Very succinctly, but I just want to be able to tell the jury.
Either this prosecutor is a complete dunderhead and actually believes what he's saying, or it's just grotesque obfuscation of the law.
That when you have these jury instructions in Wisconsin, it's legal to come to the aid of others, and that's exactly what Dante.
But they're not charged. Dante and AJ are not charged in this case.
It also intertwines with.
But has it reflect on Mr. Miu's guilt or not guilt?
His provocation is what responded them to come to the defense of Maddie, and then he starts stabbing people. And they had a legal right to come to her defense under the theory of defense of others.
So, if I may, Judge.
One question. Are you proposing the pattern instruction, or do you have something custom made?
I think it could be more succinct. I could come back with a.
Yeah, why don't you do that so that we're all looking at the same language? What did you want to add?
The only way, again, I agree with Mr. Trofsey, I just don't see how this comes in. The only way would be as it comes in under that red paragraph on page 3 under provocation in some way, but then it doesn't make sense because the issue is whether Mr. Miu's conduct was unlawful.
Right.
Whether Dante Carlson's conduct was lawful or unlawful has no bearing whatsoever on whether provocation occurred, and whether Mr. Carlson or AJ Martin's behavior is lawful or defensive of others. That has no bearing on Mr. Miu's beliefs or the reasonableness
Correct.
of his beliefs, because there's zero evidence that has been presented that Mr. Miu had any impression, understanding, or knowledge.
Now you're
that
complicating
what
it.
was done to him was legally the defense of others. And so it's irrelevant, it's prejudicial, it's confusing, it has nothing to do with
Reversible
Mr. Miu's
error.
beliefs, which this entire case is about.
Let's put it on hold. Give me the proposed language that you want to have me consider. I'll give you 20 minutes to review the most recent draft. I'd like to, if we could.
This judge has been pretty smart so far. I hope he doesn't choke on it here. This would be ridiculous.
But I'd like to finish the instruction conference today so that we can come in fresh tomorrow morning. But if the clock prevents us from doing so, we may have to adjourn it till tomorrow morning. So we'll reconvene at 4:15.
And are we on the record at 4:15 or are we?
That's my intention, yes. Yeah.
This is not a complicated legal question. That defense of other jury instruction has no role in this trial. For what? For what purpose? Dante and AJ are not being prosecuted in this case. They don't need a defense of others legal justification jury instruction. All right, let's see where we are. Did we come back today? By the way, that's Eric Nelson right there. Eric Nelson was Derek Chauvin's attorney. He did a good job there. Of course, the defense was doomed because of the politics around the case. Did a good job. Should have had more help. He was overwhelmed by talk about 13-1. I think there were 13 lawyers on the state side against Eric Nelson. Okay, let's see. Maybe we're back here.
Which lesser included?
I'm satisfied with the ones in the draft instruction.
Sorry,
Yes,
I just want to make sure I don't miss any.
Stressful. It's stressful. Just stressful listening to you answer the question. I want to get you back to Judge Michael Waterman's courtroom. They are back in session.
Yes.
Let's listen in.
Are either of the parties requesting lesser included offenses?
Yes.
Okay. I'm sorry, I missed that. Yes by the state, no by the defense. Mr. Anderson, which lesser included?
So the state's asking for lesser included because they lack confidence in their ability to get the murder conviction. So they're hoping the jury will settle on a lesser included. The defense does not want a lesser included because they have confidence they can convince the jury that the state has not met its burden beyond a reasonable doubt for murder, and they don't want the jury to have an option to compromise on a lesser included.
I'm satisfied with the ones in the draft instructions, Judge.
Okay. So I want to make sure we're clear on the record here. You're requesting lesser included for count 1 to include second degree intentional homicide, first degree reckless homicide, second degree reckless homicide.
Correct.
Then for counts 2, 3, 4, and 5, you're requesting lesser included for attempted second degree homicide, for first degree recklessly endangering safety, and second degree recklessly endangering safety.
Correct.
Mr. Nelson, any comment?
We object.
Any basis?
Below on the facts. I mean, I don't want to try to be efficient here, but I don't think it's supported by the facts that have been presented here. Certainly as to, I understand count 1, second degree. We prefer not, but I don't think there's a basis in law or fact for me to make an argument that he doesn't get second degree intentional. As to count 1, first degree reckless, I don't think that there is a basis in fact that there is any evidence that it was utter disregard for human life in this situation where the person, Mr. Shuman, died instantly. So for those reasons, so we object to first degree reckless.
That's the wrong argument. It doesn't have anything to do with Shuman dying instantly. It doesn't matter if it would have taken a week for Shuman to die. The issue is that first degree homicide and second degree homicide is an intentional killing. Reckless homicide is an unintentional killing. You did it recklessly. You created an unjustified risk of death to others without intending anyone to die. And they died as a result. The classic example would be a drunk driving homicide. So you're at the bar, you get drunk, you get behind the wheel of your car, you're driving home. You're not intending to kill anybody. You're just intending to get home. But you know, when you get behind the wheel drunk, you're creating an unjustified risk of death to others. If you then run somebody over unintentionally and kill them, that would be a reckless homicide, unintentional homicide. There's zero evidence in this case that this killing of Isaac Shuman was unintentional. None. So if there's zero evidence it was unintentional, the only options left are it was intentional and either it was justified or not. So I can see how you might get to second degree homicide, but I don't see how you get to anything having to do with reckless. There's no evidence of recklessness on the facts in this record.
As to count one. Let me go through the other count.
I have to say, these defense lawyers are being much calmer than I would be. The jury instructions are everything.
Should we just deal with count one first?
Now go through the other counts.
As to counts 2 through 5, again, I understand that second degree intentional is a lesser included of first degree intentional. So I'm not objecting to that. While we prefer that it not be offered, I agree that there's a factual and legal basis for it. As to the reckless endangerment, first degree reckless endangerment. Again,
Same argument.
no evidence that it was utter disregard. I believe in these cases, I do concede that the case law that I've seen supports the fact that reckless endangerment is a lesser included of attempted homicide.
Mr. Anderson.
So basically, both the state and defense are entitled to ask for a lesser included offense, and it's error for the court not to include lesser included offenses as long as there's a basis.
A basis, right?
A jury could conclude that although he was reckless in stabbing these people, he didn't actually have the intent to kill them. Hence,
Where's the evidence of
charges.
recklessness?
The self-defense is still at issue in all of them, but I think it's appropriate to have the lesser included.
My understanding of the law is that either party may make a request for lesser included. One party's decision to request lesser included cannot be challenged by the other party. So here the state is making the request. It's entitled to the instruction as long as the evidence supports it. In my judgment, the crimes that are being requested as lesser included are in fact all lesser included offenses. The homicides in count 1, the lesser degree of homicide certainly are. Same with the attempted homicides in counts 2 through 5. There's also a case law that says that the reckless conduct for each of the classes of offenses are lesser included. So I'm satisfied that the charges themselves are lesser included offenses. I'm also satisfied that the facts support the lesser included crimes that have been requested. I think Mr. Anderson's assessment is correct, that the jury could conclude that Mr. Miu did not have the intent to kill, but he did engage in reckless conduct by indiscriminately jabbing and swinging his knife around people. He testified today that he really didn't know what was going on, didn't know who was hitting him, didn't know where people were necessarily. It all happened very fast. Yet the knife was used in a way that would show utter disregard for human life. It was certainly reckless in nature. When considering utter disregard for human life, there are a number of factors to consider. What he was doing, why he was engaged in the conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. Again, we have a man who is using a knife in a dangerous way, indiscriminately brandishing it against others. Others were injured. Mr. Miu left the scene, left the wounded behind.
He's screwed if he gets convicted. This judge is going to hit him with everything. This is nonsense. So now the judge is talking about him leaving the scene and leaving the wounded behind. What's that got to do with recklessness? It's got nothing to do with recklessness.
After a delay, he tubed past them without rendering aid, without notifying police what happened. I think those are all facts that one could conclude are utter disregard for human life. So I'm satisfied that the facts support each of the lesser included instructions that have been.
And the judge just gave a blueprint to the state for how to argue their closing on these recklessness charges. Well, of course, he's also put the defense on notice. This is the argument you can expect from the state. This is what the state's going to talk about now, not the self-defense. He left the scene. He didn't provide aid. What's that got to do with his use of force? I did not expect this from this judge.
Been requested by the state. All right. What I'd like to do is walk through the instructions that I have. If there's an objection or something that you think warrants discussion, please stop me, and then we can have a conversation about it. I intend to issue 100 opening instructions, 145 information, not evidence, 1017 first degree intentional homicide with self-defense, and the 3 lesser includeds that I mentioned.
I do have objections about that, just I'm not sure when you want to.
Yes. What's the objection?
On page 3, I don't have an objection to 1017 in general, Judge, just some of the wording within 1017. On page 3, the first paragraph, the definition of great bodily harm is included based upon our request. We're comfortable with great bodily harm means other serious permanent bodily injury, as opposed to the entire definition. My understanding, the state wants the entire definition.
Mr. Anderson?
We have a legal definition. I think it makes sense to use the legal definition.
I believe that this is the legal definitions out of the statute. There's also a jury instruction with this definition. That's what I used. I didn't feel comfortable taking parts out of it because I didn't know how the attorneys intended to argue. So the entire definition is in there. I think the attorneys can use whichever portions they choose to use, but it is a correct statement of the law. Next objection.
The paragraph in red regarding provocation, I previously filed document 318 in which we had submitted a modified version of jury instruction 815. I sent that again last night via email to everybody at the court's request. I believe that is a more accurate rendition of the law. It's our position as is outlined in document 318 that the state needs to specify what was the unlawful conduct, which was of the type to provoke others to attack, and that there's a need in this paragraph for the court to tell the jury that it is the law that they have to prove the unlawful conduct, which is the basis for the provocation beyond a reasonable doubt. I appreciate they have to disprove self-defense, but since provocation is the the state's attempt to put a hurdle in front of whether we get self-defense, I think it needs to be made clear in that paragraph that it's the state's burden to prove the provocation occurred beyond a reasonable doubt. And again, I'm happy to go on in more detail, but I think the document number 318 with the case law that's cited in footnotes is a better argument than what I'm verbally making right now.
Mr. Anderson?
It's a pattern jury instruction. I looked at the motion filed by defense. The authority they used were two Washington state cases from the 1980s that there's been, I didn't see that it's been adopted in any other state since the 1980s. I saw a couple of California cases that cited to them that were overturned. There's no such authority in Wisconsin to modify the pattern jury instruction. It's drafted by the jury instruction committee to conform with Wisconsin law. So the closest thing I could find, I included in my response, which is directly negated a Minnesota court case that was cited. So I don't see the reason or the authority to modify it.
Just so we're clear, the jury instructions aren't law. The jury instructions are a committee's recommendations as to what the court can instruct the jury as to what the law is. But I appreciate we're asking for a modification, but in response to the state, it seems like the state is saying, I need to have some authority to say why we shouldn't use 815 in the manner that it's here. And, hey, I provided authority. I agree that it's not Wisconsin because there's no issue on point in Wisconsin. But I think we all agree, at least we did yesterday in chambers, that the burden is on the state to prove provocation beyond a reasonable doubt. So if we all agree that that's the law, and the purpose of the jury instructions is to tell the jury the law, then why would we want to include that in this paragraph to make it clear? I can tell you, Judge, and I understand my understanding is not the basis, but you know, there are lots of lawyers involved in this case, and I think we all agree that this 29 pages of jury instructions is probably some of the most complicated reading we've ever done in our legal careers. So anything we can do to simplify it, I think, is worthwhile for a group of eventually 12 people who do not have law degrees.
So the tension here is that Wisconsin, like most states, has a standardized set of jury instructions. These are typically put together by jury instruction committees, often under the mandate of whatever the highest state Supreme Court is. And what the jury instructions are supposed to do is take the legalese of statutory language, the case law of how the appellate courts want those statutes applied to real people in real cases, combine those, translate them into plain English, and that's the jury instruction. And in the old days, the parties would actually draft jury instructions for each trial. So they would look at jury instructions they've used in the past, and they would reformat them, and they'd present them to the judge. And like here, the judge would decide, all right, I have some from the state, I have some from the defense, and the judge would decide what form he wanted the final jury instructions to be in. But because they were basically created new for each trial, you ended up with similar trials having quite different jury instructions. So you'd get different legal outcomes, and it was considered unjust. So today, most states have standardized jury instructions. And those are the ones the court's supposed to use unless it has really good reason not to use it or to make a modification. And probably the easiest way for a trial court to be overturned on appeal is to mess around with the jury instructions, to modify the jury instructions, because that's not an issue of fact where the jury has discretion. That's an issue of law that the appellate courts will review. So judges are very averse to modifying the jury instructions because of this heightened risk of being reversed. And that's an L for a judge to be reversed on appeal. On the other hand, as Nelson is saying here, defense counsel Nelson, jury instructions are not themselves the law. They're supposed to be a representation of the law. The authoritative law is the statutes and the case law, the court decisions. To the extent a jury instruction is actually inconsistent with the actual law, it's the jury instruction that's wrong. And it needs to be modified to correctly reflect the law. Here, Nelson is saying, we all agree that the state has the burden. If we're going to claim that the defendant provoked the altercation through some unlawful conduct, we all agree the state has to prove that unlawful conduct beyond a reasonable doubt, just like they have to prove the underlying criminal charge beyond a reasonable doubt. If we agree that's the burden on the state, if they're going to claim provocation to prove the act of provocation beyond a reasonable doubt, that should be in the jury instruction, and it's not in the standard instruction. So that's where we're at.
So under the self-defense statute, Mr. Miu loses the privilege of self-defense if he provokes an attack by unlawful conduct. So I'm hearing two arguments. One is that the phrase unlawful conduct must be identified and defined. The other is that the instruction should include some reference to the burden of proof beyond a reasonable doubt. In terms of the modifications requested by the defense, no Wisconsin case law supports the request. The reference to unlawful conduct is part of the self-defense statute, section 939.48. The phrase is not an element of a crime that may require more specificity. Second, the phrase is not limited to a single act. It is broad enough to include multiple acts, whether they be criminal acts or tortious acts, but acts nonetheless that would cause a reasonable person to physically react. In this case, there is credible evidence that Mr. Miu engaged in unlawful conduct during his encounter with the tubers. In this case, there is credible evidence that Mr. Miu engaged in unlawful conduct during his encounter with the tubers. There is credible evidence that his conduct was of a type likely to provoke an attack by others. The jury will need to evaluate that conduct and the conduct of others and determine how it affects the self-defense claim. So
this is terrible for the defense. The judge is turning these jury instructions into soup, making this extremely complicated and messy for 12 lay jurors who don't understand these legal doctrines. And the reason this is dangerous for the defense is because, a 17-year-old was killed and 4 other people murdered. And if you're looking for some kind of, extra legal excuse to hold this defendant liable, well, then the more ambiguous and harder to understand the jury instructions are, the more likely you'll have somebody on the jury saying, well, we got to hold him accountable for something. Whereas if you have clearly defined jury instructions, the smarter people on the jury can say, well, listen, these are the steps. This is what the jury instructions tell us to do. It's very clear. 1 person died. 4 other people were stabbed.
while I understand some of the issues that other states have wrestled with, in Wisconsin, we do not have any authority to support the specificity that is being requested by the defense. As far as the burden of proof, I also declined to modify the language. In my judgment, the pattern instruction is adequate and it correctly states the law. I don't want to make modifications that could potentially be confusing or misleading. I think by adding additional language about the burden of proof with regard to provocation could do just that. It is true that the state has the burden of disproving self-defense beyond a reasonable doubt. The state has the burden of proving every fact necessary for a finding of guilt beyond a reasonable doubt. I relied on the pattern instructions. Those instructions repeatedly instruct the jury on these basic points. Adding more language about the burden of proof to the provocation paragraph could confuse the jury because it would imply an obligation to prove provocation. The state is not required to prove provocation. the state is required to disprove self-defense. The state may achieve that in a number of ways. Provocation is one of them. If the state elects to disprove self-defense by way of provocation, then the state will need to prove it beyond a reasonable doubt, and the pattern instructions adequately instruct the jury about that burden. So those are the reasons why I'm denying any additional modifications. Were there
Bad
other
call.
objections to 1017?
Yes, Judge. The next paragraph, I don't believe that there's a factual basis for that, which would normally be a bracketed portion of 815, and that is the paragraph, a person who provokes an attack, whether by lawful or unlawful conduct with intent to use such an attack as an excuse, and then it goes on. That's the sentence, which I don't believe that there is a.
This is the what he's referring to now is provocation with intent. So there's provocation. You engage in some unlawful act that provokes the other person to use force against you, and then you have to defend yourself. It's possible. So what provocation does is it loses you that element of innocence. It's possible that you could provoke a fight, like you shove somebody, you provoke a fight, you've lost the element of innocence, you've lost self-defense, but then if you withdraw from the fight, you've regained the element of innocence if the fight were to reignite. Provoking with intent is different. Provoking with intent is not simply like you had a moment of bad judgment and you shove somebody when you shouldn't have. Provocation with intent is when you're provoking someone to use force against you with the intent of then using deadly force against them. So this is the, go ahead, take your swing, take your swing. You're not saying that because you want the other person to punch you in the face. You're saying that so if they do try to punch you in the face, you intend to kill them. And then be able to say, well, I killed them in self-defense against their punch. If you're provoking with intent, you're gaming the law of self-defense. You're trying to fabricate something to be self-defense when it's just not, to fake self-defense. And the law doesn't like that. So when there's provocation with intent, and the state should have to prove the intent beyond a reasonable doubt. If there's provocation with intent, the difference between that and normal provocation, you can regain innocence by withdrawing from the fight. Provocation with intent, you cannot. You're stuck with that fight.
A factual basis to support its inclusion in 1017.
Mr. Anderson?
Before he even ran up on the boys, he touched his knife in his pocket. He kept touching his knife in his pocket while people were telling him to leave. He took out his knife and still nothing happened. And then witnesses say he punched Maddie. After they responded, he started stabbing people. So I think it's not a huge stretch to argue that he punched Maddie to provoke the response that would give him an argument for self-defense.
Is that really the state's theory?
I think there's an argument.
Sure. Is that the state's theory?
I don't think it's what I'm going to argue to the jury, but I would mention if they believe that.
So he set it all up so he could stab people.
Again,
everything.
The optional paragraph that we're talking about is an accurate statement of the law. A judge's decision to give an instruction is discretionary, but it has to be based on the facts of the case. So are there facts to believe that Mr. Miu was looking to stab people but just needed the right excuse? And he punched Madison Cohen so he'd have that excuse? That's what you're saying?
Yes. It's an argument we could make.
It's an argument we could make. They seem so confident.
Help me better understand the facts then. That leads you to that argument. Also, is it an argument that you're going to make? Because if you're not going to make it, I'm not.
He just said he was going to make it.
It's not relevant.
I was planning on briefly mentioning it, and then moving on to other theories or other theories of the case. But I think I've gave my argument, Judge.
I mean, we're asking that it not be included. These are complicated instructions. I don't think they've met their burden to prove that a reasonable jury could think that. Your Honor, I know is very judicial in letting juries decide things that are jury matters, but it sounds like Your Honor has, even in that interpretation, skepticism as to how any reasonable jury could think that. And they're
No, not necessarily that. It seems to run in the face contrary to the theory that I've heard. But, you know, it's the state's case, and if you want to give them a menu of options, it's your choice. I'll include it. Next.
Next, Judge, and this is
terrible.
I know this is not efficient, but this, as applies to this case, the effective law of self-defense, I think those next 5 bullet points, the wording of it, while implies that the burden of proof is with Mr. Miu. And he doesn't have to prove that his belief was reasonable.
So you're talking about pages 3 and 4.
Correct.
Bullet points.
Correct. Those 5 bullet points under as as applies to this case, the effective law of self-defense is, again, it's a summary. I don't think it's necessary. I appreciate that it's part of the standard, but I think it flips the burden within those 5 bullet points because it implies that it's they have to, the jury has to find his belief was reasonable, which isn't what they have to find. The jury has to find that the state has proven his belief was unreasonable. That's different.
I understand the objection. I'm going to include it. It's part of the pattern instruction. While I have discretion to deviate from the pattern instruction, I see no reason for doing so here. What the bullet points do, in my opinion, is put all of this law into context of how it fits together with the lesser includeds and a finding of not guilty. It puts it in 5 bullet points. And I think it encapsulizes a lot of different concepts and gives the jury a understandable roadmap for the thought process that they can utilize in reaching their verdict. In no way does it suggest that Mr. Miu has the burden of proving any of these elements. It just describes the way it all fits together. In fact, on page 4, the paragraph immediately after the bullet point refers to the state's burden of proving all facts necessary to constitute the crime is beyond a reasonable doubt. Later in the instruction, the court provides much greater detail on the elements of proof and what needs to be considered. Again, there's more reference to the burden of proof being on the state. So I think that the law is accurate and it does not mislead the jury. Anything else?
Yes. The next paragraph, the use of the word established, I think it should be, so the paragraph reading instead, I think it should read, instead you will be asked to determine whether the state has cross out established and put proven beyond a reasonable doubt, and then go back to the standard language.
You lost me. Which page?
Page 4, the paragraph underneath the 4 bullet points, the second sentence beginning with the word instead. The 4th line down, second word in is established. I think that word should be crossed out and we should use the word proven, and then we should include beyond a reasonable doubt. We use proof all the other times, and now here in this section we use established. I just think it's more accurate to say proven, and obviously it is their burden to prove it, the necessary facts beyond a reasonable doubt. So
that's exactly what was said in the sentence right before it.
Which is why that's why it doesn't make sense to me. If we use the word prove in the first sentence, why are we using the word establish in the second sentence and the word establish in the third sentence? Even if you don't include beyond a reasonable doubt, which I understand Your Honor says the first sentence covers that. Just change the word established to proven. At least then we're consistent with that language.
I'm going to leave it as is. I don't want to wordsmith too much. It's not misleading. I think it's accurate. The first sentence clearly states the state's burden to prove all facts necessary to constitute a crime beyond a reasonable doubt. And then I think for probably flow and just general understanding, it uses the word established. Yeah, I think it is implicit that it's established beyond a reasonable doubt. There's really no other way to read those following sentences. What's next?
Page 6, the last paragraph. I appreciate that the standard language says you must not find him guilty. I think the simpler language is you must find him not guilty.
How can that possibly be correct?
Because the verdicts are guilty and not guilty. And so
But it
if it
completely
says,
ignores the lesser included.
no, it says, if you are not so in my reading, it would say, if you are not so satisfied, you must find him not guilty of first degree intentional, and you must consider the next one.
But they're not returning a not guilty verdict.
I appreciate that they're not putting out a verdict, but I think that that's the finding.
I'm going to leave it as is. There's a lesser included, there's a sequence. They start with first degree. If they don't agree there, they go to second degree, and so on and so forth. And at the end is when they would reach the not guilty if they are not persuaded on guilt for any of the charged or lesser included offenses. Putting in, you must find him not guilty, I think would be misleading and contrary to law. Anything else in that instruction?
No, Judge. Oh, well, I mean, I'm sorry. Next is page 8 on the paragraph determining whether beliefs were reasonable. The last sentence of that paragraph, instead of his acts, I think it should say the alleged crimes, because we're not assessing his beliefs about anything other than his beliefs at the time that he committed these alleged crimes. So if you include from the standpoint of the time of his acts, it's much broader, and we're not trying to establish the reasonableness of his beliefs in the first 1 minute and 49 seconds of that video. There's nothing about the reasonableness of his beliefs then. It's only about the reasonableness of his beliefs when he committed these crimes. So I'm just asking that his acts be crossed out and replaced by the alleged crimes or the charged crimes.
I'm going to leave it as is. I don't want to wordsmith. It's an accurate statement of the law. This is a pattern instruction by the jury instruction committee, which is a committee of, I think, at least 10 judges. These instructions have been vetted and reviewed and studied, and in my judgment.
Yeah, so this is a terrible decision too. So the concern of the defense is that he's charged with stabbing 5 people, the defendant, and they're saying, listen, what needed to be reasonable was his perceptions when he used the force, right? The reasonableness of decision-making when he used the force, when he stabbed people. It shouldn't be the reasonableness of he decided to go look for his friend's phone when his friend said, I don't care about the phone, I have insurance. That shouldn't be relevant to the use of force. But if you leave it broadly, his acts, well, the state's going to argue exactly that. The state has argued that already. He didn't have to go look for the phone. He didn't have to go over by those kids. He could have stepped out of the way. He's not required to do any of that. There's nothing unlawful about any of that. But the state's going to say, well, a reasonable person would not have looked for the phone, would just have let it go. And therefore, he's guilty of murder.
10 minds are better than one. And I just don't feel comfortable wordsmithing and changing words without fully appreciating and understanding the effect that those changes may have to the broader meaning of the instruction.
And again, I understand. I just want to make sure my point is clear for the record. I disagree. I don't think it's an accurate statement of the law, but I heard your honor and we'll move on.
Okay. Anything else?
Same complaint on page 8 about the wording of not find Mr. Miu guilty as opposed to find Mr. Miu not guilty. But I, again, understand your honor's previous ruling would be consistent to overrule my objection.
Next.
Yep, I'm working through this, Judge. I'm going as fast as I can. Page 10 under jury's decision, again, the same.
If you're wondering why the pattern instructions are so bad, maybe I'll have Steve Gosney on sometime. Steve Gosney, attorney Steve Gosney, public defender down in Florida. Florida jury instructions are a pet peeve of his because apparently the committees they put together for the jury instructions in Florida are completely dominated by prosecutors. They don't want to hear anything from defense counsel. So you end up with jury instructions heavily biased in favor of the state.
Issue comes up that Your Honor previously mentioned. That's all on 1017, Judge. I believe I previously mentioned State v. Austin, and well, I would prefer the elements of the crime on page 9 include self-defense. I appreciate that, consistent with Austin. Element number 2 includes the language required by Austin, and element number 3 includes the language required by Austin. So I'll just leave it at that.
That was my assessment as well when I read Austin and considered your comments from yesterday. It looks like those pieces of law were already incorporated into the pattern instruction, just may not be in the position that you preferred.
1072 on page. Sorry.
Any objections, Mr. Anderson, on the
No.
state?
No.
1072.
First paragraph, second sentence, the word attempted is left out.
All right, thank you. Anything else in that paragraph?
No, Judge.
All right.
I don't know that the defense lawyer is acting defeated. Everyone's tired, folks. I mean, I've been live streaming since for 8 hours and 12 minutes. Probably about the same for these lawyers. They've been arguing in court. It's highly stressful. It consumes a lot of mental resources. And now at the very end of the day, when everybody just wants to go home, they're arguing through perhaps the most important parts of this trial, the instructions that will go to the jury. So everyone's exhausted.
I imagine you have similar objections to.
And it's not like this is the first day of trial either, right? So they've been doing this for 7 days in a row now.
1072 that you had in 1017.
Yes, Judge. The bullet points on page 12, and in particular, which again, I'm not trying to make the same arguments. I appreciate Your Honor's previous ruling. But nevertheless, I make those arguments. At the bottom of page 12 in red, where it talks about first degree recklessly endangering safety, I believe you would need to add at the end of that sentence and is at the end of the bullet point at the top of page 13 to be consistent with Austin, which we previously stated, you should add the words at the end of that, and did not act lawfully in self-defense.
So what I did when, because 1017 provided a nice pattern instruction for first degree intentional homicide with the 3 lesser includeds and self-defense. There wasn't a similar pattern instruction for attempted first degree homicide with the lesser includeds and self-defense. So what I did is I tried to mirror the modifications in red to what exists in 1017. Basically follow the same flow, the same thought process. And that's where I came up with the language in red. The Austin language is included where I define the crime in more detail. The bullet points on pages 12 and 13 are simply the instructions effort to put everything into context in a way that is simple and understandable for the jury. This isn't the instruction itself about the elements of the offense. or the things that the state has to prove beyond a reasonable doubt. This is just an explanation, like the introductory language that precedes it, to help the jury better understand how these lesser included offenses all fit together.
If I may, my concern is, well, I hear your honor. The argument that I'm making now, I would go back on 1072, page 4, in request. And again, I understand your honor that the same 7 words, and did not act lawfully in self-defense, be added on page 4 in the summary of first-degree reckless homicide and second-degree reckless homicide. Otherwise, when we talk about both in 1017 as and in 1072, when we talk about the intentional crimes, self-defense is included in that summary. When you talk about the reckless, it isn't, which if somebody goes and does a quick glance without doing a deep dive, it may, I'm worried the jury would think they just look at that and then they don't have to think about self-defense. So to add those 7 words, I don't think is contrary to the law, and I don't think it's confusing. I think it's just correct.
I disagree, because Austin didn't say you need to look at utter disregard for human life and self-defense separately. What Austin said is that someone does not act in utter disregard for human life when they're acting in self-defense. Now, that may be a small, subtle nuance, but I think it's an important one. And the concept of self-defense is subsumed in the term utter disregard for human life. And that's the way that Austin presented it, and that's how the instruction reads when you get to the detailing of the elements of the offense.
So this is, I don't know how technical I should get. We've been doing this for 8.25 hours. They're not doing a very good job of talking these legal concepts through right now. So, but perhaps I can help explain it. I've had to consult on cases like this. So when we're talking about an intentional killing and you're trying to justify that intentional killing, you're saying, yeah, I shot that guy, I killed him, but I did it in lawful self-defense. What you're claiming in self-defense is you're claiming you have the required elements of self-defense, and the state can defeat your claim of self-defense. To do that, they have to disprove any one of these 5 elements beyond a reasonable doubt. If they do that, your claim of self-defense goes away. So you're conceding all the elements of the underlying charge. I intentionally killed that person. You're conceding that. You're not denying that. You're not denying the elements of the underlying charge. You're saying, despite all that being true, I still should have no criminal liability because of the justification of self-defense. And then the state can try to disprove your justification by disproving one of the required elements of self-defense beyond a reasonable doubt. But when you're talking about a recklessness charge, it's not an intentional killing, and you raise the legal defense of self-defense, it's a little different. It's not a affirmative defense. It's not a defense of confession and avoidance. You're not confessing to intentional murder, but avoiding legal liability through justification. You're doing something else when it's a charge based on recklessness, and you're raising self-defense. When you do that, you're engaged in an element negating defense. It's not confession and avoidance. You're saying, no, I didn't recklessly kill anybody because I didn't reckless. My conduct was not reckless. So you're denying one of the required elements for reckless homicide. And how do you explain that your conduct was not reckless? You say, well, it was lawful self-defense. Lawful self-defense, by definition, one of the requirements is reasonableness. To believe it was self-defense, the jury has to believe it was reasonable. If it was reasonable, it wasn't reckless. So it's a subtle distinction. The state still has to convince the jury it was not self-defense, but it's a more ambiguous form of argument than when it's a defense of confession and avoidance. Now, these people here in this courtroom are not using the phrase element negating. Actually, it's called an element negating traverse defense, to get super technical. But that's the subtle distinction. You're not saying I did it, I meet all the I concede all the elements of the underlying charge of murder, intentional murder, but it's still justified. You're saying, no, I deny the element of reckless homicide because my conduct wasn't reckless. So yes, I would, if it were me, I'm with the defense on this modification, but the judge just does not like changing the pattern jury instructions.
Right. What else do you have?
On the paragraph on page 13, the same arguments I made before about the difference between the use of the word establish as opposed to proven. Just again, note the similar objection.
Noted.
At the last sentence, which I also, on page 13, it's the same last sentence as is on page 4 in 1017. And so I want to incorporate this argument for both. Instead of using the words, you will be instructed to find Mr. Miu not guilty, I think this is the instructions. So I think you should just say, you must find Mr. Miu not guilty. I don't know.
I'm sorry, you lost me. Where are you? On page
The
13?
last, on page 13, the paragraph beginning, because the law provides. Are you with me?
No.
At the top of page 13, under the red bullet point.
Yes.
The last sentence of that paragraph, the words will be instructed. I think those words should be crossed out and say must. It implies you will be instructed to find Mr. Miu not guilty. The literal meaning is I'm not telling you that now, but I'm going to tell it to you later. And I get it.
Is it meaningful?
It is to me.
Oh.
I think the word should be, you must find Mr. Miu not guilty, because you're instructing them now in this moment. You're not telling them about what you're going to do at a future moment, which is what it implies in this sentence.
What difference does it make? That's what I don't understand.
If it doesn't make a difference, then why wouldn't we agree? Why?
No, that's not the way it works.
Well,
you tell me why it's different and I'll consider making a change.
because this implies I'm not telling you that right now, right? I'm going to tell you that later, but we don't actually tell them that later.
We do.
When do you say, if the state does not satisfy those facts as established by the evidence, you will be instructed? When do you give that instruction?
This is the worst day of the defense for this trial right here. This is all bad news for the defense.
I'm looking at page 20. For one, if you are not so satisfied, referring back to the previous paragraph, you must find him not guilty. And I believe it's also in 140.
Okay. I stand by my argument. I appreciate your Honor's comments, but
anything else in this instruction?
Same on page 16, determining whether beliefs were reasonable, the same arguments that I had made previously when discussing 1017.
Okay. Objections noted.
I just need to, I got about this far, Judge, so if I know it's not fun to watch anybody read, but that's as far as I got in my in-depth reading before.
Mr. Anderson, do you have any concerns or objections to 1072?
No, Judge. I'll also say too, I'd changed my mind on the asking for a special change or instruction on defense of others. I think I can make the argument with the provocation instruction.
Thank you. You weren't going to get it anyway.
Good.
All right,
Finally.
let's, I don't want to just gloss over the rest of 1072, but we'll put it aside for the moment. Let's continue on because I think the others are probably pretty easy. There was a request yesterday to use 1220A with the self-defense battery. Any objection?
No. And this, I trust this is 1220A, and so.
It should be.
Okay. Yes, then thank you. We
I
agree?
think the red language is the new stuff.
Sure.
That's the difference. Continuing on, 990. I think there was a request last night to include the more robust definition of great bodily harm, which I included. It's in the red text. It's the same definition that you saw earlier. It's repetitive, but one came at the beginning, this one comes at the end. So the rest are kind of sandwiched in between. No objection, I'll continue on. 140, burden of proof.
If the defense is smart on closing, Nelson, Teraphacy, I don't know if you watch this. I know you're busy. If the defense is smart on closing, they will urge the jury when they go into deliberations to start with self-defense. Do self-defense first, wherever it may be in the 29 pages of jury instructions. Start with self-defense first. Because what I would be concerned about is if they spend hours, days going through the 25 pages of all these criminal charges and lesser included, they may convince themselves there's something there. But if you start with self-defense, if you decide it was self-defense, all the criminal charges go away. Self-defense is a legal defense to every one of these criminal charges and the lesser included. And I would tell them, ladies and gentlemen of the jury, I would suggest you start with self-defense, because if you start with self-defense and you conclude it was self-defense, you could all go home in a couple hours. And wouldn't that be nice?
There was a request last night for a modification.
What happened? You went back to the beginning?
Perhaps different with lesser included, but it's, our position that since he's presumed innocent, that the verdict of not guilty is the first choice.
Mr. Anderson?
I don't have anything to add, Judge. I know that this is the standard way, and I don't see a reason to change it.
Yeah, I understand the sentiment of wanting to have the not guilty read first.
Did I screw something up?
This can be made, but this instruction is an accurate statement of the law and will give the attorneys a platform for making those arguments. Continuing on, 157 remarks of counsel.
Oh my gosh.
Pattern instruction for first degree intentional homicide with the 3 lesser included and self-defense. There wasn't a similar pattern instruction today to use 1220A with the self-defense battery.
Okay.
Any objection?
No.
And this, I trust this is 1220A. Yes, then
the difference.
Okay. I think I'm back where I need to be.
Continuing on 990. I think there was a request last night to include the more robust definition of great bodily harm, which I included. It's in the red text. It's the same definition that you saw earlier. It's repetitive, but one came at the beginning, this one comes at the end. So the rest are kind of sandwiched in between. No objection, I'll continue on. 140, burden of proof. There was a request last night for a modification to the last sentence, which I made. It's in the red text.
Only a couple minutes left, folks. And then I'll do Q&A, and then we can all go home.
We filed our previous objections in writing, and I appreciate the modification. Thank you.
Okay. Continuing on, 103, evidence defined. 170, circumstantial evidence. Last night, again, I'm referring to last night. I'm talking about the Chambers conversation off the record. Mr. Anderson requested 172, so I included that. Any comment?
We object.
Mr. Anderson, why do you think it's justified?
The evidence is that he walked away, changed his appearance, tubed past the chaos. Yeah, discarded the knife, tried to walk past an officer, and essentially was only apprehended because he was recognized from the photo. So I think it's appropriate.
I think the facts support the instruction. Obviously, there's competing inferences. Different arguments can be made, but this Instruction is an accurate statement of the law and will give the attorneys a platform for making those those arguments. Continuing on, 157 remarks of counsel.
I wonder if that's consciousness of guilt
155
instruction.
exhibits, 148 objections, 147 improper questions, 190 weight of evidence, 195 jurors' knowledge, 300 credibility, 160 closing arguments,
Too fast for me to keep
460
up.
closing instruction, 485 verdicts submitted with lesser included counts, and concluding with 515. Mr. Nelson, does your client request any special instructions regarding his decision to testify?
No, Judge.
I think it's 315. You
Correct,
don't want,
Judge.
do not want it.
We do not want it.
Okay.
Hold on.
So this would be an instruction that the defendant has no obligation to testify, has a right not to testify. I think I would want it. I don't think I would pass it up because I think it makes your client look better for having testified.
Just so we're clear, Judge, I'm not asking for the instruction. Obviously, the law is the law is the law, and either side, well, they won't quote from 315. They can make arguments consistent with 315.
Absolutely. Did either of you look at the wording of the verdict?
I did, and I appreciate it's perhaps different with lesser includeds, but it's, our position that since he's presumed innocent, that the verdict of not guilty is the first choice.
Mr. Anderson?
I don't have anything to add, Judge. I know that this is the standard way, and I don't see a reason to change it.
Yeah. I understand the sentiment of wanting to have the not guilty read first. I don't think it makes a difference one way or the other. I don't think it is suggestive which verdict is read first. The reason why I organize it the way I do is because I think it's consistent with the order of proof. The state going first, defense going second. So that's the way I order it. Is there anything that you think I missed that should be included?
No, Judge. I just want a chance to finish reading 1072.
Yes, and what I propose we do is adjourn for the night since it's 5 o'clock. I'd like to have the attorneys come back tomorrow at 8. We can pick up the instruction conference. That'll give the attorneys a little bit of extra time to look at 1072. Since that instruction did have a substantial amount of additions, given the late addition of the lesser included offenses. So we can pick up where we left off, but at least this gives me a clear indication that most of what's been prepared is going to be delivered. Is there anything else that you think we need to address?
Nothing I can think of. I guess we did have I think these might not have gotten numbers.
So I had a diagram with Mr. Miu. I'll pick up Mark. You did? Thank you. What was it marked as?
This is
90?
Yes, exhibit 90.
90? So that was the illustration you gave Mr. Miu? Right. So 90 will be received just for purposes of illustration. It's not evidence, of course.
62A is the photos of the boys.
Do you have any objection?
No.
That's 62A, correct?
Yes.
All right, 62A is received. Anything else from the state?
We have the blown up photo of Isaac, but we also admitted the normal size, so unless the fence, I don't think we have to mark it and admit it.
No position, Judge.
It's up to you.
I guess we might as well.
All right.
91.
All right, so 91 is the portrait of Isaac blown up. The 8x11 was already received into evidence. Anything else, Mr. Anderson?
No.
Mr. Nelson, anything else?
No, Judge.
All right, so we'll pick up on the instructions and then be prepared to 8:30 with arguments shortly followed. Good night, everyone. We are adjourned.
Good night, everyone. All right, so I'll do Q&A. Before I do, last time I'll mention this today. Upcoming, the Law of Self-Defense Advanced Class, Saturday, April 20th, 2024. This is our full-day class taught live by me, streamed to you on your computer using Zoom, teaching you everything you need to know in one day about how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, your property. Nicolae Miu would have been well served to have taken this class before he went tubing July 30th, 2022. He would not be in this courtroom today. We only teach this class twice a year, folks. So if you miss this April 20th date, it'll be October at best before we do it again. If you can't make the Saturday, April 20th date, sign up anyway, because we'll make the playback version of this live class available as a recording for at least 2 weeks afterwards. So you can watch it at your leisure over those 2 weeks, but that only goes out to registered students. We teach you self-defense. We teach you defense of others, including family, neighbors, colleagues, strangers, like an active shooter type of situation. We teach about defense of property, including highly defensible property like your home, and least defensible property. Believe it or not, your pet is least defensible property. We teach you consciousness of guilt evidence. We teach you about self-defense immunity. We teach you about interacting with the police in the aftermath of a use of force event. That's almost an hour all by itself. And we teach you much, much more. If you go to that website, lawofselfdefense.com/advanced, you'll see we have a list of over 100 very specific self-defense law questions we answer in plain English. And there's plenty of opportunity for Q&A. Don't miss this class, folks. You don't know when you'll be attacked. You don't know when you'll need this. Nicolae Miu did not know he was going to have a very bad day the morning of July 30th, 2022. You need to have onboarded this knowledge before you find yourself compelled to use force in defense of yourself, your family, or your property. And this is the last week for early registration, 50% off at lawofselfdefense.com/advanced. All right. Let's see where we are. Yeah, the cough is really hanging on. I know, it's terrible. It is, believe it or not, it's like 3 or 4% better every day. But that doesn't mean it's gone. I was really sick a couple weeks ago. Let's see. I honestly can't remember the details of the jury instructions in Rittenhouse, so I'm not sure if they were as bad as this. Yeah, so it appears that they actually just added these lesser included charges at the very end of the trial, which is, allowed. I mean, the defense is on notice that they exist. It's not a surprise in that sense, but it's kind of offensive when they're not kind of on the table until the end. So the defense isn't crafting their arguments or their questioning of witnesses with those lesser includeds in mind. So you can kind of get ambushed by the state afterwards, late in the day. Let's see. Yeah, the risk of the lesser included is that they're used as a compromise verdict. Yep, the defense, Will Parker points out the defense on closing should pound home that the state has to prove every element of any crime beyond a reasonable doubt. The trouble is you do all that, and then you send the jury into deliberations with 29 pages of jury instructions. You get to talk to them in closing for maybe an hour. Then they might spend days in deliberations. These are very favorable jury instructions for the state. So these make up for a lot of the state's poor performance. This is why the risk of going to prison is never zero, folks. You could do everything legally right. I've seen no compelling evidence that Nicolae Miu did anything wrong in defending himself with that pocket knife. But he could still get convicted. That's just the noise in the system. And these kinds of jury instructions don't help. Law self-defense member Lawful to Shoot says, what's the scariest thing a concealed carrier has to face? Answer, a liberal social justice judge and jury. Paul says, I have friends who say some stupid crap about what they will do in such a case, like shoot them and drag them inside before you call the police. I've given up trying to educate themselves. Yeah, it's a problem. Yeah, I made a joke earlier that, my content is for people of above average intelligence, and it's just the way it is. I mean, it's not a good fit for, low IQ people. Doesn't work. They tend to function on too much of an emotional level. Let's see. If the jury is looking for a reason to convict, the judge gave it to him with these very complicated, amorphous jury instructions. But the truth is, mostly the jury will have decided already, as individuals at least, how they feel about the case. And that might be where the 20-year-old juror screws up the process. All right, so that looks like, the last 100 messages from the Law Self-Defense membership is all I can get to. So I just screened through all of those. Let me take a look at Super Chats and see if we have anything new there. Let's see. I don't think we do. No, I think I've answered everything. All right. Well, boys and girls, 8 hours and 42 minutes today. I love my work. I love my work. Thank you all for being here all this time. I really appreciate it. I'll be back in the morning. I'm going to plan to start at 10 a.m. Eastern time. If the court's streaming something interesting, like more arguments over jury instructions or something, then I'll live stream with the court. To the extent the court's not doing anything interesting, I'll continue with my coverage of testimony from Friday, and then yesterday, and then whatever pre-Miu testimony happened today. So that's how we'll spend together the day tomorrow. I would expect that we'll hear closing argument tomorrow. If not in the morning, then in the afternoon, and it'll go to the jury for deliberations before the end of the day, would be my expectation. All right. So with that out of the way, I remind all of you that if you carry a gun so you're hard to kill, carry a knife so you're hard to kill, carry pepper spray so you're hard to kill, study jujitsu so you're hard to kill. I do all those things, all of them. So I'm hard to kill, so my family is hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict as well. Until tomorrow morning, Wednesday, April 10th, 10 a.m. Eastern time. I'll see you all then. Until then, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.